House will come to order. Calendar for the day. First bill on the calendar for the day is Senate File 1737. The clerk will report the bill.
Senate File 1737 on the calendar for today, an act relating to state government.
Representative Rosenthal.
Thank you, Mr. Speaker. And Senate File 1737 provides employer insurance contributions to former corrections officers who were rendered totally and permanently disabled as a result of assault. This came about. Dave Campo, one of the most decorated officers in the Stillwater prison system, was brutally attacked in 2010. He has a traumatic brain injury and I believe a large metal plate in the back of his head. He was dedicated to his career. He loved his job, and he's not been able to work since. And since that time, he's spent over $80,000 in medical expenses. His premium has jumped from $163 to $1,600 a month. And under this bill, the Department of Corrections are going to pay the state share until age 65. So I ask for your support, and I will take questions.
There are no amendments at the desk. The clerk will give the bill its third reading.
Third reading, Senate File 1737.
Third reading. Any discussion to the bill? Representative Cornish.
Mr. Speaker and members, Representative Rosenthal, thanks for bringing this bill forward. Just a short comment. It's a good bill, and please vote green.
Representative Detmer.
Yeah, thank you, Mr. Speaker. And again, thank you, Representative Rosenthal. You know, we've talked about this issue, and actually, he is actually one of my constituents. And I think he's up, and there he goes. And he actually helped coach wrestling for a few years in Forest Lake. So again, this is a good thing that should be done, and thank you for bringing it.
Any further discussion? Seeing none, the clerk will take the roll on the bill. The clerk will close the roll.
Mr. Speaker, I am on there. I'm on there.
Who? I'm sorry. There being 129 ayes and 0 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is House File 2318. The clerk will report the bill.
House File 2318 on the calendar for the day, the first engrossment, an act relating to school board elections.
The author of the bill, Representative Hansen.
Thank you, Mr. Speaker and members. House File 2318 is a bill relating only to the South St. Paul Special School District. South St. Paul is one of 2 special school districts. It's not an independent school district. And as a special school district, it elects its school board members by ward. What this bill does would allow for them to elect their school board members at large. And it relates only to the South St. Paul district. I'd ask for your support.
There's no amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File 2318.
Third reading. Any discussion to the bill? Seeing none, the clerk will take the roll on the bill. The clerk will close the roll. There being 127 ayes and 1 nay, the bill is passed and its title agreed to. The next bill on the calendar for the day is House File 2090. The clerk will report the bill.
House File 2090 on the calendar for today, the first engrossment, an act relating to civil action.
Representative Hortman.
Thank you, Mr. Speaker and members. This is a bill we've been working on for 5 years, and it's to establish that indemnity agreements in design professional service contracts are void under Minnesota's civil liability statutes. There used to be a clause that a lot of people would require in construction contracts requiring designers to get insurance to indemnify contractors for the contractor's errors. But there wasn't insurance available for that, and so it made no sense to have these provision in contracts. I would appreciate your support.
There's no amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File 2090.
Third reading. Representative Scott.
Thank you, Mr. Speaker, and thank you, Representative Hortman, for bringing this bill. It's a good bill, business-friendly, and I would encourage our caucus's support. Thank you.
Any further discussion? Seeing none, the clerk will take the roll on the bill. Clerk will close the roll. There being 130 ayes and 0 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is House File 2659. The clerk will report the bill.
House File 2659 on the calendar for today, an act relating to state government.
Representative Slocum, the author of the bill.
Thank you, Mr. Speaker. House File 2659 involves threading. Threading is defined as the removal of hair from eyebrows, upper lips, or other body parts through the use of cotton thread to pull the hair from follicles. It provides for a licensing exemption for persons that perform threading. It exempts from the salon license requirement for facilities at which only threading but no other licensed service is performed. And it provides for Board of Cosmetology rulemaking to exempt threading from cosmetology licensing. And the Board of Cosmetologists are backing this bill also.
There are no amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File 2659.
Third reading. Any further discussion on the bill? Seeing none, the clerk will take the roll on the bill. The clerk will close the roll. There being 129 ayes and 0 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is House File 2937. The clerk will report the bill.
House File 2937, an act relating to state government.
Representative Freiberg.
Thank you, Mr. Speaker. This is the Technical Corrections Bill for the Minnesota Historical Society. The Minnesota Historical Society was created by the territorial legislature in 1849. It's a 501c3 organization, but many of its governing documents are set out in state statute. This bill clears up many of those state statutes to reflect what is current practice in the Minnesota Historical Society. It updates statutes to include correct references to federal law, and it updates the statute to correct one address. I urge your support for this bill.
There's no amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File 2937.
Third reading. Any further discussion to this bill? Seeing none, the clerk will take the roll on the bill. The clerk will close the roll. There being 130 ayes and 0 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is House File 2658. The clerk will report the bill.
House File 2658, the second engrossment, an act relating to workers' compensation.
Representative Mahoney.
Thank you, Mr. Speaker and members. This is the annual Work Comp Advisory Council bill. It is chock full of contentious issues. And I would like to thank Representative Kiefer for her good work on this, because you see, there's only 2 legislators out of the 4 that show up. I'll let you guess which 2 elected officials show up. Anyhow, it's got a couple of changes to it. One of the things in there is last year in the work comp bill, we extended coverage to PTSD for public employees, for all employees. This change in the bill allows for if you had an accident and there were 10 responders that claimed PTSD under the old rules, they would all be classified as one. Under this change, they are individually put forth. That way, it goes to the reinsurers, which is the 360 plus insurers in the state of Minnesota, thus not breaking the bank for any one insurer. The rest of the work comp bill has some language changes. That is pretty much changes from policyholder to from premium to policyholder and a variety of things like that. It changes one of the words on page 4, line 10, from preceding calendar year to current calendar year, and then puts into effect some changes that require the commissioner to actually make the decisions on refunding money in the current year rather than based on preceding year. And then also in this bill is the unsession part of the Department of Labor and Industry. Such things as there is in law, it requires that the office be in the city of St. Paul. We are removing that language. It has not extensive, but it covers in 175.14, it talks about travel expenses. That's covered elsewhere in our state statutes. Violation of local ordinances. State law requires the Department of Labor to keep track of local ordinances and notify them when they are violating the law. They don't do that. There's a variety of other things in here, but medical fee review, small claims court, they actually have the ALGs and the work comp board legal system over there. They don't use small claims court any longer. And then, well, that's about it. There's really not much of controversy in the bill. I would just appreciate your support.
There are no amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File 2658.
Third reading. Any discussion to the bill? Seeing none, the clerk will take the roll on the bill. The clerk will close the roll. There being 130 ayes and 0 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is House File 2948. The clerk will report the bill.
House File 2948, the first engrossment, an act relating to economic development.
Representative Mahoney.
Thank you, Mr. Speaker, and I have an amendment to this bill.
There is an amendment at the desk. The clerk will report the amendment.
Mahoney moving to amend House File 2948, the first engrossment as follows. The amendment is coded 202.
Representative Mahoney.
Thank you, Mr. Speaker. And in this bill, this is the Department of Employment and Economic Development's unsessioned bill. They took the amendment, the RA 14, on page 4, deletes lines 16 and 17, and what that is in the bill, deed was getting rid of the transit improvement areas. There was some consternation from local governments that they wanted that left in. We are leaving that in. That is what that amendment does, Mr. Chair.
Discussion to the amendment. Seeing none, all in favor of the amendment say aye. All opposed, no. The motion prevails. There are no further amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File 2948 as amended.
Third reading. Representative Mahoney, to your bill.
Mr. Speaker, this bill, this bill is the unsession bill. It takes out some requirements from deed to have a bond when they are appealing a particular decision. At the courts have signaled that they don't want that bond any longer. Then it goes into repealing a variety of acts and groups. And I'll read these off. The Environmental Coordination Procedure Act, that is something from way back that is now done in a different part of the law. The e-commerce ready designation, something that we held over from the .com. Only one city in the 15 or 16 years that it's been in existence has asked for it. This is the one that I suspect everyone might have some consternation over, so I want everyone to listen to this, if you would, please. On page 3, line 26, we are deleting the Rural Policy and Economic and Development Center Fund. What this is a trust fund that was established when the RUI was made. In the year 2002, the legislature directed that all funds be taken out of that trust fund in the year 2005 because it's a direct appropriation to this organization, and the trust fund was no longer used or needed. So there has been no money in the trust fund since 2005. We do it by a line item appropriation now. We are not changing the way we have done it for the last 10 years. We are just getting rid of the trust fund language that is not being used any longer. It has, and anyhow, on the bill, starting at page 3, line 20, it has 16 different pieces that are coming out or being gotten rid of. And then after that, starting on page 4, line 23, is just the conforming language that would go along with it. And members, I'll stand for questions.
Representative Pepin.
Thank you, Mr. Speaker. Would Representative Mahoney yield to a question?
He will. Representative Pepin.
Thank you, Representative Mahoney. You mentioned that it repealed a number of things, and I'm wondering, does this bill save the state any money or does it repeal or sunset any active board, commission, agency, or otherwise?
Representative Mahoney.
Thank you, Mr. Speaker. And my hearing's getting a little bad, so I think what you asked me is there any cost savings in this particular bill? There was not a fiscal note with the bill, so I'm going to say no, there is not. Almost all of these have not. All of these boards or commissions have not been meeting for the last 10 years or better. So any savings that came from it is booked long ago.
Representative Pepin.
Thank you, Mr. Speaker. So just to be clear, Representative Mahoney, it doesn't repeal anything that's active, so we're not saving the state money or repealing anything active, but we are removing some lines from the statute books. Is that accurate?
He will yield. Representative Mahoney.
That is my understanding, yes.
Any further discussion? Seeing none, the clerk will take the roll on the bill. The clerk will close the roll. There being 130 ayes and 0 nays, the bill is passed as amended and its title agreed to. The next bill on the calendar for the day is House File 3072. The clerk will report the bill.
House File 3072 on the calendar for today, an act relating to transportation.
Representative Simonson.
Thank you, Mr. Speaker and members. House File 3072 is DPS Transportation Unsession Bill. This bill amends Chapters 168, 169, 171, 299, and 609. There are a number of items that are contained in this bill, some of which I will draw your attention to. In Chapter 168, and this is probably the most interesting portion of the bill, Chapter 168, we eliminate the list of vehicles that are eligible for classic car license plates and allows nationally published standards and guides to determine which cars are designated. This change simplifies the process while ensuring that the list of classic cars is updated in a timely manner. Chapters 169 would eliminate the requirement for report on activities and expenditures from the Minnesota Child Passenger Restraint and Education account. The information, of course, will still be available upon request, as DPS is still doing this function. Also in Chapter 169, eliminate the 1937 requirement to use a parking brake and turn your wheels when parked on a hill. Statute is no longer necessary with the modern automobile and technology. Chapter 169, eliminate the prohibition for driving with the vehicle in neutral. Chapter 169, eliminate the law to allow a peace officer to stop and submit the passenger automobile to an inspection if it has reasonable cause to believe tires are unsafe. Under current law, peace officers can, of course, stop vehicles for any reasonable, articulable suspicion of violations of 169, making this statute unnecessary. Also in 169, we eliminate the regulations related to the size and color of bug deflectors. Bug deflectors are no longer commonplace in automobiles. Chapter 169, eliminate authority for municipalities to establish vehicle inspection stations. This statute, originally from 1937, is no longer used, as evidenced by the 50-cent and $1 maximum fees allowed. Chapter 169, eliminate the ability for non-Minnesota residents who are issued a speeding citation to plead guilty and pay the fine with a credit card. Law enforcement agencies currently do not have the technologies to administer this system. Chapter 168, satisfaction of security interests. This would eliminate the subdivision 168A.201A. It is irrelevant because it is covered in another portion of the statute. Chapter 299, eliminate authorization for the commissioner to purchase or lease land in Wisconsin to operate, construct, or maintain radio repeater stations, unnecessary with the advent of armor.
Next.
And Chapter 169, eliminate driver's license revocation when a driver is convicted of a criminal negligence in operating a vehicle when death occurs. Revocation is covered in other statutes. So that, Mr. Speaker, in summary, is the DPS Transportation Unsession Bill, and I would understand that there are amendments at the desk.
There are amendments at the desk. The clerk will report the First Amendment.
Hamilton moving to amend House File 3072 as follows. The amendment is coded A2.
Representative Hamilton.
Thank you, Mr. Speaker and members. And you heard some of the questions that I had on the House floor, and I have been working with Representative Mason and also with the Minnesota State Council on the disability. And I think there may be a picture that's going out there with some of the concerns. And right across the street, the handicap parking spots, right across the street, right over here on the north side of University, the signs themselves are off-centered. So in the event we line up like the language was written, we'd automatically be in violation. And the amendment that we have here would be for individuals who are authorized to park in those spots, because I fully understand what the disabled community is trying to get accomplished here. But if they are authorized to park in those spots and they didn't do it according to as written, they would then be subject to a fine that is outlined by local law enforcement or local ordinance, and not automatic a $200 parking ticket. But I've spoke with Representative Mason, and her and I are going to be working on this together along with the disabled community. So, Mr. Speaker, I'm going to withdraw this amendment. Thank you.
Representative Hamilton withdraws his amendment. There is another amendment at the desk. The clerk will report the amendment.
Lencheski moving to amend House File 3072 as follows. The amendment is coded A1.
Representative Lencheski.
Well, thank you, Mr. Speaker and members, and thank you for your work, Representative Simonson. Members, this simply removes a sales tax reference. It's being carried in the tax bill, in the unsession part of the tax bill that we just voted for when we passed the second tax bill off the floor. Thank you.
Any discussion to the amendment? Representative Simonson.
Thank you, Mr. Speaker, and Representative Lencheski, and I certainly support this amendment and encourage a yes vote.
Any further discussion? All those in favor of the amendment say aye. Aye. All opposed, no. Motion prevails. There is another amendment at the desk. The clerk will report the amendment.
Erdahl moving to amend House File 3072 as follows. The amendment is coded 1050.
Representative Erdahl.
Thank you, Mr. Speaker and members. We have here a very common sense amendment that is so filled with common sense that you passed it last year by a vote of 79 to 45. In 2011, we allowed a change in how some speed limit violations are recorded. We included in that a study. Legislation before us requires, or current legislation, that the statute expires before the study in January 15th, 2015. My point today, the same point that I made and you verified just last year, was that we should make a decision based on the results and merits of the study and not terminate the statute before we know what the study is. Again, right now the statute would end August 1st, 2014. The study wouldn't be until January 15th, 2015. And so I urge you, please, to support this amendment as you did before. And I promise this time, because it was lost in the Senate, that I will work with Representative Earhart and everyone else that is on that committee to make sure that the Senate sees the wisdom of the House position.
Representative Simonson.
Thank you, Mr. Speaker and members, and I would encourage a no vote on this amendment. I understand. But the reason is just as simple. MnDOT needs some time to put this report together, and you heard, as you just heard, it's going to be coming out in January of 2015. So it makes perfect sense that this provision sunsets now, and we don't renew it. Obviously, we'll have the report that will be put together over the rest of this calendar year. It'll come back to the legislature in January, at which time Chair Earhart certainly could hold a hearing, and we could determine what to do with the results of that report. But at this particular point in time, members, I would just encourage a no vote.
Representative Erdahl.
Thank you, Mr. Speaker. And members, just once again, we should make our decisions based on what we know the report to be and not make a decision based on the report before it comes out. And with that, I request a roll call.
Roll call being requested. Seeing 15 hands, there will be a roll call. Any further discussion on the Representative Earhart?
Thank you, Mr. Speaker. Representative Erdahl, I had talked to MnDOT a number of times on this issue, and it is their considered opinion that you had an agreement with them that you would not deal with this issue again, and you continue to do it. Now, you may have a different opinion, but I am inclined to believe that if you once reach an agreement that you would wait till after the report came out, that's what we should run on.
I'm sorry, I missed that. Representative Erdahl. Will yield. Representative Erdahl.
Thank you, Mr. Speaker. And I just say this: if there was some miscommunication, I'm sorry for that. But hey, what we have here is our word. That's really all we've got in this legislature. And I certainly am not going back on any promise or commitment that I made. The agreement was, as far as I was concerned, is that there would be a study and we would make our opinion based upon the study. And it wasn't the language in my bill, and when the agreement was reached, that it be done the other way around. It just doesn't make sense. And I'm certainly, I will do no legislation that contradicts the study once it's reported. But it hasn't been, and it just seems very reasonable to know what we're doing before we do it.
Any further discussion? Seeing none, the clerk will take the roll on the amendment. The clerk will close the roll. There being 68 ayes and 62 nays, the motion prevails. The amendment does go on. There's another amendment at the desk. The clerk will report the amendment.
Keel, moving to amend House File 3072 as follows. The amendment is coded A3.
Representative Keel.
Thank you, Mr. Speaker and members. This is a bill that I carried 3 years ago, and in the light of the unsession, there was some wording put into this bill by the Senate that is basically redundant, and would work well to just remove it. Thank you.
Representative Simonson.
Thank you, Mr. Speaker and members, and I would just encourage a yes vote. I think this amendment is common sense and it fits in the concept of the bill.
Any further discussion on the amendment? Seeing none, all in favor of the amendment say aye. Aye. All opposed, no. Motion prevails. The amendment is adopted. There is another amendment at the desk. The clerk will report the amendment.
Norna is moving to amend House File 3072 as follows. The amendment is coded 1048.
Representative Nornis.
Thank you, Mr. Speaker. Members, in 2009, this body passed legislation that allowed local units of government to issue a permit to drive mini trucks on county and township roads. This legislation before you right now is simply an amendment to remove, there is a sunset provision in that expires July 31st of this summer, and this legislation basically removes that sunset provision. That's all there is to it. Thank you very much, Mr. Speaker.
Representative Simonson.
Thank you, Mr. Speaker. And I can certainly appreciate the passion of Representative Nornis on this particular issue, but I don't think that this really conforms with the unsession spirit of this bill, so I would ask members for a no vote.
Any further discussion? Representative Erickson.
Thank you, Mr. Speaker and members. Well, this is undoing a sunset, so I think this is appropriate for unsession.
Representative Nornis.
Members, I also agree that if this doesn't undo something, I don't know what does. And it's very unnecessary to have the sunset. Why it was put in there in the first place, I can't even tell you. Representative Bria Saylor was the chief author back at that time, and for some reason felt we had to have a sunset. The legislation is working well. The local units of government have issued these permits. There's been no problems with it. But if the sunset stays in, all those provisions to operate the mini trucks will go away, and I don't think we want that to happen.
Representative Anderson.
Thanks, Mr. Speaker. I rise to support the Nornis amendment. It's been working, as the representative said, out in outstate Minnesota. It'd be confusing to repeal it and try to get it back again in a year or so. So I would also support the Nornis amendment.
Representative Earhart.
Thank you, Mr. Speaker, and Representative Norris and all. We spent some time in committee a year ago with this problem, and all of those people who are concerned with motor vehicle safety testified against this, including DVS, the State Patrol, and several motor vehicle safety standard experts. Now, if we really prolong this, I've got a page and a half here from the American Association of Motor Vehicle Administrators, the Federal Motor Vehicle Safety Standards, and they, frankly, the mini trucks do not satisfy any safety requirements. And they say that the best practice on mini trucks, which recommends that jurisdictions not register or otherwise allow mini trucks to be used on public roadway highways regardless of age, and so forth. Not issue for mini trucks a certificate of title that authorized on-highway operation. Deny on-highway titles and registrations for mini trucks. Restrict on-highway mini truck uses. Restrict mini trucks from operations on public highways consistent with how the jurisdiction, and so forth. You know what they're talking about here is they want to conserve lives. And these trucks are not built. If you want to drive around the back street of your farmyard, maybe that's one thing. But what we're doing here is going beyond that. And so the reason we continue to uphold the principles of not spreading the mini truck authorization around is because of the very safety for the operators of these vehicles. And that's it. We spent several hours in committee going over this with the people testifying as to the we have another we didn't do it this year because this wasn't brought forward again, but we spent enough time on it last year doing just that. Thank you.
Representative Nornis.
Again, thank you, Mr. Speaker, and I apologize to the members. This was not intended to be a debate on whether mini trucks are good or bad. That was last year. All this is doing is telling our rural members they'll own a mini truck. They may be a farmer, they may be a small business, they may be a resort. They have these trucks, they're driving them legally on the roads, and all we're doing is taking a sunset away from the current legislation. That's nothing at all related to what we just heard from Representative Earhart. So, members, it's a very simple thing. It's undoing the sunset, and I don't know what could be simpler than that. So I urge you to vote for it, and then we'll move on.
Representative Simonson.
Thank you, Mr. Speaker and members. And again, I would just encourage a no vote. Thank you.
Representative Earhart.
Mr. Speaker and Representative Nornis, undoing the sunset puts more people at risk. That's the whole point of things. And we don't want to undo the sunset.
Representative Nornis.
Mr. Speaker, I just need to add one more thing. There's never been an accident, so the risk is very low, and I would like to have a roll call, Mr. Speaker.
A roll call has been requested. Seeing 15 hands, there will be a roll call. Any further discussion on the amendment? Representative Fabian.
Thank you, Mr. Speaker. Members, if you live in rural Minnesota, this is a good bill to vote for, okay? We're not asking for anything great here. There's no public safety involved in this. Representative Earhart, I appreciate your concerns about wanting to save people and protect us from ourselves, but this is about people making choices to drive these mini trucks in their small businesses, maybe around some of the back roads in rural Minnesota and those sorts of things. And this is just a common sense bill. Let's vote green. Thank you.
Where are they? Seeing no further discussion, the clerk will take the roll on the amendment. The clerk will close the roll. There being 67 ayes and 64 nays, the motion prevails. The amendment is adopted. There are no more amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File 3072 as amended.
Third reading. Further discussion. Representative Cornish.
Mr. Speaker and members, Representative Earhart, if I could just get your attention for a second. Rarely will I disagree with my law enforcement folks, except when it's about guns or some other subject. But they really don't know what they're talking about. When they got so retentive on this issue that I don't know if they ever drove the mini truck. I've driven them. A guy sells them in my area, and they're allowed in other states on state highways. So a lot of that hype is just from some retentive bureaucrats that don't want to see a vehicle get on the road without their say. So if you could bring it back from conference, I'd appreciate it.
Any further discussion on the bill? Seeing none, the clerk will take the roll on the bill. clerk close the roll? Rosenthal votes aye. There being 130 ayes and 1 nay, the bill is passed as amended and its title agreed to. The next bill on the calendar for the day is House File 3014. The clerk will report the bill.
House File 3014 on the calendar for today, the second engrossment, an act relating to labor.
Representative Carlson.
Mr. Speaker, members, this bill would create a public employment relations board under the Bureau of Mediation Services. The board would handle unfair labor practice charges administratively, replacing the current practice of handling unfair labor practice charges through the courts. This bill would only apply to public employment, not the private sector. The private sector employees are covered under the National Labor Relations Act. One member of the board would be appointed by the governor to represent employers. One member would be appointed by the governor to represent employees. The third member of the board would be selected by the other two. Alternates would be appointed in case a board member had a conflict of interest. The bill would create the board as of July 1, 2014 and allow it to develop rules for its operation. $125,000 would be appropriated to the Bureau of Mediation Services for fiscal year 15 to cover the cost of setting up the board and promulgating rules. The board would begin processing charges as of July 1, 2015. In the meantime, it would develop a budget request to the 2015 legislature. The Commissioner of Mediation Services would assist in setting up the board and creating rules. Why is the bill important? The Public Employee Labor Relations Act lists unfair practices by employers and unions. Unfair labor practice charges can be brought by the union against employers, employers against unions, or individuals against employers and or unions. The current practice of bringing charges through the district court is very expensive, cumbersome, and time-consuming. Individuals or organizations bringing charges need to hire attorneys, and the typical cost is $50,000 to $75,000, and it can take years to get a decision. In fact, I think we had one case that went as high as $200,000, if I recall, from committee hearings. This makes the current process of going through the courts prohibitively expensive for individuals, small unions, and even small public employers. When the unfair labor practice is handled administratively, the party bringing the charges does not have to have an attorney and typically spends around $5,000 to bring a charge. Parties bringing charges do not need an attorney. In states that use the administrative system like this, most charges are either settled or dismissed for a lack of merit at the investigation stage, before they even go to a hearing. The timelines are also much quicker than the district court process. This proposal is supported by virtually all of the public employee unions and the AFL-CIO, and with an amendment I will have a little bit later, which is basically really a housekeeping amendment, MMB, which handles employee bargaining from the management perspective, also supports the bill. This bill was heard in 5 committees in the House and 2 in the Senate, and no one testified in opposition to the bill. As I mentioned, MMB had some suggested changes to the bill, which will be offered as an amendment, as I was saying. The National Labor Relations Board, which handles unfair labor practices, charges in the private sector uses an administrative process. There are 35 states that have unfair labor practice statutes. Of these, 32 use the administrative process. Only 3 states, Minnesota, Arkansas, and Texas, process charges through the courts. So, Mr. Speaker and members, that's a quick summary of the bill. And just to reiterate, it's not, I don't think I could call it an official part of the on-session initiatives, but it fits into that category. It would save the state money, it would save the union's money, and it would also be a faster, quicker, more efficient process, which is one of the goals of this legislative session. So, Mr. Speaker, with that, I would take questions or amendments.
There are amendments at the desk. The clerk will report the first amendment.
Drazkowski moving to amend House File 3014, the second engrossment as follows. The amendment is coded A5.
Representative Drazkowski.
Thank you, Mr. Speaker. Mr. Speaker, members, we did hear this bill in committee, this union payback bill. Mr. Speaker, members, page 8.1 and 8.2 of the bill refer to something called concerted activity. And, excuse me, Mr. Speaker, we have A5 and not A9. I think I heard it improperly. I'm up to speed now, Mr. Speaker. Actually, this doesn't refer to concerted activity. That's a different amendment for later members. But this amendment removes the power of this newly developed and designed board to issue and have its own powers to issue subpoenas and apply administrative oaths. Members, we have a board here that we are, it's very, very interesting that we're developing a board to carry some of the same powers that our judiciary has, from which we are taking the responsibilities to handle these activities. As a matter of fact, we heard in committee that very rarely was there a case that gets to the court level. And I think the $50,000 example, maybe the author can talk more about it later, but I think it was the only example that could be recalled even by the union representatives who were advocating and helping design and develop this bill. But members, this amendment removes the power of this new super energized union supporting government agency to issue its own subpoenas and have those powers that come with those in order to do all of the duties that the author and then the union supporters of this bill design within the bill. So I'd like to remove those powers and reserve those powers as they should be for the judiciary. With that, Mr. Speaker, I'd ask for a roll call on the amendment.
Roll call being requested. Seeing 15 hands, there will be a roll call. Representative Pepin.
Thank you, Mr. Speaker. Would Representative Carlson yield to a question?
He will yield. Representative Pepin.
Thank you. Representative Carlson, I'm curious about the subpoena power. I think you explained the board as being 2 members, one appointed as a representative of labor, one as from the employer, and then those 2 folks would appoint a 3rd member, and that would be the board. Now, this board would have subpoena power. Is that commonly done?
Representative Carlson.
Mr. Speaker, yes. In fact, in Minnesota, some examples that have subpoena power would be the Campaign Finance and Disclosure Board, the Environmental Quality Board, the Nursing Board, and boards that regulate other professions, the Gambling Control Board, the Chief Administrative Law Judge for the OAH hearings, the Commissioner of Employment and Economic Development for unemployment insurance hearings. There may be others, but those are the ones that I'm aware of.
Representative Pepin.
Thank you, Mr. Speaker. Would Representative Carlson continue to yield?
He will. Representative Pepin.
Thank you. And Representative Carlson, of those different boards that you just mentioned, how many of them use the ALJ process and how many of them do not?
Representative Carlson.
Mr. Speaker, I don't know the answer to that question. Maybe others do.
Representative Pepin.
Thank you, Mr. Speaker. And Representative Carlson, I have done some research, and I believe that virtually all of the agencies that have subpoena power go through the Office of Administrative Hearing, an actual system that's parallel to the courts, and they have specific rules and rules of evidence governing them. So this, I believe, is highly unusual. So essentially you have this three-member board, three-panel board of folks who don't have any legal experience, who don't have to work through the actual legal process, go through any of the rules of evidence or rules of procedure that are followed by either the district courts or the Office of Administrative Hearings. And Representative Carlson, you had mentioned in your opening that that you thought that this was kind of an unsession bill. Well, I don't think this is an unsession bill at all. This is a very controversial bill. I don't think that this is something that we should be doing. I think it certainly is a union bill. It's probably a union model bill. I'm not sure. You could comment on that, I guess. But when you talked about costs, I'm wondering if you'd given any thought to the constitutionality of it, Representative Carlson. There's two things. I don't know if you had a chance to look at a brief that House Research did on administrative subpoenas. It said there are at least two constitutional grounds for challenging an administrative subpoena. First, while probable cause is not necessary for the issuance of an administrative subpoena, the Fourth Amendment's protection against unreasonable searches and seizures apply to requests for information, and that was Marshall versus Barlow, a Supreme Court case. And then the second one was the Fifth Amendment privilege against self-incrimination can be raised to challenge an administrative subpoena, and that was Couch versus the United States, both Supreme Court cases. So I'm actually pretty concerned about this, Representative Carlson, because there are a lot of things in this bill, and we'll talk about it more as we go along, but I don't think that this is going to save money at all. I think that this is going to result in a lot of court challenges because you're not particularly following any. In fact, you have a section in here where you remove any requirement to follow the rules of evidence, and there doesn't seem to be any procedure that you're following here. So it's just sort of this three-panel board that doesn't have any legal experience is making the rules up as they go along when we have a very well-established procedure under the ALJ. And so, Representative Carlson, I'd ask you to support this amendment because I think the likelihood for a court case is certainly there's a potential because of the way you've set this up. And so I'd ask you to consider this, and members, I'd certainly ask you to support the Drazkowski amendment.
Representative Simonson.
Thank you, Mr. Speakers and members, and I would just stand to speak against the Drazkowski amendment, the A5. If we take away what he's proposing that we take away, we will essentially be rendering this newly created board ineffective. We will take away their ability to investigate unfair labor practices, which is what we are putting them in place to do. Without subpoena power, they will be unable to compel the testimony that they need to do to complete their investigation. Under PELRA, under current law in PELRA, statute grants to the BMS Commissioner subpoena power in unit determination hearings, and it grants to arbitrators subpoena power in interest arbitrations. This bill provides the same power to the board which this amendment would take away, and I would encourage and ask for a no vote.
Representative Nelson.
Thank you, Mr. Speaker. And members, I think there's a bit of misunderstanding here about what the PELRA bill and the PELRA board would do. It's not just unions that are filing unfair labor practices. Oftentimes, it's also our government entities, the employers, that are filing unfair labor practices against the employees or the union members. And so this board would save our local governments, our counties, our cities, our townships, our state government, could save all those groups money because they don't have to go to court, which is what has to happen right now. If there's an unfair labor practice charge they file, under the current statute, the way it's set up now, the only way they can get at these is to go to court. this board being set up with the subpoena power that they need is there so that both sides can save money. It's not just a union bill, it's also help our state government, and it's a cost savings money. And Representative Pepin, you keep asking on all the unsession bills, does this save money? This bill will save the state of Minnesota money.
Representative Carlson. Go ahead, Representative Carlson.
Members, I would just encourage a no vote, and as far as the subpoena power, other states provide this subpoena power to the boards. That's fairly routine in the 33 states that do provide it. So I would encourage a no vote. It goes to the very core, this amendment does, of the bill. And I would like to answer the question about this is a union bill. The unions do support it. There was opportunity in 5 committee hearings in the House, 2 in the Senate, for any employer to come forward and testify against it. None did. MMB had a few suggestions that we will be taking up, as I mentioned earlier, and with those suggestions and their housekeeping suggestions, they have indicated that they support the bill. So both labor and management, as far as I know, supports the bill. So to tilt it exclusively one way, I think misrepresents the goal of the bill.
Representative Pepin.
Thank you, Mr. Speaker. And Representative Carlson, would you yield to another question?
He will yield. Representative Pepin.
Representative Carlson, do the cities also support this bill? Cities, counties?
Representative Carlson.
Mr. Speaker, members, as I pointed out, this bill went through 5 committees, one that you sit on at least, and no one came forward to testify against it. So I can't say that they support it or oppose it. They had an opportunity. It was well posted. 5 committee hearings is a lot of time spent on the bill, and there was no opposition. The only ones that raised questions, quite frankly, were a few people on your side of the aisle. Beyond that, no one in the public raised any concerns about it other than MMB, and their concerns are going to be met.
Representative Pepin.
Thank you, Mr. Speaker, and Representative Carlson. Well, Representative Carlson, I don't know that House File 3014 was heard in government operations. I believe there was a similar bill, but there was House File 3015, 3014, and 2926 that all basically did the same thing and took different avenues. One went to labor, one went to government operations, one went to judiciary. I'm not sure what the plan was in that, so I think that could have been somewhat confusing to the public. And I would encourage all members to contact their local governments because this is going to cost a lot of money. Representative Nelson, you said that this was going to save money. Representative Nelson, there's a appropriation for I think $125,000 in here. And I will point out we already have a process in place that's been working since the 70s that we could use, the Office of Administrative Hearings. The process is already set in place with the rules set up, with the procedures set up. It's working. The process is working. And so, Representative Nelson, I think we need to really be concerned about the constitutionality of this and potential legal challenges. I think there will be a cost, and certainly there is a cost in the appropriation. Thank you, members. I encourage a yes vote.
Representative Drzeskowski.
Thank you, Mr. Speaker. Well, you know, the discussion about the current the subpoena powers that the Bureau of Mediation Services has, they already have this power. The Commissioner does. The question is, why haven't they been using it if indeed they need that within the agency in order to do this? But instead, members, we have another bill coming forward to build an even bigger bureaucracy within a bureaucracy and give them subpoena powers as well. Members, this is a common sense amendment to take away these unnecessary powers. The outcomes of any of these decisions anyway would still end up going to district court to be enforced, as I understand. So this is an unnecessary component of the bill. I'd urge your green vote on the amendment.
Representative Albright.
Thank you, Mr. Speaker. And would Representative Carlson stand for a question?
He will. Representative Albright.
Thank you, Mr. Speaker. Representative Carlson, on page 13, I note that there is a new section that would include the addition or the clarification of labor practices involving charitable hospitals. And I'm just curious as to why such specificity is required. Is there an occurrence or an emphasis that you want to place on this, and why the new language? Thank you, Mr. Speaker.
We are on the A5 amendment, members. Representative Carlson.
Speaker, members, as the bill was going through the process, we found that there was a category of public employees that are generally referred to in the small hospitals as charitable hospitals. They're all public hospitals, but they came under a separate section of law. PELRA was passed back in the early 1970s, mid-1970s, and those public hospitals were under federal law. So in the 1990s, when federal law was changed, then we passed a state statute. So these small public hospitals that employ public personnel were included under a separate statute. They came forward as the bill was moving through the process and asked to be included in the process that we're setting up here, and that's why you see that language and that reference.
Any further discussion on the A5 amendment? Seeing none, the clerk will take the roll on the amendment. The clerk will close the roll. There being 61 ayes and 70 nays, the motion does not prevail. The amendment is not adopted. There is another amendment at the desk. The clerk will report the amendment.
Erickson S. moving to amend House File 3014. The second engrossment as follows. The amendment is coded A6.
Representative Erickson.
Thank you, Mr. Speaker and members. This amendment would delete the rulemaking section of House File 3014. It is my belief that rulemaking is something for agencies and for boards that provide licensing. This is not a board that would provide licensing. There isn't even a direct relationship in this board to an agency. So, and I'd like a roll call on this, please, Mr. Speaker.
Roll call being requested. Seeing 15 hands, there will be a roll call. Representative Erickson.
Thank you, Mr. Speaker and members. And when I think back to the history that has occurred in this body in regard to rulemaking and how carried away it has gotten, today we have more than 20 volumes of rules. And members, that means that we're not writing legislation specifically enough. And so these boards that do license and agencies then write hundreds and thousands of rules to complete an obligation that we really have. So I would say, Representative Carlson, that if there's going to be rulemaking in this provision that you've provided, that it should be the responsibility of the legislature to provide for this, in light of the fact that I'm going to argue that this board should not have rulemaking authority. So, members, I'd ask for your support.
Representative Carlson.
Mr. Speaker, members, I would urge a no vote. It's very necessary that the board be able to adopt the rules necessary for governing the basic operations, such as the investigation process and the presentation of issues. The fine details of how the board functions need to be worked out in rules and not statute. I find it rather interesting. There were comments from the other side of the aisle on the last amendment that there was concern that there not be rules or process in place, and this is what or these rules is what keeps the process in place and makes the board functional.
Representative Erickson.
Thank you, Mr. Speaker and members. Well, I believe my colleagues on this side of the aisle were referring to actual rules, not to rulemaking, because both are specified in this provision. Members, I still ask for your support.
Seeing no further discussion, the clerk will take the roll on the amendment. Clerk will close the roll. There being 60 ayes and 70 nays, the motion does not prevail. The amendment is not adopted. There is another amendment at the desk. The clerk will report the amendment.
Leidiger moving to amend House File 3014, the second engrossment as follows. The amendment is coded A7.
Representative Leidiger.
Thank you, Mr. Speaker. Let me get to the... this particular amendment has to do with subdivision 7, page 8, 8.1, 8.2. Talks about concerted activity. And I've not heard this term before, and I'm trying to understand the term. And and I'm not sure where this has come from, but it talks about public employees have the right to engage in concerted activities for the purpose of collective bargaining or other mutual aid or protection. So, Representative Carlson, this, to me, I'd like to ask a question, if you'd please yield.
He will yield. Representative Leidiger.
Representative Carlson, to me, when I read this, it seems very all-encompassing, as though any activity that any employee does is some sort of a concerted activity. Can you explain? Is that the way? Am I defining this correctly?
Representative Carlson.
Mr. Speaker, members, a concerted activity would be activities that are generally used in the collective bargaining process. If you're referring to a slowdown and or a strike, that's already prohibited under certain conditions under PELRA. But if you're concerned about further defining that, which I don't think is really necessary, I accept your amendment.
Representative Leidiger.
Thank you. I appreciate that.
Any further discussion on the amendment? Seeing none, all in favor of the amendment say aye. All opposed, no. Motion prevails. There's another amendment at the desk. The clerk will report the amendment.
Leidiger moving to amend House File 3014, the second engrossment as follows. The amendment is coded A8.
Representative Leidiger.
Thank you, Mr. Speaker. Well, then, Representative Carlson, you'd accept this amendment as well, then?
Representative Carlson will yield.
Mr. Speaker, members, again, I'm not sure of the necessity because this goes back to 1935, the National Labor Relations Act. So if it gives you some comfort level on the bill, I'll accept the amendment.
Representative Leidiger.
Well, thank you. I have nothing else to say on this. I think we both agree on this.
Any further discussion? All those in favor of the amendment say aye. All opposed, no. Motion prevails. There is another amendment at the desk. The clerk will report the amendment.
Drazkowski moving to amend House File 3014, the second engrossment as follows. The amendment is coded A9.
Representative Drazkowski.
Thank you, Mr. Speaker. Members, this amendment also relates to the concerted activity. It was interesting. In committee, we asked what concerted activity was, and we got the same rather nondescript description. And I know at least in two committees, Representative Carlson, I had suggested that maybe you want to actually write a definition for what concerted activity is. And as we see in front of us, there is no definition of concerted activity, and it remains as elusive as it was in committee. And that may be by design. I don't know. But one thing that I think that these amendments are hoping to do is at least describe what concerted activity is not, because obviously it's some sort of union activity that we really give them carte blanche in the language there to do things that they public employees may want to do related to collective bargaining, really without any other guidelines in them. So members, what this particular amendment does is says that concerted activity does not apply to smoking breaks on the job in state government or any of the local governments that this would apply to. In other words, that this does not give the entitlement to the employee under the language that doesn't have a definition here in the bill to do smoking breaks under the head of that concerted activity. So I would ask members that you support the amendment.
Representative Carlson.
Mr. Speaker, some employees may refer to their break time as a smoking break, but a break is a break. In my employment history, and I'm a non-smoker, but I did during break time have a cup of coffee or maybe grabbed a sandwich or a cookie or something. A break is a break. I am not sure what you're trying to do with this, but we'll accept it as well.
Any discussion? All those in favor of the amendment say aye. All opposed, no. Motion prevails. There's another amendment at the desk. The clerk will report the amendment.
Drazkowski moving to amend House File 3014, the second engrossment as follows. The amendment is coded A10.
Representative Drazkowski.
Thank you, Mr. Speaker. Mr. Speaker, members, this is in the same vein of discussion, if you will. What it would provide is that employees engaged in concerted activity, which does relate to collective bargaining and union activity, cannot be engaged in bullying. Certainly we wouldn't want bullying activity around these union-type discussions. So this amendment, members, precludes employees from engaging in bullying activity that could be construed to be concerted activity under this bill. Mr. Speaker, I'd ask for a roll call.
Roll call has been requested. Seeing 15 hands, there will be a roll call. Representative Carlson.
Mr. Speaker, this whole series that you're coming up with here, well, I just never want to challenge somebody's motives, but the fact of the matter is, if you were to look at PELRA, it already identifies 15 unfair labor practices, including restraining or coercing the employee or coercing or restraining other employees in the exercise of their rights. I think it's already covered. Why don't you just withdraw the roll call and we'll just put it to a vote and I'll accept it.
Any further discussion? Representative Drazkowski.
Thank you, Mr. Speaker. Well, Representative Carlson, why didn't you then include a definition in the bill? We asked about that in committee, and there was this really kind of a elusive response that said, well, it's in the National Labor Relations Act somewhere. That's all we heard. And how are the people of Minnesota, the employees and employers throughout this state supposed to have guidance under this bill if we don't have a definition? So that's the reason for these amendments as we come forward. Thank you, Mr. Speaker.
Representative Carlson.
Mr. Speaker, I'm not sure if that was posing a question, but what I just described is in Minnesota Statutes 179A, Subdivision 13. It's already the law. So there wasn't any need to clarify it any further. I remember when you asked the question, but I thought we gave a clear answer. I'm giving a very clear answer here today. It's already in the law, but I'm accepting your amendment. If you want a roll call, that's fine, but I don't think you need one.
Any further discussion? Seeing none, the clerk will take the roll on the amendment. The clerk will close the roll. There being 105 ayes and 26 nays, the motion prevails. The amendment is adopted. There's another amendment at the desk. The clerk will report the amendment.
Drazkowski moving to amend House File 3014, the second engrossment, as follows. The amendment is coded A11.
Representative Drazkowski.
Thank you, Mr. Speaker and members. This is another another exception to what concerted activity means, and Representative Carlson, I did try to write down the reference that you gave us. I think you said 179A.13. Which refers to unfair labor practices. I don't, however, see anything related to concerted activity yet, unless I didn't hear you properly. But members, this amendment would provide that employees under this bill cannot engage in activity that includes strong-arming business to sign labor peace agreements as part of their understanding of what concerted activity means under the bill. So I'd ask for your adoption of the amendment. Thank you, Mr. Speaker.
Representative Carlson.
This deals with labor peace agreements. You used the reference to strong-arming businesses. This bill, just as a reminder, deals with public employees. When you say strong-arming businesses, I'm not sure exactly what you are concerned about there. There is no statutory definition for strong-arming. I think this is one that, if I accept it, I'm going to have to look into exactly what your motives here is, or what the situation is that you're trying to solve when you say strong-arming businesses. We're talking about the employer-employee relationships in this bill within the public sector. But I'll accept this one with the understanding that I'll have to take a look at exactly what you're trying to resolve with it.
Any further discussion? Representative Drazkowski.
Thank you, Mr. Speaker, and thank you, Representative Carlson. Representative Carlson, I think you're right. Now that I read the amendment, it isn't clear. And for that reason, I'm going to withdraw the amendment. But, Representative Carlson, I still don't see anywhere in statute, Mr. Speaker, Representative Carlson would yield.
He will yield. Representative Drazkowski.
Thank you, Mr. Speaker. Representative Carlson, can you tell the body again where in statute that the definition of what concerted activity is?
Representative Carlson.
Yeah, Mr. Speaker, PELRA defines basically what you can and cannot do. And when I've read the statute, I don't think they use the term and in a definitional manner, but they do list in PELRA what you may or may not do in terms of the various activities when you're dealing with a collective bargaining situation.
Representative Driscollowski.
Thank you, Mr. Speaker. Thank you, Representative Carlson. And I do have that section of law in front of me, 179A.13, unfair labor practices. But again, nowhere in here is concerted activity defined. Not only is it not defined in current law, it is not defined in the bill. And that is, of course, a weakness of the bill that was brought up in committee. And obviously, it's in the interest of the author and probably the groups bringing this bill forward, which I understood to be, I thought I heard the author say 9 different unions. But that's the reason that I'm bringing these amendments forward, and I suspect maybe it might have something to do with some of the other amendments coming too. But, Mr. Speaker, thank you, and at this point I'd like to withdraw the amendment.
Representative Driscollowski withdraws the amendment. There is another amendment at the desk. The clerk will report the amendment.
Quam moving to amend House File 3014, a second engrossment as follows. The amendment is coded A12.
Representative Quam.
Thank you, Mr. Speaker. And, well, we might remember a previous activity and debate about the unionization effort with child care providers. During that, I had many constituents come forward with issues of where they were harassed by people. Sometimes they would identify themselves and sometimes not. So therefore, this amendment is to try and make sure that we keep track and don't have that happen or don't consider it concerted activity. And it's to make sure that concerted activity does not include intimidating and harassing child care workers or personnel care attendants to join unions. I do not believe that's an appropriate activity should be allowed in our state.
Representative Carlson.
Mr. Speaker, members, this is part of a whole series here that really it's current law that already covers these kinds of activities. If you look at 197A, point 13, subdivision 3, it's already covered. I don't know what your motivation is other than you're trying to apparently try to make a point about the bill. I won't challenge the motivations of the other side of the aisle other than to say this whole series of amendments is already covered by current law and they really are not in any way, shape, or form needed. That's why I'm accepting them, because they're already covered by current law, and I'll accept yours as well.
Representative Quam.
Thank you, Mr. Speaker. And my motivation is the same motivation I stood on this floor and spoke out against the activities that went on during that process to get the cards signed. My motivation is I had constituents telling me they were told there's nothing they could do, nowhere they could go and take care of this behavior. The only recourse they had was to call the police and wait for the people to leave. They had no recourse after the fact for the poor behavior that they were seeing. So I would hope that everybody will vote positive on this amendment.
Representative Franzen.
Thank you, members. And I would just urge a vote with Representative Quam to vote aye on Amendment 12. I too have heard some concerning stories across the state of workers being harassed and targeted. And I just think that we could just perhaps put a little bit more trust back into this body. This is a very contentious bill that was passed last year, the child care unionization, and as we know, it's at the Supreme Court right now. But in the meantime, organizers are still going out and visiting our home child care workers while they're busy caring for the youngest of our young. And I think it would give reassurance to the taxpayers of Minnesota, along with the business owners, the small business owners who are predominantly women, that they would be left alone in order to run the business and take care of our youngest of our young children. So I'd urge a yes vote. Thank you.
Representative Driscollowski.
Thank you, Mr. Speaker. I ask for a roll call on the amendment.
Roll call being requested. Seeing 15 hands, there will be a roll call. Representative Carlson.
Mr. Speaker, again, I indicated it was one that I was accepting because I don't think it was needed, but there is something I want to point out. If this bill passes, people who believe they're being illegally harassed or intimidated could bring an unfair labor practice. Now, they would have to go into the court. It would be very expensive. I said earlier that on average it would run them $50,000 to $70,000, maybe more. On average, if this law passes, it would cost them about $5,000. And in my introduction, I did indicate that this bill is particularly helpful to small employers, and that's what you're talking about here with this amendment. Small employers and smaller unions could bring it forward at a whole lot less money than if they go into the courts, hire an attorney, and incur an expense of $50,000 to $70,000 on average. So I'm accepting the amendment. I don't know why you need a roll call, but I would appreciate it if you would withdraw it. It's unnecessary.
Representative Leidiger.
Thank you, Mr. Speaker. I thought I understood this bill, and now I'm very confused because I thought the bill was for public employees or public employers, and now we're talking about daycare employees, or employers, I should say. And so I don't see how this actually fits in this bill. Because daycare organizations are private concerns. They're not public concerns. Am I right, Representative Carlson? I'm a little confused on this.
Representative Carlson will yield.
I didn't bring up daycare. I said if this bill passes, people who believe they're being illegally harassed or intimidated, and I referred to small employers. Was your side of the aisle that brought up the daycare?
Any further discussion? Seeing none, Representative Drazkowski.
Thank you, Mr. Speaker. Well, Representative Carlson, I heard the discussion about, these child care workers and personal care attendants would be covered in the process that this new and powerful and expansive piece of government within the Bureau of Mediation Services is providing. But I don't know if you're hearing what we're saying. Lines 8.1 and 8.2 basically give cover to any employee, as I see it, in government service in the state of Minnesota to engage in anything that they consider to be concerted activity, without a definition in statute or the bill as to what that concerted activity is. And so that's the reason these amendments are coming forward. Mr. Speaker, I'd withdraw my roll call from this amendment.
Roll call has been withdrawn. Is there any further discussion to the amendment? Seeing none, all those in favor of the amendment say aye. Aye. All opposed, no. No. The motion prevails. The amendment is adopted. There's another amendment at the desk. The clerk will report the amendment.
Anderson S. moving to amend House File 3014. The second engrossment as follows. The amendment is coded A4.
Representative Anderson.
Thank you, Mr. Speaker. Members, what my amendment does is it establishes a legal fund, a defense fund for individuals who believe they have been wrongly classified as public employees. If you remember, just a year ago, we discussed on the House floor both child care providers and personal care attendants under the child care unionization bill. They were being classified as state employees, even though those individuals, in particular the child care providers, are small business owners, predominantly women small business owners across the state, and they have been fighting in court, for a couple of years now to prevent the classification of them as state employees. So it's very clear they're operating their own business out of their own home. They employ people, some of them do, and this is to make sure that we are not picking on the little guy and giving them no recourse, because they have now taken a lot of their personal money and their personal time in order to address this issue in the courts. And I think it's a tragedy that we are forcing them to sue against their own governor, against their own state, and I'm establishing just a legal fund for them to help them out, defray the costs, because they shouldn't have to fight against their own government on this. So, Mr. Speaker, I would ask for a roll call vote on this and ask for your support.
Roll call has been requested. Seeing 15 hands, there will be a roll call. Representative Moline.
Thank you, Mr. Speaker and members, and Representative Anderson. I would ask members to oppose the A4 amendment. The amendment not only completely guts the bill, but inserts some language regarding legislation that passed this body last year. And members are probably never going to agree on whether or not child care providers should have had the right to vote on whether or not to join a union. The legislature last year and the governor decided that they should have that right to vote, and we passed legislation which became law. And I understand well now, and I remember very clearly from last year, that the Republican minority was opposed to that legislation. But nonetheless, it did become law. And, you know, Representative Anderson, these child care providers decided to go to court and sue the state for legislation that they didn't like or they thought was unconstitutional or unfair, and they certainly have the right to do that as citizens. Checks and balances are a very important part of our democracy. A judicial review of legislative actions is a very important part of our democracy. And citizens, of course, have the right to bring a lawsuit if there's legislation that they think is unconstitutional. From my understanding right now, that lawsuit is on stay in the 8th District, pending a Supreme Court decision on another similar case. So it is a pending action in federal court. But what we have before us with your amendment, Representative Anderson, is to set up a compensation fund before the outcome of the lawsuit is even known, to pay attorney's fees to private citizens who brought a lawsuit. And I think, you know, that would be an unprecedented action. There are several other pending lawsuits against the state right now, having to do with the Viking Stadium, the Senate office building. Are we going to start setting up compensation funds for every time a private citizen or an interest group sues the state of Minnesota because they don't like what the legislature does? I think that would be a pretty dangerous path to go down. I don't think it's our job as a legislature right now to determine the validity of a court action. Now, of course, if the court is to rule in their favor, the court could decide to pay attorney's fees, or they could not. That would be up to the court, but I'm not sure that that's an appropriate decision for the legislature to be making today. And so, you know, although we're probably always going to disagree on the merits of the legislation that we passed last year and became law, I think that going this route and setting up a compensation fund before the case is even determined is a pretty dangerous path to go down. And so I would ask that members please vote against the A4 amendment today. Thank you.
Representative Anderson.
Thank you, Mr. Speaker. Members, already the state has spent $60,000 to reimburse these small business owners for the costs that they have had to incur to defend their constitutional rights. $60,000 that the state has already spent on this for people that are small business owners that did not want to be considered state employees because they own their own business. They don't work for the state. They work for themselves. And you know what? We as a state should not be the enemy to the citizens of our state. They should not have to go up and fight against their government. In 2011, the governor was told he had overreach when it came to this issue. And those poor small business owners had to spend their savings to defend themselves against their own governor. How is that right, folks? What kind of state are we establishing where we now have to force business owners to fight against their own government and spend their own money out of their own pocketbook? Can you imagine where that money could have been spent rather than in a courtroom? $60,000 that has already been paid out. We need to have a plan. We need a plan B because this is going to happen to us. And we need to make sure that there is money in place so that those folks have a recourse. Now, I understand that you think it's okay to unionize anybody and everybody. You would unionize everybody here for sure. But these folks are small business owners that never asked to be considered state employees. So I'd ask for a green vote, folks.
Representative Winkler.
Thank you, Mr. Speaker. Representative Carlson and Moline, you've done a fine job addressing a number of amendments that make zero sense, but this is the one that makes the least sense of all, Representative Anderson, because this is a civil rights claim. A civil rights claim is a claim that results in attorney's fees if the plaintiff is successful. So all they have to do is be correct, and their attorney fees, that $60,000 you're talking about, will get paid out. That's the nature of a civil rights claim. That's the nature of this case. This amendment is completely unnecessary, just like the other amendments that deal with this matter. I thought you might want to know that and perhaps withdraw the amendment accordingly.
Representative Scott.
Well, thank you, Mr. Speaker, and I like the Anderson amendment, and I encourage everyone's green vote on that. These small business owners, predominantly women, as we see that the union bosses and the Democrats are attacking women-owned businesses, they're just seeking justice. They're totally seeking justice, and this is a good unsession bill. Why don't we just repeal that whole bill? Let's just repeal that whole bill. The reason that there are a lot of lawsuits, Representative Moline, regarding the stadium and the blob now is because the Democrats are running amok with the taxpayers' money. How many millions of dollars have we spent watching the Democrats spend money that we don't have for things that we don't need? I'm going to start just addressing all of my comments in the future just to the people of Minnesota, because addressing them to the Democrats on the other side really has no effect. So people of Minnesota, the reason you're seeing amendments like this one is because the people of Minnesota are fed up. They've had enough, and they're not going to take it anymore.
Further discussion. Representative Anderson.
Thank you, Mr. Chair. Representative Winkler, you're wrong. What this sets up is a fund to make sure that the dollars are there for those folks so they can get compensated when they have to sue their own state because they don't want to be considered state employees. That's what this amendment does.
Seeing no further discussion. Did you want Representative Franzen? Sorry. Okay. Seeing no further discussion, the clerk will take the roll on the amendment. Clerk will close the roll. (61 ayes and 70 nays). The motion does not prevail. The amendment is not adopted. There is another amendment at the desk. The clerk will report the amendment.
Benson M. moving to amend House File 3014 to second engrossment as follows. The amendment is coded A13.
Representative Benson.
Well, thank you, Mr. Speaker and members. We've already heard on before with Representative Erickson's amendment that would limit, in fact, not allow for rulemaking to be done. But this amendment, in effect, what it does is that any rules that the board would make I'm sorry, A13. All right, I got 14 too. So A13. I was more prepared to talk about that one anyway. So thank you, Mr. Speaker and members. So if you look at Section 5 of the bill, it talks about Public Employee Relations Board power, authority, and duties. Talks about how they're selected, who are selected, who can make the selection, and so on. But it doesn't speak at all to their qualifications to be on this board at all. And inasmuch as I don't like this bill, I argued against it in Labor and Workforce and Regulated Industries as just another government overreach. We already have a really great system that works. I usually don't try to make bad bills, terrible bills, any better. But members, this is a glaring hole in that there is nothing in this bill that would set any kind of a qualification for the members of this board. So what Amendment A13 does is inserts on page 5, line 31, that all members of the board and all alternate members must have completed necessary training to be a qualified neutral and must be on the roster of qualified neutrals maintained by the judicial branch. This falls in line with Rule 114.13 in that anybody that's doing mediation, whether they be a facilitative, I think there are at least 3 or 4 of us that have taken that training, I'm included, would go through some training to do that. But this is specifically the adjudicative, evaluative, neutral arbitrator training. And this would at least require that they go through the training, they be certified, they pay their dues, and they're on the list. This is just a minimum qualification for somebody to be qualified to be on this board. I would add that the vast majority of the people that are on this list have law degrees, and most of this is done by one of our 2 law schools or some other Center for Dispute Resolution centers to provide the training. So this just allows or adds a little comfort into that in this bill, and that the people that will sit on this board will have some idea of what in the world they're doing. I'd appreciate a green vote.
Any further? Representative Simonson.
Thank you, Mr. Speaker and members, and I would stand up to oppose the Benson amendment. Members, this board is not creating a board of mediation. It's not creating a board of arbitration. It's creating a board that's set up to investigate unfair labor practices. And I really am somewhat offended that you suggest that the members of the board wouldn't be qualified to do that. When I look at the bill on page 5, it talks about the membership of the board, 3 members, who they are, where they come from, 1 coming as an officer and an employee of an exclusive representative of public employees appointed by the governor. 1 shall be a representative of public employers and shall be appointed by the governor, and 1 shall be representative of the public at large and shall be appointed by the other 2 members. We can't have a more diverse board here that's certainly qualified and educated enough to make determinations on unfair labor practices. What we don't want to do, and what we would be doing with this amendment, is tying the governor's and the board's hands in selecting the most qualified candidates. It's going to be really difficult, I'm guessing, to find someone with public sector labor experience, and yes, there is such a thing, from the list that's being talked about in this amendment. As was said, this list is containing mostly attorneys, and the board should not be limited to just attorneys. We should be focusing on qualified members of the board that have public sector labor experience. So, members, I would encourage a red vote.
Representative Quam.
Thank you, Mr. Speaker. And frankly, when I went through the training to be a qualified neutral, there were actually 2 people in that training that had labor background. And if you go to that training, I think there's probably quite a few of us sitting here that have, it's improving your skill set in how you handle conflict between groups in a neutral, and understanding and improving how you can listen to both sides, not let your personal or any of your history affect what you're doing. And frankly, whether you're here on the floor in committee or on a board like this, that's a good skill to have. Right now, there really doesn't seem to be anything other than association and then being, I guess, a friend of somebody, of getting put on the board. And I think that we need to look past that. I'd like to have broader qualifications and restrictions. In fact, I've got an amendment later on that would try to address some of that. But I would support this because I've been through the training, and I think it's a good program.
Representative Leidecker.
Well, thank you, Mr. Speaker. And this board, I think, should be called the super partisan board. I mean, am I the only one seeing this? I mean, we've got a representative of the employer appointed by the governor, and then the employee nominated by the governor, and then both of those members that are basically put there by the governor then they come up with the third person that's supposed to hypothetically then represent everybody else. I mean, this is about as partisan as can possibly be. I don't think we have anything else like this in government. I can't think of anything else where we have allowed the governor to essentially, he just handles the whole thing. And no training is required. There is no requirement that any of these people have any kind of knowledgeable background on the issue. I don't see it in the bill. I mean, this is as partisan as can be. At least this amendment here attempts to introduce some sort of training and some sort of qualification that we can at least trust that we're getting somebody that's trained up and maybe not partisan. Please correct me if I'm wrong, but I don't think there's anything else in government quite like this. So I recommend a green vote on this.
Representative Pepin.
Thank you, Mr. Speaker. And I just wanted to comment on some of the things that Representative Simon had said. Representative Simon, one thing that you forgot to point out was that this board that doesn't have any legal, there's no requirement of any legal training, no requirement of any mediation training, any requirement they have any skills in the law whatsoever. However, the board shall be issued state findings of fact and require the party to cease and desist from the unfair labor practice. They shall post a cease and desist notice in the workplace. They can require that. They can require reinstatement of public employees with back pay and compensatory damages up to 3 times the amount of actual damages. This is a board with real power, but yet they have no legal training whatsoever. None. There's no requirement that that they're a lawyer, that they're a judge, and there is no requirement anywhere in this bill that there be a neutral judge. That should be offensive to every one of us. You have a board with no legal training whatsoever. No requirement, you're speaking against this, no requirement that they have any mediation training. We have a process that's already set up that we've spent years perfecting through the Office of Administrative Hearing. They've promulgated rules, they have rules of civil procedure, they have rules of evidence that they've already set forth, and now we're expecting people, I cannot believe that we're even discussing this. People deserve to have a neutral judge. And if you think that 2 members appointed, one is a member of a labor union and one is a member of the employer and one is appointed by the other 2, if you think those people are, number 1, not partisan, and number 2, you can honestly say that they're neutral judges, that is shocking to me. At least this amendment, at the very least, provides that they have some sort of knowledge and training in mediation services. Frankly, this looks a lot like a kangaroo court to me. We need to have something in place, and I am just shocked that we wouldn't want to at least put some requirement in place, because I don't see how you can say that we're not going to put this in front of a neutral judge. Everyone is entitled to a neutral judge, and this bill in no way allows that. It's a sham, frankly, and members, I would encourage a green vote on this amendment.
Representative Benson.
Thank you, Mr. Speaker. And first of all, I request a roll call.
You already have one.
No, I didn't, but that's thank you. All right. So, to Representative Simonson, well, I'm amazed that you're offended. I am such that someone who wrote this bill and the other side didn't at least think about the kind of qualifications. I respect you as someone who knows labor and has probably been involved with arbitrations. And you know that the people that sit on those arbitration boards or an arbitrator has exhaustive experience in labor negotiations. So to think that this board, with the amount of responsibility they have, can have absolutely zero, that's offensive. That's offensive. And the people that have to go through this should be offended that we're not requiring any more training that's in this bill, the lack thereof. And another misconception about just the fact that the dispute resolution training that's required, on the civil side, you have to delineate exactly what you have experience in. It includes bankruptcy, creditor, debtor, business, commercial, complex litigation, class action, construction, employment, general civil, insurance, personal injury. These folks have a lot of training. And it's an exhaustive list. So I would be surprised if the governor couldn't find someone on this list to help pick his hand-picked people to get the kind of decisions he wants. But folks, we're going to give a lot of power to a small board, and we're saying to them, it's okay to pick anybody you want. Members, we need a little common sense, and I'm hoping the author of the bill sees that and will include some training. Thank you.
Representative Carlson.
Mr. Speaker, just a quick comment. These are gubernatorial appointments. The governor is held accountable for the appointments he or she might make. But in addition to that, I just want to remind people that my introductory comments pointed out that there are only 3 states that use the system that we currently use, and that something like 32 or 33 states, I forget the exact number, use a system like we have before the body. And it's working in those states. We modeled this legislation after what is done in other states, and I would encourage a no vote.
Okay.
Yep.
Seeing no further discussion, the clerk will take the roll on the amendment. The clerk will close the roll. There being 62 ayes and 71 nays, the motion prevails, or the motion does not prevail. The amendment is not adopted. There is another amendment at the desk. The clerk will report the amendment.
Benson M. moving to amend House File 3014, the second engrossment as follows. The amendment is coded A14.
Representative Benson.
Thank you, Mr. Speaker. And I started with this one, unfortunately, the last time, but it's similar in that Representative Erickson, I think, spoke to this already. So I'm not going to get into the weeds regarding everything that she said, but essentially this gives this board broader powers than than any other. It's rulemaking ability rivals that of an agency, and what goes on in here, and the agency heads. So to limit that power somewhat, we need to have some concern about it, how evidence is presented to the cases and how they're adjudicated eventually, so on and so forth. All this simply does is add to the language that the rules that they make don't remain in effect permanently. In fact, they have to be adopted by the legislature. All rules adopted by the board remain in effect only until the adjournment of the next regular session of the legislature after final adoption of the rules, unless the legislature enacts a law continuing the rules for a longer period. So simply, members, this adds some breaks to it in that it adds some assurances that if there are things that the board does that we don't like, it gives us some comfort in knowing that any rules that are made, we have to give our final stamp of approval. And I would encourage a green vote.
Representative Carlson.
Members, Mr. Speaker, members, I would urge a no vote. If this amendment were to become law, the board would find itself in limbo, unable to operate and unable to enforce unfair labor practices. If a legislator feels that the board has adopted a rule that is not good public policy, they can always just introduce a bill to overturn the rule or the rules in question. So, as I mentioned, this would create uncertainty for the board, and I would encourage, again, a no vote.
Representative Benson.
Thank you, Mr. Speaker. Members, really all this does is make sure that the board doesn't overstep their bounds. There is plenty of rules that already exist in how these things are done and how the cases would be adjudicated, that they don't need to be off in some kind of trip to design or redesign the entire system. This will give us some comfort as legislators to know that regardless of who's in power, Republican or Democrat, that eventually these rules would have to come back to this body and we would have a say. So, Mr. Speaker, I'd like a roll call on the vote, and I would ask for your support.
Roll call being requested. Seeing 15 hands, there will be a roll call. Seeing no further discussion, the clerk will take the roll on the amendment. The clerk will close the roll. There being 61 ayes and 71 nays, the motion does not prevail. The amendment is not adopted. There's another amendment at the desk. The clerk will report the amendment.
Scott, moving to amend House File 3014. The second engrossment as follows. The amendment is coded A15.
Representative Scott.
Thank you, Mr. Speaker. This amendment would allow for 60 days for the appeal of the ruling by the board rather than the 30. Seems like 30 days is just a little bit of a too short of a period of time, and we wouldn't want someone to be out of town or in the hospital and not being able to have adequate time to appeal the board ruling. The board this bill is also silent as to how those involved in a dispute will be notified of the board's ruling. So we really don't know, a document could get lost in the mail. We don't know how this is going to be sent. The notification is going to be sent, so I'd encourage a green vote just to make it a more fair process.
Representative Carlson.
Yes, Mr. Speaker, members, again, I would encourage a no vote. This amendment really flies in the face of the basic intent of the bill, which is to do things in a faster, more timely, less expensive manner when we're dealing with unfair labor practices. Currently, the 30 days mirrors Pelra's timeline for appeal of a commissioner's decision, and I don't think we need 60 days. That just simply slows the process down and flies in the face, as I say, of one of our goals. Please vote no.
Representative Quam.
Thank you, Mr. Speaker. And having listened to previous comments by the author of the bill and others, that this would include an impact on local governments. Some local governments, especially during parts of the year, don't have a lot of activity going on, and therefore, if they don't get notified quickly enough, and again, it's sort of ambiguous how they'd be notified. So if something is sent by letter and it doesn't get there until after they have a meeting, they might not get together for another month, and therefore I think it's just reasonable to extend this to 60 days, because I know we've got some of that with other activities that go on. And again, local government should have plenty of time, and many of the people in local government are part-time people.
Further discussion on the amendment. All those in favor of the amendment say aye. Aye. All opposed, no. No. The motion does not prevail. The amendment is not adopted. There is another amendment at the desk. The clerk will report the amendment.
Hansen, moving to amend House File 3014. The second engrossment as follows. The amendment is coded A16.
Representative Franzen.
Thank you, Mr. Speaker and members. This amendment simply says that requires a minimum of 30 days notice between issuance of a complaint by the board and a board hearing. The bill currently provides 5 to 20 days between issuance and the hearing, which I feel is inadequate for a party to prepare for the hearing. Simply put, Representative Carlson, that let's say a person is going on vacation or maybe is on an extended vacation and gets notice of this hearing and is unable to attend. So I just ask for just to change it to a minimum of 30 days. I don't think that should be too hard to do. Thank you.
Representative Carlson.
Yes, Mr. Speaker, members, again, this slows down the process, so the issue is the same as the last amendment. We're trying to make this a faster, more efficient process than what we currently have, and I would encourage a no vote.
Representative Pepin.
Thank you, Mr. Speaker. Would Representative Carlson yield to a question?
He will. Representative Pepin.
Representative Carlson, I'm wondering if you could give a rundown of the timeline. I'm trying to read this. It looks like that after you serve the complaint, and maybe you can talk about that service of process, is it in person? Normally in civil, the rules of civil procedure and even the ALJ provide specific rules for service, which isn't clear here. Does it have to be by mail, in person? Is that shown anywhere? And then if you could give the timeline of the process. It looks like after the complaint is filed, they have 5 days, not less than 5 days and not more than 20 days, and then they can amend it at any time until the hearing. And then the party who is the subject of the complaint has the right to file an answer. So it looks to me like they can require the hearing in as little as 5 days. During that 5 days, they can amend the complaint any time, and the other party has to respond potentially within that 5-day period. And just to give some context, the rules of civil procedure allow for at least 21 days, the Minnesota Rules of Civil Procedure, sometimes up to 60, and then an answer, a response time of up to 14 days if there's an amended complaint. And even the ALJ process allows for, I think it's 30 days. And so my concern here, Representative Carlson, is that I'm not sure how they're going to be served. There's no clear understanding of how we know that the person even gets the information that there's a hearing. And then if they're out of town or whatnot, it could happen within 5 days. They don't really have time to amendment. So I'm wondering if you could kind of run down the timeline and how this is going to work and the whole service issue.
Representative Carlson.
Mr. Speaker, you've pretty well run down the timeline. It's from 5 to 20 days. What the amendment does is it extends it an additional 30 days, which slows down the process. You're concerned about how the process would work, and unfortunately we had some amendments that were offered, but fortunately they were defeated, which was to provide for a rulemaking process. So some of the issues that you're raising, in my view, would be resolved when the rules process takes place and those rules are adopted.
Representative Pepin.
In terms of clarity.
Thank you, Mr. Speaker. Representative Carlson, it's very troubling to me, especially, I think it's far too short of a notice, and especially the part that says the party who is the subject of the complaint has the right to file an answer to the original or amended complaint prior to the hearing. They might not even get 20, there's not even a requirement that there's 12 hours or 24 hours. I wish I know there's a dozen lawyers on the other side. I haven't seen any of them pop in and speak on behalf of the process here, but, if there's any over there that actually are prosecutors, I'd love to know what they thought about not having any time to reply to an amended complaint in only 5 days. I think this is just a violation of due process of the rights of people. You're asking people to respond when we don't even know how they're going to be. We don't even have a guarantee, because there are no rules yet that say how they have to be served. I cannot believe you talk about rulemaking, but we already have a process in place. We've spent years developing a process that works very, very well, very efficiently, and now we're abandoning that process of having these cases heard before a neutral judge, and instead we're going to go to this process with people with no legal training whatsoever, no mediation training, and they're going to have this system where they can file a complaint, require a hearing within 5 days, that we can amend their complaint, and then the other party has no time to respond. I just do not see how anybody, the other side, you talk about justice a lot, liberty and justice for all, we hear in here a lot. How is that justice? How is it justice that folks have absolutely no time to reply? If you could potentially file your complaint, and then you can amend the complaint and have virtually no time to respond. I mean, this is just really surprising, really shocking. I encourage you to support the Franzen amendment because this will at least go back to a process that's already established in place. It will provide a little bit more time. I think the bill needs a lot of work on the rules and how the claim is going to be served, and the amendment time, how long you're going to get, but at the very least, we should at least put in 30 days. I mean, that's only fair. I just cannot believe anybody, think about it. Would you want to do this, anybody? Would you want to be served with a complaint and say, okay, it's Monday, you have to be in court on Friday. Oh, whoops, you didn't get it? Well, I gave it to your stepdaughter. I gave it to the dog. Why aren't you here? I mean, this is ridiculous. I cannot believe it. Members, I really encourage you to support this Franzen amendment. And I'm not sure if she asked for a roll call, but I'd like a roll call on this.
Representative Pepin requests a roll call. Seeing 15 hands, there will be a roll call. The member from Douglas, Representative Franzen.
Thank you, Madam Speaker. Members, this is just a simple bill or an amendment. This is really an injustice. Like Representative Pepin said, an injustice. We're asking 5 days. I think most of you know I've got a lot of speeding tickets on my record, but every time I have gotten a speeding ticket, I have been given more than 5 days to dispute that claim. I have never gotten a speeding ticket that says, on a Monday, you need to be to court on Friday to dispute that. That's all I'm asking for. I'm asking for a little justice for those. And it's really not that hard. I mean, I don't know if Representative Carlson would yield to a question.
He will yield. Representative Franzen.
Thank you, Madam Speaker. Representative Carlson, I'm curious. Is this something that PELRA recommends? Is this on their website? 5 days?
Representative Carlson.
Madam Speaker, I can't say that PELRA recommends because PELRA is a law. The question that we're trying to resolve, and as I mentioned earlier, we looked at what other states do to have a faster, more efficient, less costly system. And this is what 30-some states do. So when you're kicking up your heels, so to speak, that this isn't workable, it works in most of the United States of America. And there are only 3 states that have a system like we do. And our system is potentially very slow, long and drawn out. Sometimes it takes years for resolution, and that's what we're trying to resolve, as well as the high cost of trying to get these unfair labor practices resolved. So it's a system that will work, and as I mentioned earlier, if there are issues that on the process that are not mentioned directly in the statute or potential statute, that will be a part of the rulemaking process.
Representative Franzen.
Thank you, Madam Speaker. And Representative Carlson, thank you for that answer. You said that 30-some states have this already enacted. But this is Minnesota, and I think that Minnesota, we like to think that we are, leading the charge across the nation here, and I would just hate to think that if 30-some other states wanted, something done, that we would have to follow suit. So members, I just ask that you vote yes on my amendment. Thank you.
Is there any further discussion to the amendment? Seeing none, the clerk will take the roll on the amendment. The clerk will close the roll. There being 62 ayes and 71 nays, the motion does not prevail. The amendment is not adopted. There's an amendment at the desk. The clerk will report the amendment.
Albright, moving to amend House File 3014, The second engrossment as follows. The amendment is coded A18.
The member from Scott, Representative Albright.
Thank you, Madam Speaker. Members, this amendment deals with the appointment to the members on the board, and my amendment actually, I think, strengthens the case for impartiality. Currently under this bill, which Representative Carlson has put forth, there are two members on there. One is appointed by the governor, and one is a representative of the public at large. And between the two of those two appointees, they appoint another one. I think in the broader scope, as you look at it, there are more than just public employees that are important to this. You've got individual employees that may not feel the union represents their interests. You might have employees that may be dues-only members of the union with a different perspective. Different units of government may agree with each other or may not agree with each other on labor strategy, and impartial taxpayers have an entirely different perspective and interest on labor or management. So this amendment candidly puts the taxpayer at the forefront of the board and makes sure that their interests are best served, and I ask for a green vote.
Representative Carlson.
Madam Speaker, I would encourage a no vote, and Section 5, Subdivision 8 of the bill already has a strong conflict of interest standard. If a member of the board does have a conflict, they are required under this section of law not to participate, and we did, during the committee process, include three alternates. So one of the alternates that would not have a conflict of interest would step forward. We're also, with this board, trying to develop some expertise in labor law, and as they gain more experience, we'll have, as I've indicated earlier, faster, better rulings. I think there's sort of an assumption here that every judge has a background in labor law, and that's just simply not true. And so we would have, I think, a stronger system in place, and I would again say vote no.
The member from Carver, Representative Leidiger.
Thank you, Madam Speaker. Thank you, Representative Albright, for bringing forward this amendment. It really does make the board, to me at least, far more palatable instead of the SPB, the super partisan board. But I want to ask a question of Representative Carlson. You know, you talk about the 30 states. If he would yield, please.
He will yield. Representative Leidiger.
There are 32 states that you've been mentioning, 30 or 32. And my question to you is, how are their boards made up? Is it the same kind of a system across those 30 states where they have this super bipartisan board, or is it more along the lines of what Representative Albright is proposing?
Representative Carlson.
Madam Speaker, when you look at those states, there is variation in terms of the makeup of the board. What I'm referring to when I mention those other states is a very similar process to what we are setting up here. Some of the states would have a system that's very close, if not almost identical to what we're proposing here, but when you're dealing with 30-some states, 30-some different legislative bodies, obviously there would be some variation when we were researching this particular bill. I hope that answers your question.
Representative Leidiger.
Thank you, Madam Speaker. No, it doesn't answer the question. I would really love to have it broken out, know how many are exactly like you're proposing, how many are different. But I know I'm not going to get that answer. And this is the biggest problem I have with this bill, and I've got a deed to bring up later. But, you know, we're talking about a super partisan group. Two guys, two people, you know, nominated by the governor, and then those guys get to huddle and bring in their guy that's supposed to somehow represent the rest. No training, nothing. And we're supposed to believe that that's going to work. Well, I like what Representative Albright is brought up, and I hope that you'll accept that amendment. Thank you.
The member from Hennepin, Representative Nelson.
Thank you, Madam Speaker. And members, the super partisan board that you're talking about is similar to a board that we already have in statute in 197.46 that Representative Leiter should be well aware of. It's called the Veterans Preference Act, removal forbidden right of mandamus. And there they have a board that's set up where a veteran has issues and wants to have them, and doesn't want to go to the Civil Service Board, and Representative Detmer had a bill earlier this year dealing with this. But this board also, this law part also sets up a board where one person is picked by the veteran, one person is picked by the employer, they pick a third neutral person, and that's the board that the veteran who may be getting in the process of getting fired or let go by the government agency he's working for uses. This is the same type of board as we're setting up here for PELRA. And that's not a super partisan board. So members, this way we're setting this board up is the way it needs to be done. You have one employer representative, you have one employee representative, and they pick a third person, and then they hear the complaints and they decide. That's what the board sets up, and I say vote red on this amendment.
Representative Albright.
Thank you, Madam Speaker. Before I respond to the points, I have a minor technical amendment to my amendment.
Representative Albright, go ahead. We'll see if it's something that you can incorporate.
It's an oral amendment, ma'am.
An amendment to the amendment wouldn't be in order because it didn't meet the filing deadline, but we'll see if if it's minor, then you can
incorporate it. It is just to modify on line 1.2, insert under the word, it should be spelled F-I-V-E, not F-V-E. We wouldn't want that to be misinterpreted.
Representative Albright, I'm told that it's the way it's represented here on the paper, it doesn't show the I, but in the electronic version we have, the I is there. So you're all set.
So the ayes have it.
The I is present.
I'll be here all night. Representative, Madam Speaker, if Representative Nelson would stand for a question.
He will yield. Representative Albright.
Representative Nelson, in your prior remarks, you speak to the correctness of the board and in regard to knowledge of these measures with regard to National Labor Relations actions. And I'm just curious, and maybe you can not comment to this, but it seems to be a bit analogous to the way that the board was put together for another one of our more favorite topics on this floor in the last session, an acronym that starts with an M and ends with an E, and I'm not sure what goes in between. But I'm just wondering why we are going after people with expertise on this board and we selected people for other boards that might not have the same expertise. I'm wondering if you could speak to that.
Representative Nelson.
Thank you, Madam Chair, or Madam Speaker. I didn't understand the question.
Representative Albright.
I'll retract the question and just ask a roll call on this amendment, Madam Speaker.
Representative Albright requests a roll call. Seeing 15 hands, there will be a roll call. Representative Carlson.
Madam Speaker, I just wanted to reinforce what Representative Nelson was saying. When you use arguments like super partisan board, keep in mind we're dealing with unfair labor practices, and of this three-member board, one represents the collective bargaining side, the representatives of the union, the other is representing the employer with their selecting the neutral person. So I just have to take strong exception with the idea that somehow this is a super partisan board. This kind of thing is done throughout labor law. When you go into mediation and so on, you have processes where you select neutral parties. We just wanted to make sure that the concerns of the employer are represented, that the concern of the employees are represented, and then there be a neutral person chosen by the other two.
Representative Leidiger.
Well, thank you, Madam Speaker. Representative Nelson, you're wrong. It's
what you just talked about with the Veterans Board is nothing like this at all. In that board, you have the veteran that has their person, you have the entity that he's going against have their person, and they come together and they get a third person. In this case, what you have is the governor appointing both people, and then they get together and they get the third guy. It's not, we don't have anything else like this in government. And I realize you got up to try to come up and say that the veterans thing is somewhat similar. It is nowhere near that. Because each party is able to ask for their own representative.
Representative Nelson.
Thank you, Madam Speaker. And Representative Leidiger, it's exactly similar. The governor appoints one person who's a representative of the government employees or government employers. He's appointing one person that represents the labor side of it, and those two people pick the third person. And the part where it's dissimilar is that in the case where the Veterans Board, the veteran picks his person, but that's what they're being done by the employer representative being picked. And that's what we're talking about here, that this is the same similar type board as the Veterans Preference Board. And we can argue back and forth whether it's similar or not. You say tomato, I say tomato.
Representative Leidiger.
Thank you, Madam Speaker. Once again, the common denominator at what we're talking about is the governor. It's the governor. The governor appoints both parties. And then those people get that third party, right? That means the common denominator, the governor, has complete power over that board. That's why I call it the super bipartisan board. Very different. We don't have anything like this in government. Just know that.
The member from Wabasha, Representative Drazkowski.
Thank you, Madam Speaker. Would Representative Nelson yield?
He will yield. Representative Drazkowski.
Thank you, Madam Speaker. Well, Representative Nelson, I've been listening to this discussion, and the amendment actually inserts something novel for your side of the aisle, that we should actually have this board protect or have represented the interest of the taxpayers of the state of Minnesota. So how, Representative Nelson, can you deliver to us the notion in this bill, as written, the taxpayers are represented?
Representative Nelson.
Well, thank you, Madam Chair and Representative Drazkowski. I didn't realize that if I'm an employee representative, a business agent for a union, or if I'm a government employee, will be the management of them are not taxpayers. And we had a lot of discussion earlier about a term that is defined in federal law that you yourself kept asking for a definition. Where's the definition of an impartial taxpayer? We're all taxpayers if we live in the state of Minnesota and work in the state of Minnesota.
Representative Drazkowski.
Thank you, Madam Speaker. Well, thank you, Representative Nelson. And you may be right. The amendment may need to be better defined or have some definition behind what is an impartial taxpayer. But the reality is the interests of taxpayers are not represented in this bill. We've got the confluence of big labor coming together with big government, and those two are very well represented here. Just as we've seen in the employee contracts, the unions are negotiating with themselves. And so now we've got a bill to come together that represents, again, well, we've got the interests of big government, we've got the interests of big labor, big unions, and they're both appointed by, really, the state's biggest union leader, if you will, that we have. Where are the taxpayers represented? They are not. And so, Representative Albright, thank you for bringing your amendment. Thank you for starting to point out to the people of Minnesota, and the people of Minnesota are watching. They realize what is happening to them here, and it's the people of Minnesota who are losing out on these union interest bills that keep coming forward by the Democrat Party to forward the interests of those organizations so that they get paid back for the legislature and the governor that they delivered to Minnesota in the last election. Thank you, Madam Speaker.
Representative Albright.
Thank you, Madam Speaker. Would Representative Carlson be willing to answer a couple more questions?
He will yield. Representative Albright.
Thank you, Madam Speaker. Representative Carlson, on line 5.28, it talks about that the first two appointed to this board will appoint a third. And I'm just wondering if you could speak to any type of qualifications that they would use as a template for selecting that third member to this board.
Representative Carlson.
Mr. Speaker, members, if once the rules are in place, I would suspect that that concern could be addressed there. The main qualification, of course, is to find a person that would represent a neutral point of view and not represent the issues of the employer or the employee. And that's why we also have the alternates in place, just in case there would be a conflict of interest among the regular board members. But as far as any other criteria, that could be a part of the rulemaking process.
Representative Albright.
Thank you, Madam Speaker. And Representative Carlson, I'm just wondering if you could point me to where that rulemaking is in here, and it seems a bit concerning that we would leave so many of these provisions up to a three-member board without putting some guardrails up, as we've heard before, in terms of how this board is put together. So I'm wondering if you could speak to that, please, Madam Speaker.
Representative Carlson.
It will take me a minute to find the rulemaking authority. Maybe we can come back to that.
Representative Albright.
Thank you, Madam Speaker. And I'm going to just ask maybe an elaborative question for Representative Carlson on that, in terms of specifically in the bill where mutually agreed to concerns are also enumerated. Madam Speaker.
Representative Carlson.
Madam Speaker, I indicated it would take me a minute to find where the rulemaking authority is, and it's on page 6 of the bill, subdivision 6, rulemaking. The board shall adopt rules under Chapter 14 governing the presentation of issues and taking of appeals under subdivision 5. All issues, appeals presented to the board shall be determined upon the record of hearing, except that the board may request additional evidence when necessary or helpful. You asked about the rule-making authority, and that's where the process would be set in place. Again, page 6, subdivision 6.
Representative Albright.
Madam Speaker, would Representative Carlson continue to yield?
He will. Representative Albright.
If we're appointing this board, how would they know Chapter 14 would be applicable to them, and would they be versant in Chapter 14? If you're looking for that third person, what qualifications? And I go back to that because it just seems as if we are setting them up for a bit of a circular decision, and I'll leave you with this as well as a question in terms of, on line 5.31, Representative Carlson, you talk about a term beginning for each chair that's decided on the 1st of July every year. And I'm just wondering if there is a rotation, or can the same person act as chair in perpetuity, Madam Chair?
Representative Carlson.
Madam Chair, you would have a term of office of 1 year. That would be up to the board in terms of whether you would serve a second year. We have a lot of governing boards, and they usually establish their own traditions as to who might be the chair. Some might choose to have it as a rotation. What comes to mind when you select the officers, for example, the Board of Regents at the university, they have a tradition, if you will, that you select a board chair who serves a set term, and then you usually elevate the vice chair to that position. Many of us here serve on various community boards and so on, and they set their own processes in terms of how long a person may serve. But the term is 1 year, and then they would determine whether that would continue beyond a year or whether they would rotate it.
Representative Albright.
Thank you, Mr. Speaker. I think we've enumerated the issues that are most concerning to this, and from a policy perspective, I think more in this case is a more robust discussion, particularly when we're dealing with issues of labor. I think the more voices that are heard, the more consideration is very beneficial. And as my good friend Representative Draskowski said, this puts the taxpayer at the forefront of the consideration for these, and that's what we were called to do, is come here and represent the taxpayer. And so I urge a green vote. I think it is measured. I believe that it is well balanced, and I believe that it does assert the best interests of all Minnesotans. Thank you.
Hold on. Any further discussion? Seeing none, the clerk will take the roll on the amendment. The clerk will close the roll. We should wait for this one. There being 61 ayes and 71 nays, the motion does not prevail. The amendment is not adopted. Representative Holberg, for what purpose do you rise?
Thank you, Mr. Speaker. Members, I rise for a point of personal privilege.
State your point of personal privilege.
Thank you, Mr. Speaker. Members, we have sad news today. One of our former members has passed, Representative Steve Smith. He was first elected in 1990 and served 11 terms. He served as the Civil Law Chair, the Judiciary, Finance, and Public Safety Chair, and before coming to the legislature, he was the mayor in Mound. He was a unique character. He was a vocal member of the very small labor caucus in the Republican House of Representatives. He worked tirelessly on child support issues, and I remember him working 5 or 6 years on a bill that finally passed about 10 years ago. And it was a big accomplishment. It was a lot of work dealing with a lot of interest, and I don't think we've seen reform in that area to that degree since then. He was the chair of the Civil Law Committee when I, as a freshman, was sentenced to serve on the Civil Law Committee, and I have to admit I came in with a pretty bad attitude and wasn't really interested in the issue. Subsequently, I never left the committee, and it's probably my favorite interest area. But in our first meeting, he sat us all, the Republicans, down, and he told us that if you're on my committee, you will vote as I vote. And boy, I thought this was going from bad to worse really quickly. And so at a later time, I went and had a one-on-one with him and said, well, just, I thought I was supposed to come up here and vote with my constituents. And he kind of laughed and said, well, certainly that's the case. What I really was saying, that if you have issues with bills, don't surprise me, then please talk to me ahead of time and we'll work them out. So I have many, many fond memories of Representative Steve Smith. The news of his passing is very sad. He's survived by his son, Ryan. At this time, given that he was just found today, we don't have any more details about services, etc., but we'll be sure to get them out. And with that, I'd like to ask for a moment of silence.
There is another amendment at the desk. The clerk will report the amendment.
Franson moving to amend House File 3014, the second engrossment as follows. The amendment is coded A20.
Representative Franson.
Thank you, members, or Mr. Speaker and members. 820 simply says requires the commissioner approval before investigations can be commenced. Straightforward amendment, and I ask for your support. May I get a roll call, please, too, on this, Mr. Speaker?
Roll call being requested. Seeing 15 hands, there will be a roll call. Representative Simonson.
Thank you, Mr. Speaker and members, and I would ask that you vote no on the A20. The board that we're creating here in this bill is responsible for adjudicating unfair labor practices. The commissioner of the BMS, on the other hand, is responsible for mediation. What this amendment may do, perhaps, by inserting the commissioner in the process of approval, may create a conflict between the mediation and the adjudicating of unfair labor practices. If you read the bill, one of the options that's before the two parties to the unfair labor practice charge is that any time during the process or even during the hearing, if they mutually agree, they can submit the issue to mediation, at which time it would come before the commissioner for resolve. So I personally think that we should vote no on this because it creates a potential conflict of interest between the commissioner and the board.
For Representative Franson.
Thank you, Mr. Speaker. Members are actually, would Representative Carlson yield to a question, please?
He will yield. Representative Franson.
Thank you, Mr. Speaker. Representative Carlson, I'm just wondering here with this another union payback bill. First, I'm wondering. Well, I'm not going to ask you to yield to this, but I am wondering out loud why we just don't have one big ominous union payback bill and make things a lot simpler. We could argue for 20 hours and vote on one big, huge package. But my question to you, Representative Carlson, is why would we even have a commissioner of BMS if they are not going to have any authority over this issue?
Representative Carlson.
Yes, Mr. Speaker, Representative Franson. First of all, as I did earlier, I want to take strong exception with the rhetoric that this is somehow a payback bill. Keep in mind my introductory comments that with some housekeeping language that I'll be coming up with a little bit later in the process, this bill is supported by MMB, which represents the management side, and it's also supported, yes, by a number of the labor groups, but it also covers individuals that might want to raise an unfair labor issue. So the idea that this is somehow a payback is strictly false. Now, going to the Commissioner, I think that was already addressed by Representative Simon, and that's that it would, we've set up an independent board, and it would put the Commissioner into the middle of the unfair labor practice dispute, and that would not be the role of the Commissioner, and it would be the role of the board to resolve the issue.
Representative Franson. Representative Leidiger.
Thank you, Mr. Speaker. You know, Representative Franson's bill is very good. I mean, I think we're going to need adult supervision over this board that we're creating. This board that we're creating is being put together by one person, the governor. He gets both sides, and then those people get the third person. It makes a lot of sense that we have the Commissioner of Mediation Services at least look over what's going on, at least for the first 5 to 10 years. It makes sense to me. So I recommend a green vote.
Any further discussion? Representative Franson.
Thank you, Mr. Speaker. Members, I just want to remind you about MNsure. You know, there's no oversight on MNsure, and look at the debacle that has caused our state, the citizens of this great state, and even this legislative body. And now we're going to pass another bill with hardly any oversight again. So I'm just asking for a yes vote on this amendment, and we can move forward. Thank you.
Seeing no further discussion on the amendment, the clerk will take the roll on the amendment. The clerk will close the roll. No, right. Okay. Lomer votes aye. There being 61 ayes and 72 nays, the motion does not prevail. The amendment is not adopted. There's another amendment at the desk. The clerk will report the amendment.
Quam moving to amend House File 3014, a second engrossment as follows. The amendment is coded A21.
Representative Quam.
Thank you, Mr. Speaker. And members, this is to sort of idle back a little bit of the power of the board, maintain some of the functions within the purview of the Commissioner of Mediation Services, and allow the Commissioner to determine the possible future action. And the deletions on page 11, 12, and 13 are just removing the added language of "or the board." And so it's maintaining some of the same activities as we presently have. And again, I have some concerns about the board, the makeup. I'm not calmed by the statement that's been made that, well, we'll pass it and then some rules will get generated and we'll figure out how it works. I think we need a little more structure than that. And I'm trying to mitigate the impact by decreasing some of the expansive powers of the board. And I hope for your support.
Representative Carlson.
Mr. Speaker, I would again urge a no vote. This basically negates the board's authority to make decisions while still having a board. In other words, it guts the authority of the board. It flies in the face of what we're trying to accomplish here with this legislation. So again, a no vote would be appreciated.
Seeing no further discussion, all those in favor of the amendment say aye. Aye. All those opposed, no. No. Motion does not prevail. The amendment is not adopted. There is another amendment at the desk. The clerk will report the amendment.
Pepin moving to amend House File 3014, a second engrossment as follows. The amendment is coded A22.
Representative Pepin.
Thank you, Mr. Speaker and members. My amendment is pretty straightforward. It just says that opinions issued by the board are not binding, but they would be given deference to the court, and it would also allow for attorney's fees of the prevailing party. Members, it's pretty simple, straightforward, fair, and I'd ask for your green vote. And could I get a roll call, Mr. Speaker?
Roll call has been requested. Seeing 15 hands, there will be a roll call. Any discussion to the amendment? Representative Simonson.
Thank you, Mr. Speaker, and I would stand to oppose the A22 amendment. This really guts the intent of the bill. The intent of the bill is to simplify the process and take the excessive cost out of the process for folks that are wanting to raise the question of an unfair labor practice. If we were to accept this amendment, essentially what we would be doing is be making the current practice even worse. It takes any teeth out of the board decision. It requires the parties to go to state court to get the relief that they sought in the first place, and it's going to make the process even longer than the current process, because in addition to having to go through the non-binding board process, I now then have to go to state court in order to get it resolved. So I would encourage a red vote, members.
Any further discussion? Seeing none, the clerk will take the roll on the amendment. Clerk will close the roll. There being 61 ayes and 72 nays, the motion does not prevail. The amendment is not adopted. There is another amendment at the desk. The clerk will report the amendment.
Quam moving to amend House File 3014, the second engrossment as follows. The amendment is coded A23.
Representative Quam.
Thank you, Mr. Speaker and members. If you look at this language, it'll seem a little bit familiar in that it was touched on in previous discussion. We had a major bill that passed last year in the restrictions in order to ensure that there would not be any conflict of interest. Doctors and nurses that had not been unemployed from their profession for a year or longer were not allowed to participate in a board. Well, I think that if that was the determination of the majority of this body, then the majority of this body would see the logic in not allowing a current employee or an employee that has not been discontinued from his position for less than a year to be part of this board. Because I heard from the majority last year it was important to not allow conflict of interest to seep into these powerful decision-making boards. And therefore I'm borrowing from that logic and placing it directly into this bill with this amendment with your support that would prohibit, pretty straightforward, a public employee or an employee of an exclusive representative of the public employees may not serve on the board. And it does have that on the last line, the 1 year after employment. So again, this should be very familiar to the majority in the across the aisle, and something that you've spoken vehemently for in committee on other boards. Therefore, I anticipate much bipartisan support on this amendment and ask for the green vote.
Representative Simonson.
Thank you, Mr. Speaker. Will Representative Quam yield to a question?
He will yield. Representative Simonson.
Thank you, Mr. Speaker. Representative Quam, can you tell me what you're trying to accomplish exactly with this amendment?
Representative Quam.
Thank you, Mr. Speaker. Basically, and channeling some of the logic that was used in the past, is that to make it less likely to have a suspicion or a thought that there was a conflict, we would not be allowing a current employee to be on the board if they were active in this process. You know, similar to, it didn't matter if the doctor was private or part of a hospital, they weren't allowed on the MNsure board unless they'd been unemployed in that profession for a year. Because, as was brought up repeatedly by, I guess, a member that's not in the chamber at this time, that that would be inappropriate, improper, and so I want to make sure that we don't allow this board to suffer the thought of impropriety or conflict of interest, and so for to make the board better. That's why I brought forth this amendment, and I guess I would like a roll call.
Roll call has been requested. Seeing 15 hands, there will be a roll call. Representative Simonson.
Thank you, Mr. Speaker, and thank you, Representative Quam, for answering that question. So, members, I'm going to oppose the A23 amendment for the simple reason that we heard from the representative that his concern is about conflict of interest and trying to avoid conflict of interest, which I concur with. I agree that's a good idea. But this bill, as Representative Carlson well knows, that addresses conflicts of interest by appointing alternate board members, and if you look at Section 5, Subdivision 2, and again at Subdivision 8, it very clearly addresses conflicts of interest. If we were to pass this amendment, members, we would not be allowing public employees or their exclusive representative to represent their position on the board, and that makes absolutely no sense. I encourage a red vote.
Representative Dean.
Thank you, Mr. Speaker. Would Representative Simonson yield for a question?
He will. Representative Dean.
Thank you, Mr. Speaker and Representative. We brought up the conflict of interest standard, and Representative Quam, I think, brought this up in the form of an amendment, really bringing back the standard for conflict of interest that you yourself in your party and your caucus brought forward with the MNsure board, which is to say that people who are in the field, in the case of MNsure, doctors, people who are caring for patients and providing care, and people from the insurance industry, those who are paying for that through the processing of insurance, have just an inherent conflict of interest. That was the standard that you set through your policy last year. Representative, how is that working out for you?
Representative Simonson.
Very well. Thank you for asking the question.
Representative Dean.
Well, Mr. Speaker and Representative Simonson, I think would you categorize MNsure's launch, success, oversight as an unmitigated success, a brilliant success, or just a garden variety success? Since how would you rank that as moving as that has been rolled out? Because I think that if you believe that that is the case, that this is an unbelievably well-managed organization, and this was rolled out properly, that the oversight of this board is enhanced by those standards that you set in place, how would you rank that in terms of its success?
Representative Simonson will yield. Representative Simonson.
Thank you, Mr. Speaker and Representative Dean. I know where you're going with this, and I think I understand the question, but it's really hard to quantify that in an answer. But I think that what we see now, the end result, is good for Minnesota. We see more Minnesotans now with health insurance than we had before we started the process. But, Mr. Speaker, I don't understand what the question has to do with the issue at hand, which is the amendment.
Okay. Representative Dean.
Thank you, Mr. Speaker and Representative Simonson. The connection was drawn together by the amendment that is before the body, currently the A23 amendment, that seeks to join together the standard that you set for conflict of interest last year in that board for the one that you see now. Now, we might say maybe this is a good idea, maybe it's a bad idea for public policy. Let's look back at the standard that we set last year. Representative Quam, I'm really sorry. I think this is it didn't work out so well, so I'm going to vote against your amendment, because I think people who know what they're doing should be managing the boards that we are setting up. I think that that's good public policy. But I appreciate the point that you're making, Representative Quam, which is the standard that was set for conflict of interest through the MNsure board was rolled out catastrophically in the last year. We are seeing that has one set of standards for one sector of the economy, medicine, and we have another set of we're talking about labor and labor groups. That maybe we have a different standard for conflict of interest when we're talking about another set of professionals, when we're talking about lawyers and labor unions and not doctors and nurses and people who take care of our patients. So, Representative Quam, I thank you for bringing this amendment forward, and I intend to put up a big red vote against your amendment.
Representative Nelson.
Thank you, Mr. Speaker and members. If Representative Quam's amendment were to go on, I mean, we heard earlier about the super partisan board, super labor-friendly board that we're creating here. We would remove anyone that has interest for the government, for the current administration, or future administrations for the state of Minnesota. Say a Republican, say Representative Zellers becomes governor in the next election. He would not be able to appoint anybody from his administration to this board to look out for his administration's point of view, because they would be considered a current employee of the state of Minnesota. So therefore, this could be a super partisan labor board that would not be looking out for the best interests of the state of Minnesota. So I would say vote red on this amendment, because we're going to be hamstringing our future governors the chance to be able to appoint people to this board to represent the government side, the employer side on this board, as well as the labor side from the other side of it. So vote red.
Representative Quam.
Thank you, Mr. Speaker. And I guess we'd have to have citizens, average citizens, and if we had allowed another amendment that had been trained to be impartial on issues and looking at stuff, and have them decide. I guess I will withdraw the roll call.
Roll call's been withdrawn?
People to feel conflicted about, well, I voted this way last time, and am I being inconsistent? So we'll add some anonymity to the vote. But, again, I'm just trying to bring forward, I assume that the author of the bill or the members on the other side of the aisle neglected to be as persistent with the adherence to try and prevent conflict of interest as in a past bill. And we'll see what the body wills.
Representative Pepin.
Thank you, Mr. Speaker. And to Representative Nelson's comments about each side should have someone to represent them. That's the point, Representative Nelson. This is an adjudicative process. It should be a neutral decision maker, not representatives from either side. I'd like you to think about it in a court of law. If you're in a court case, you've got the prosecution and you've got the defense. Each side has a lawyer that represents them. And that's what we have here, but what we're missing here is the judge. So the problem is that we don't have a neutral decision maker. So this is a conflict. This board is making adjudicative decisions that can result in fines and can result in all sorts of bad things outlined in the bill. And that's why this is different and why the conflict of interest thing is really important. And Representative Quam, I thank you for bringing this forward, and I intend to support this amendment, give it a green vote, and I hope you do as well.
Okay, hold on. Any further discussion? Seeing none. All those in favor of the amendment say aye. All opposed, no. Motion does not prevail. The amendment is not adopted. There's another amendment at the desk. The clerk will report the amendment.
Pepin moving to amend House File 3014, the second engrossment as follows. The amendment is coded A24.
Representative Pepin.
Thank you, Mr. Speaker and members. The Carlson bill says that no rules of evidence will be used. And for those of you who are lawyers, I know that you know that that's very problematic, because it's not very clear if hearsay can be used, if double hearsay can be used, if triple hearsay can be used, if relevant evidence is required. We don't know because there's no process in place, and the bill actually says that we're not going to use the rules of evidence. And so it's really unclear what people can bring in and what will be used towards the evidence. So all this amendment does is say that the rules of evidence adopted by the Office of Administrative Hearings to govern contested case proceedings, our rules in this bill will follow those rules. The rules have already been set up. They are a little less robust than the rules of evidence that we would use in the district courts. not as many requirements, but they still have standards, and they still lay out what exactly would be admissible. And I think it's very troubling that there are no laid out rules of evidence that are used. Because if you think about it, if you want to have someone coming in and saying, well, I heard this from the other person that this happened, and then the bill calls for a preponderance of the evidence, and you've got people that aren't trained in the law that are going to get this information. They don't know what's admissible and what's not. They have no guidelines to follow. So I think this is a really common sense amendment. At the very least, we should have rules of evidence so that it's a fair process for all involved, so that everybody knows what can be included in evidence, what can't be included, what's admissible and what's not. And I think that's the very minimal that we can do. Any court case you go to, if you go to a trial and through a district court process or through the ALJ, there would be a process for the rules of evidence, and that's all I'm asking for in this amendment. And Mr. Speaker, I'd ask for a roll call.
Roll call has been requested. Seeing 15 hands, there will be a roll call. Representative Carlson.
Mr. Speaker, it's not the role of the legislature to micromanage. This should be done through the rulemaking process. But would Representative Pepin yield to a question?
She will yield. Representative Carlson.
Representative Pepin, what does substantially conform mean?
Representative Pepin.
Thank you, Mr. Speaker and Representative Carlson. I would say it means getting as close as possible to the rules, and I don't know if you had a chance to read the chapter. I think it's 1400.7000. That lays out very clear rules of evidence that talk about hearsay, relevant evidence, and what can be admissible in court. And so I would like it to be, it doesn't have to be word for word, but I would like it to be substantially similar. And as far as it's not our role, the problem is it's a court's role to come up with the rules of a court proceeding. But there's no court here. You have people that aren't trained in the law, no judges, no lawyers, no one with any mediation services, no one with any knowledge of the law, and we're coming up with a rulemaking process. Right, okay. They don't have the first clue about the rules of evidence, and that's what's troubling to me. Maybe this is not the legislature's rule, but it certainly is the rule of a court of law, the responsibility of a court of law to come up with the rules of evidence. And for that reason, again, members, I ask you to support this amendment.
Mr. Speaker,
Representative Carlson.
The reason I asked that question, on the face of it, I was initially open to perhaps accepting this amendment, but now as I listen to the discussion, I think this is something that needs further discussion as the bill would move along, and so at this point in time I would encourage a no vote.
Seeing no further discussion, the clerk will take the roll on the amendment. The clerk will close the roll. There being 59 ayes and 73 nays, the motion does not prevail. The amendment is not adopted. There's another amendment at the desk. The clerk will report the amendment.
Holberg moving to amend House File 3014, the second engrossment as follows. The amendment is coded 215.
Representative Holberg.
Thank you, Mr. Speaker, members, and I'd like to request a roll call vote.
Roll call being requested. There are 15 hands. There will be a roll call.
Thank you, Mr. Speaker and members. This is pretty simple. It just makes sure that people that provide gifts to the Bureau of Mediation Services or employees of those that do gifts or grants of or are officers of an organization that provides gifts, grants, or bequests, that they cannot be members of this board. It's certainly would be a conflict of interest, and we as public policy makers should at least set this low bar in law. And I'd appreciate your support.
Representative Carlson.
Mr. Speaker, members, I would encourage a no vote. It's already a given that if a party petitions the court, it must pay its own costs and attorney fees, so I don't think this language is necessary.
Representative Holberg.
Well, Mr. Speaker and members, just a couple of days ago we had an amendment of mine that got divided, and in the Bureau of Mediation, my amendment would have made sure that the gifts and items that were donated would only be used for the conflict resolution functions of this department. That amendment was divided, and so the division, if you will, of grants and gifts going into this department was not taken care of because the first part of that amendment was defeated by the majority. So we now have a situation where this body has said that grants to this organization are not contained within the use of the conflict resolution portion of this agency or organization, and now we are going to have this particular function under their umbrella as well. And it's important that we not have a situation where individuals are donating to the Bureau of Mediation and then serving as judges in this labor process. So I think you could go a lot farther in making sure you didn't have conflicts of interest. This is pretty basic and would appreciate your support.
Any further discussion? Representative Carlson.
Mr. Speaker, listening to the discussion and being that it's already given, I guess your amendment is a bit redundant, but I don't think it in the end does any harm to accept it. Thank you.
Any further discussion? All those, there's a roll call, so the clerk will take the roll on the amendment. Okay. The clerk will close the roll. Hillstrom votes aye. There being 122 ayes and 10 nays, the motion prevails. The amendment is adopted. There's another amendment at the desk. The clerk will will report the amendment.
McDonald moving to amend House File 3014, the second engrossment as follows. The amendment is coded 825.
Representative McDonald.
Mr. Speaker, my amendment is fairly simple. I suppose you heard that often today. What it does is it takes the party petitioning the district court for enforcement must pay the attorney fees. It gives the ability for the petitioner to petition the court, not the board. I think that's important to look out for the taxpayers' dollars, and that the fee should be paid for by the petitioner. Just looking out for local interest, being a former mayor and involved in my city, I hope that Representative Carlson, you'll accept this as a friendly amendment to your bill.
Representative Carlson.
Mr. Speaker, I would encourage a no vote on the amendment.
Representative McDonald.
Yeah, would Representative Carlson yield for a question?
He will. Representative McDonald.
Representative Carlson, just curious as to why you wouldn't want to protect the taxpayers if the petitioner has the authority to petition under my amendment. he too should pay for the cost of it, not let the taxpayers foot the bill. Just curious as to why you wouldn't think that's a good idea, that the petitioner pays and not the taxpayers in the local jurisdictions.
Representative Carlson.
Mr. Speaker, as I mentioned in an earlier discussion, that's already a given that you pay for your own attorney's fees, so I would encourage a no vote.
Representative MacDonald.
Thank you, Mr. Speaker. Sorry to disagree with you. You're a wise young man, but your bill does not state that. The cost would be to the taxpayers, not the petitioner, so it's not repetitive or duplicative. My amendment certainly allows for the taxpayers not to foot the bill. So in looking at your bill and have an expert opinion, that is not what it does. So I would encourage a green vote if you want to protect the taxpayers' dollars, that those who petition should pay for it, not the taxpayers. Should I call? I'll call for a roll call, Mr. Speaker.
Okay, seeing 15 hands, there will be a roll call. Seeing no further discussion, the clerk will take the roll on the amendment. Yeah, good. Thank you. The clerk will close the roll. There being 61 ayes and 69 nays, the motion does not prevail. The amendment is not adopted. There is another amendment at the desk. The clerk will report the amendment.
Pepin moving to amend House File 3014, a second engrossment, as follows. The amendment is coded A27.
Representative Pepin.
Thank you, Mr. Speaker and members. My amendment goes back to what the current statute and says that public employers, their agents and representatives are prohibited from violating or refusing to comply with any lawful order or decision issued by the Commissioner. That's all it does, and I would ask for a green vote, and Mr. Speaker, I would like a roll call.
Roll call being requested. Seeing 15 hands, there will be a roll call. Discussion. Representative Nelson.
I encourage a red vote on this. This amendment removes the provision that makes violating the board order, which is what they're trying to do, is to deal with these unfair labor practices at the board level. That's why we're creating this board. It makes violating these board orders an unfair labor practice. It already is an unfair labor practice to violate a commissioner's orders. And so we don't need this amendment. What the bill is trying to do is create this board so we can quicken the process. We can move it down to the level where we can get it done without having to go to court. This will increase court costs for our employers, our government tax-paid employers, and it'll cost our taxpayers more money.
Any further discussion? Seeing none, the clerk will take the roll on the amendment. The clerk will close the roll. There being 60 ayes and 72 nays, the motion does not prevail. The amendment is not adopted. There's another amendment at the desk. The clerk will report the amendment.
Beard moving to amend House File 3014, the second engrossment, as follows. The amendment is coded 216.
Representative Beard.
Mr. Speaker, thank you. And Mr. Speaker, I'd like to ask for a roll call on this simple amendment.
Roll call has been requested. Seeing 15 hands, there will be a roll call. Representative Beard.
Thank you, Mr. Speaker and members, and Representative Carlson. There is within the judicial appointments process in Minnesota something called the Merit Selection Commission. It consists of about 49 members appointed jointly between the Governor's Office, Supreme Court, ostensibly to qualify judicial candidates who might be appointed by the governor whenever there are openings that appear. This has served the judiciary well, Representative Carlson and members, in that it actually kind of pre-vets or pre-qualifies the candidates and gives the governor a little bit of an arm's length distance from the transaction. And I thought that if we took your bill and applied to this Merit Selection Commission process, which already exists, to this, which is a quasi-judicial function, it appears from your bill, that this might make your bill even better. So with that, Mr. Speaker and members, I'd urge a green vote. Thank you.
Representative Carlson.
Yes, Representative Beard, first of all, thank you. You're the only member that gave me a heads up on this particular one. I appreciate that. That hasn't been what's happened this afternoon. But I will have to encourage a no vote. The Merit Selection Commission is for state court judges. This will be an administrative board, and it's not even necessarily made up of attorneys. And the board members will not be full-time. They will receive a per diem of $50 per day plus expenses. So it's quite a different type of board from a judicial appointment. But I do, again, want to say thank you for the heads up, and I would encourage a no vote.
Any further discussion to the amendment? Seeing none, the clerk will take the roll on the amendment. The clerk will close the roll. There being 60 ayes and 72 nays, the motion has not prevailed. The amendment is not adopted. There's another amendment at the desk. The clerk will report the amendment.
Leidinger moving to amend House File 3014 to second engrossment as follows. The amendment is coded DE1.
Representative Leidinger.
Thank you, Mr. Speaker. Well, here it is. This is a delete everything amendment. And what it says is Commissioner of Mediation Services Authority. The Commissioner of Mediation Services may investigate charges of unfair labor practices under this chapter, and if the Commissioner determines that a party has engaged in unfair labor practices, may issue a corrective order. Here it is. What it does is it replaces the Democrats' 14-page bill. The Democrats are trying to establish a whole new way of doing business in labor practices, in public employment relations, by establishing a public relations board. And not only are they establishing this very powerful, super partisan board, but they're giving it superpowers. The superpowers can come in and in 5 days can get you to submit. In 5 days. And you must respond. It has numerous powers. Cease and desist. It can order damages. It doesn't have to adhere to any kind of normal rules of evidence. And early on, as we were talking about this bill, we were talking about the concerted activity. The answers that we got as we were asking these questions was, well, PELRA covers that. PELRA covers that. That's right, PELRA has been around for a long time and has been working for a long time. And the Commissioner of Mediation Services has been around for a long time, and we funded them quite well. And they've been trained. They're exacting in their purpose and what they do. Training, of course, nothing happens well without training. The United States military, that's all they do, all the time. That's why we're the best in the world. So we've had PELRA, we have the Commissioner of Mediation Services. It's what has been done. They're funded, they're well trained, we know how it works. And then all of a sudden now, the Democrats are trying to create a whole new animal here, a whole new thing. A whole new board, totally partisan, controlled by one person. It's already been established. The governor, he's got complete control, sets it up. And that board, they have their own rule-making authority. Do we do that elsewhere? I'm actually unsure, but I don't think so. We establish a board, and the board itself does its own rule-making. So who knows how whether they're going to get hyper powers? We don't know. So here's a brand new thing, and of course it's reminiscent of what was happening last year. We set up MNsure. Holy smokes, did we ever realize that we were going to get such a boondoggle? Well, here it is again. Democrats are now trying to set up this commission, this board with all these powers to go and handle something that has been handled by our mediation services. Now, for the last 3 hours, the Republicans have been offering, I don't know how many it's been, 30? It's been at least 30 amendments, trying to correct it, trying to work with the Democrats to make the bill seemingly work. And I called out a couple of amendments which I thought were excellent. You think about Representative Albright's bill and a few others amendments that really tried to at least do something with that board so it wasn't so partisan. But no, the Democrats didn't take those amendments. For the last 3 or 4 hours we've been trying to work with you and make it a better bill. Well, it didn't happen. You're very hard over with ensuring you put up this partisan board, totally untrained, with superpowers. Giving them their own ability to do their own rulemaking. Well, I do have one more question. Representative Carlson will.
He will yield. Representative Leidiger.
The last thing, and then I'll. Oh, by the way, before I ask the question, I want to ask for a roll call, please.
A roll call has been requested. Seeing 15 hands, there will be a roll call. Representative Leidiger.
Representative Carlson, you're handling this bill. You're highly respected. They put their best person forward with this bill. I certainly respect you. But this is a bad bill. This is very bad. It's setting up something that we don't need, and I'm very worried about it. But the question is, how is this board supposed to be paid for going forward?
Representative Carlson.
Mr. Speaker, members, the bill has $125,000 in it for the rulemaking authority, and the next biennium they will come forward with their budget request. The experience in other states has been that it's a very small complement. What we're looking at is probably a number each year, the next biennium, similar to the 125, but that would be a part of the formal budgetary request next biennium.
Representative Leidiger.
Thank you, Mr. Speaker. Thank you, Representative Carlson. But it's more money. It's more money that we're, putting into this brand new organization, and we don't really know. I mean, I know the initial amount that we're putting in, but because of the board and the way it's set up and the way I think it's very partisan,
we may be needing a lot more money in the future. I'm unsure. We're unsure. Just like Minsure. Well, members, here's a chance to just let's stop. Let's stop with trying to fix this. It's not, the Democrats have not taken any of our recommendations, and here it is, a very simple D amendment. I recommend a green vote. And Mr. Speaker, I'd like to retract the roll call.
The roll call has been withdrawn. Any further discussion? Representative Carlson.
Mr. Speaker, very quickly, I would encourage a no vote, and let me give you 2 or 3 reasons, and I think there probably will be a lot of consensus on the no vote. If this amendment were to pass, it would no longer provide for a hearing. It would take away the parties' rights to be heard, and no other state agency fails to provide for a hearing process. So it takes away the right to a hearing that the parties have now, even though it is in a court. So I would view the amendment truly as a major step backwards, and would encourage a no vote.
Any further discussion? All those in favor of the amendment say aye. All those opposed, no. The motion does not prevail. The amendment is not adopted. Division has been called for. So those voting aye, please stand up. All the nays, please rise. There being 48 ayes and 71 nays, the motion does not prevail. The amendment is not adopted. There's another amendment at the desk. The clerk will report the amendment.
Quam moving to amend House File 3014, the second engrossment as follows. The amendment is coded DE2.
Representative Quam.
Thank you, Mr. Speaker and members. Well, we've tried to improve this, and frankly, I understand, some of the concerns with the past DE. This one is acknowledging that this isn't ready for prime time. It doesn't have a lot of details. That it's probably not prudent to sort of say, we'll pass it, let them come up with some rules, and then we'll see how it works. As to the cost, we're really not sure what the cost is. We're actually probably violating the tails, which I thought maybe the Ways and Means Chair would object to an ambiguous tails Well, frankly, we've got a single source of appointments through the governor. We've got rulemaking authority given to a group that does not have defined qualifications. We have, subpoena power. We've got a lack of normal evidentiary rules for evidence and process. And if we don't have that, how can we give the board the power to make statements of fact? If you don't have the capability of judicial controls and rules for evidence, how can you base a statement of fact on something that you can't say is judicial quality evidence? I think that's a definite problem. But again, the board doesn't have a requirement for any legal expertise, but they have judiciary executive powers for doing orders. They're basically adjudicating these decisions, and I've got concerns there. It was stated by the author, develop some expertise in labor law. Frankly, I'd prefer, if we're going to create a new branch, a new agency, a new board, give it all this power, they actually start out with a little bit of knowledge and expertise on labor law. But apparently that's not a priority in this bill. Frankly, this bill is a lot of chalk dust. And yes, I use that in front of people involved with schools, and they say, well, we don't have chalk in schools anymore, but I think you'll remember what it meant. It meant that you didn't write up on the board your proof, your facts, your information. You just left that to the imagination. And when we're doing the business of the citizens of this state, when we are growing government with a new board, and we don't have it well defined, I don't think we're doing the appropriate job that we're sent up here to do. And frankly, even though some of the amendments were taken, I find a lot of the activities that could be acknowledged in here is disconcerting activities. So what this amendment does is it asks for a study. And frankly, I'd like to have a little more understanding of what we're going to do and a little more thought and forethought put into this activity. An unsessioned bill that expands government by creating a new body with great powers, I think is not trivial. And the other thing that causes a little bit of pause is I would not be surprised if this is only supported by one side of the aisle. We've seen in the past, when we've gone forward without bipartisan support in creating new entities or expanding the scope and range of taxation, what happens? And frankly, I would think that it would be prudent on your side to accept that you need to have a little coverage by having something that would be bipartisanly supported. So that's why I'm bringing forth this amendment, to give a little pause, to allow us to take a breath, try and work together across the aisle to come to a solution. And that's why we were sent here. So I ask that you would please vote in support of this amendment. Thank you.
Representative Carlson.
Mr. Speaker, as Representative Quam pointed out, his amendment would create a study, and I can point out that there have been countless discussions and the look at what's happening in the 30-plus other states that have an administrative process, which is what we're attempting to do here. So I don't really think that there's a need, and I've had 2 meetings with MMB, and MMB has done their own analysis of the bill, and we'll have an amendment coming up later with their suggestions to improve the bill. So it's been looked at extensively in a variety of quarters, and I've had several meetings with people who have looked at this issue very carefully. And I would remind members that the bill did go through 5 committees in the Minnesota House, not this House file. There were other bills that were identical to it, however, that were heard in 5 separate committees. So with that, I would encourage a no vote.
Seeing no further discussion, all those in favor of the amendment say aye. Aye. All opposed, no. No. The motion does not prevail. The amendment is not adopted. There's another amendment at the desk. The clerk will report the amendment.
Carlson moving to amend House File 3014, the second engrossment, as follows. The amendment is coded 828.
Representative Carlson.
Mr. Speaker, members, this is an amendment that does adjust some of the dates in the bill, and these changes were recommended by Mark Shepard, who's in our nonpartisan House Research Department, and so we should adopt these date changes. Thank you.
There is an amendment to the amendment. The clerk will report the amendment.
Carlson moving to amend this amendment 3014 as follows. The amendment is coded A30.
Representative Carlson.
Mr. Speaker, members, this amendment is the one that I've alluded to several times during our discussion of the bill. These are language changes recommended by MMB, and what it essentially does is it clarifies the standards for dismissing frivolous complaints. It deletes the possibility of treble damages to a prevailing party, and it deletes a reference to differing to an outside arbitrator or grievance process. And so these were recommendations that they made, and the other proponents of the bill were acceptant of those recommendations as well. So this does come from the management side, and would appreciate your support.
Any discussion to the amendment? Seeing none, all those in favor of the amendment say aye. All opposed, no. The motion prevails. The amendment is adopted. There is another... Right. There's another amendment.
No. Oh, okay.
Yeah. There's another amendment to the amendment.
Peppin moving to amend the Carlson amendment as follows. The amendment is coded 220.
Representative Peppin, I think this is an identical to an amendment that you offered previously.
Thank you, Mr. Speaker. Yes, I think I'll withdraw the amendment.
Representative Peppin withdraws her amendment. There's another amendment to the amendment. The clerk will report the amendment.
Anderson S. moving to amend the Carlson amendment to House File 3014 as follows. The amendment is coded A29.
Representative Anderson.
Mr. Speaker, this is the same amendment that was offered earlier, as I understand it, so I'm going to withdraw it, okay?
Representative Anderson withdraws her amendment. There's another amendment to the amendment. The clerk will report the amendment.
Quam moving to amend the Carlson amendment, House File 3014, the second engrossment as follows. The amendment is coded 228.
Representative Quam.
Thank you, Mr. Speaker. And I'm trying to remember if this was passed and accepted.
It was not, Representative Quam.
It was not. Then, actually, I will withdraw this amendment.
Representative Quam withdraws his amendment. There is another amendment to the amendment at the desk. The clerk will report the amendment.
Quam moving to amend the Carlson amendment to House File 3014 as follows. The amendment is coded 229.
Representative Quam.
Thank you, Mr. Speaker. And this one I don't believe is a duplicate, and it does cover something new. So basically, I don't want to have unlawful picketing or unlawful boycott to be part of this bill. So I'd ask for support of this amendment.
Representative Carlson.
Mr. Speaker and members, this kind of falls in that same category of bills at the very beginning where they were redundant in terms of what's in current law. PELRA already prohibits unlawful picketing and unlawful boycotts. PELRA classifies unlawful picketing and unlawful boycotts as unfair labor practices. So this amendment, Representative Quam, under current law is truly not needed. It's redundant. If you want to press it, I guess I can accept it like I did some of the earlier ones, but it's in that category. I guess I just leave it up to the body. It's already law.
Any further discussion? Seeing none, all those in favor of the amendment say aye. All opposed, no. Motion does not prevail. The amendment's not adopted. There's another amendment to the amendment at the desk. The clerk will report the amendment.
Howells moves to amend the Carlson amendment to House File 3014 as follows. The amendment is coded 231.
Representative Howe.
Thank you, Mr. Speaker. And members, this amendment actually goes to what Representative Nelson brought up earlier. It's the Veterans Hearing Bill. And what this does is it allows the veteran a choice between a civil service commission or a three-member panel. It also dictates who pays what as far as the cost of the hearing and the veteran's attorney's fees. The reason this was brought forward was because we had an event where a veteran had come back, been given his notice to discharge. He filed for his right to a veteran's hearing. He was given his veteran's hearing with the board. He was reinstated to his job. And the government employer turned around and sued him for $64,000 for the cost of the hearing. The current system is a little broke. This just puts it in law who pays what, and it also identifies that the veteran gets a choice. Members, I urge you to support the amendment.
Representative Carlson.
Mr. Speaker, members, rise to a point of order. 3.21 motions and propositions must be germane. This goes to Chapter 197. And in addition to that, Representative Howe's bill, House File 2117, is on the General Register and will be voted on in a few days. So it's not germane to this bill, but your bill will be coming up later.
Representative Howe, what purpose do you rise?
Point of advice.
And state your advice.
Well, Mr. Speaker, this bill that we're looking at today works with public employment and boards. That's exactly what this bill does. It deals with public employment and boards. And I understand that this bill is coming up in front of the body, but I take this advice from Representative Kahn. You slide it in as many times as you can, wherever you can. So I hope you find the point of order out of order, Mr. Speaker.
Well, having reviewed the rules and the amendment and the bill as amended, I find that the point of order is well taken. We're on the Carlson amendment. Any further discussion on the Carlson amendment? Seeing none, all in favor of the Carlson amendment say aye. Aye. All opposed, no. No. The motion prevails. The amendment is adopted. There's no further amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File 3014 as amended.
Third reading. Any further discussion to the bill? Representative Erickson.
Thank you, Mr. Speaker. And would Representative Carlson yield to a question?
He will yield. Representative Erickson.
Thank you, Mr. Speaker. Representative Carlson, for this creation of your House File 3014, was there an increase of labor relations complaints so that you felt necessary to move to this new process?
Representative Carlson.
Mr. Speaker, Representative Erickson, no. Past few years, the number of filings have been relatively constant, and that there were a relatively small number. But the point that I want to make is that it's not the number of complaints, it's the cost and how long it takes to get them resolved. That's the reason that the bill is here. I've got the number of complaints going back 10 years. There were 89 complaints over a 10-year period that ended up in the courts. But again, that's very expensive on average, roughly $60,000 to $70,000. I think one went as high as $200,000 that I mentioned earlier. And those numbers that I'm sharing are, that's a cost to both the employer and the employee. So much more expensive than what those numbers might indicate. But in addition to that, we want to have those kinds of complaints resolved in a timely manner, and that's what this bill does. It brings about more efficiency.
Representative Erickson.
Thank you, Mr. Speaker. And will Representative Carlson continue to yield?
He will. Representative Erickson.
Representative Carlson, the change for charitable hospitals. How many charitable hospitals are there? And how does it work when the employer is public and the employee is public? How will that process work? Because Representative Faust and I have a public hospital in Kanabec County, and I know there are others across the state. So how many are there, and how does the process work when it's public versus public?
Representative Carlson.
Mr. Speaker, this bill covers only the public hospitals. The term charitable hospitals is perhaps somewhat confusing. We did in committee have one of the testifiers listed off several public hospitals. They're small, rural hospitals by and large, or I think probably in total already included under Pell are the larger metropolitan ones like Hennepin County and so on. So these are small hospitals, but all publicly owned. They're all public employees. If it's a private hospital or a for-profit, and I'm told we have just one for-profit in Minnesota, they would not be governed by this particular bill.
Representative Erickson.
Thank you, Mr. Speaker. And Representative Carlson, will he yield again?
He will. Representative Erickson.
So thank you, Mr. Speaker. Representative Carlson, so the veterans hospitals, and we have one in St. Cloud and we have one in Minneapolis, and then the hospitals that are located on tribal land, are they not part of this agreement or this proposal you're bringing forth?
Representative Carlson.
Mr. Speaker, the Veterans Hospital, and I can check on that further, I would assume that they would be under perhaps federal law, but if they are under PELRA, it is a public entity, so they would be included either under federal law or perhaps PELRA, but I would have to investigate. With all the hearings we had, there was no reference to the Veterans Hospital, so I did research that.
Representative Erickson.
Thank you, Mr. Speaker. Well, my main concern with this proposal is I don't think this is very well put together. I think there are some loopholes in this language, and I know I have the greatest respect for Mark Shepard, who I'm sure helped put this together. But there are some grave concerns here on rulemaking, for example. Are we setting a precedent, members, for rulemaking when this is a board that doesn't license? Furthermore, there are, as I've listened to the discussion here, loopholes, and these are small. On the charitable hospital side, these are small hospitals. Representative Faust and I have one in Kanabec County. And now they're going to be, maybe they've been part of this process, but they will fall under, at least the complaints will, from employee to employer, under this proposal. And this board will make decisions, and I'm not sure that this language assures us that this is going to be really what's considered a fair practice. So members, I would support a no vote on this proposal.
Representative Skowski.
Thank you, Mr. Speaker and members. I think we've articulated a lot of concerns with this union building bill, but we don't have to look any further than what's going on with one of the states that Representative Carlson talked about. He said other states have these public employment relations boards. One such is the state of California, where now a taxpayer group is writing about how the powerful Public Employer Relations Board in California is actually going out to sue two communities that had landmark pension reforms happen in their communities in San Diego and in San Jose, I believe was the other community, San Jose and San Diego. And we've got, in that case, an activist PERB, if you go with the PERB acronym here, that we're going to have a brand new acronym with a brand new piece of government that is being built by the majority. They are actually using their lawyer positions there to interfere with cities that have put forward pension reform in those cities out of necessity in order to operate within their municipalities. So that is what we are building here, members. And Minnesota is seeing the Democrat union payback bill, one of many that are coming through the legislature here. They are hoping, the majority is, that this board can become an activist one like the California one does, where there's 57 positions, Representative Carlson. I understand that California is much larger than the state of Minnesota, 7 times larger, but 57 positions out there for this board. So in Minnesota next year, we can expect a board near you in the state of Minnesota to be looking for 8 positions, 8 FTEs, if we extrapolate that number, and $8.7 million in California extrapolated here to Minnesota. You're looking at about $1 million or $1.5 million a biennium in order to budget or fund this union supercharge board that we're looking at here. And members, Minnesotans, Mr. Speaker, please vote against this bill that is designed only to build within the walls of state government more influence for the unions to further build our government beyond the size that it is here today. Thank you, Mr. Speaker.
Representative O'Driscoll.
Thank you, Mr. Speaker. I was wondering if Representative Nelson could yield to a question, please.
Representative Nelson will yield. Representative O'Driscoll.
Thank you, Mr. Speaker. Representative Nelson, you and I have had an awful lot of opportunities to talk about different policy and procedure things, and I do actually hold you as one who's a member in the government operations to help us to vet out some of these kinds of questions. As I was reviewing the bill again this afternoon, I have a question. In your experiences, have you ever seen or have heard of or have seen need for immediate judicial relief, injunctive relief because of unfair practices, either on management or labor side?
Representative Nelson.
Thank you, Mr. Speaker. And Representative O'Driscoll, yes, there are cases where something would be so egregious on either side that the facts would stand up and say, yes, that they need immediate relief. And so that's why that's in the bill. But it could be from an employee doing something egregious and that the management is filing the unfair labor practice. So it could be the government employer that's filing the unfair labor practice, and they would get the immediate relief.
Representative O'Driscoll.
Thank you, Mr. Speaker. Would Representative Nelson yield to another question, please?
He will. Representative O'Driscoll.
Thank you, Mr. Speaker. Representative Nelson, as I read the bill, the area that deals with the unfair labor practices does strike the judicial relief provision and says that if there's going to be any kind of relief, and I will go to the final part of this on lines 9.4 and 9.5, it says must file an unfair labor practices charge with the board, and does remove that. In your experience, does that become problematic if this provision became law?
Representative Nelson.
No.
Representative O'Driscoll.
Well, members, what I thought I just heard Representative Nelson say is that immediate judicial relief that's being struck from this bill right now is not problematic for management or for labor, that we'd simply be filing with the board to have a hearing on this. Mr. Speaker, would Representative Carlson yield to a question?
He will. Representative O'Driscoll.
Thank you, Mr. Speaker. Representative Carlson, is it your intention that the individuals who would be needing to seek, whether they're management or labor, immediate judicial relief to be struck from the bill and have those be sent to the board instead? Mr. Speaker, it's getting a little noisy here as well.
Representative Carlson.
For the very reason that he just asked about the noise, I didn't quite hear the question.
Representative O'Driscoll.
Thank you, Mr. Speaker. Representative Carlson, in the bill on pages 8.31 through 9.5, language is struck to allow for judicial relief by an individual, whether they be management or labor. And it says that simply now going forward, one would have to file an unfair labor practices charge with the board. My question is, do you see a need anymore for immediate judicial relief for either management or labor going forward?
Representative Carlson.
Mr. Speaker, the intent of the bill is to have administrative relief. However, if one side or the other, after the board ruled on an unfair labor practice, chose to appeal that ruling, then it could go to the courts. But the main thrust of this bill is administrative relief for the reasons that I cited earlier.
Representative O'Driscoll.
Thank you, Mr. Speaker. Representative Carlson, would you yield to another question, please?
He will yield. Representative O'Driscoll.
Thank you, Mr. Speaker. One of the things that I find kind of interesting in here, and I'll give you a scenario where immediate judicial and injunctive relief might be needed. Let's assume for a moment that there was a campaign within a government entity to provide for unionization, and management came out and said, you know, take those signs down, we're going to step on your rights to organize. Or there is already organized labor in place and there was going to be a wildcat strike or an unauthorized strike. Members, I have no idea by looking at this bill how long those labor rights would be trampled, nor do I know how long the government entity would be without the services of people who would choose for a wildcat strike, because it doesn't tell me, other than the fact that I have to file with the board and then I have to wait for the board to make a decision. Now, my assumption is that the board is not going to be at the ready like a judge would be to be able to be summoned to seek judicial relief, that we'd have to file a complaint. We'd have to bring the members together, potentially, as we heard earlier today as well, that there would be a potential conflict of interest, so we'd have to find the alternate to sit on the board, have the hearing, the board would have to then render a decision, and I have no idea if that can be done within a 12 to 24-hour period of time to protect labor and or management's rights on here. And I was wondering if maybe Representative Carlson could shed some light on the process for the body today.
Representative Carlson.
Well, Mr. Speaker, members, that's why when we had the discussion earlier, not for that particular scenario, but we do have a very tight timeline for the resolution of these issues. When you start talking about wildcat strike and that kind of thing, I suspect that that board could be convened very quickly if need be. But the idea that we had a very tight timeline that we discussed, I think it was, well, I don't even remember which member, there's been so many amendments, but that's why we have a tight timeline. So if you do have crisis situations or you need resolution very quickly, we have a tight timeline, but not so tight that both sides don't have a chance to present their arguments.
Representative O'Driscoll.
Thank you, Mr. Speaker. Representative Carlson, would you yield to another question, please?
He will yield. Representative O'Driscoll.
Thank you, Mr. Speaker. Representative Carlson, you've used the words a compressed time, and I might be paraphrasing that, or a shortened period of time on this. Could you explain to me how this might work over a long holiday weekend, and we have situations where management may be trampling on the rights to organize and or labor may be doing a walkout, and we don't have the ability to get it in front of the PERB board to be able to get the complaint heard?
Representative Carlson.
Mr. Speaker, we have a range of days in the bill, 5 to 20.
Representative O'Driscoll.
Well, thank you, Mr. Speaker. Members, you just heard 5 to some 20 days. And we had heard earlier today that this could be a situation which could be at a public nursing home or it could be at a public hospital. And we would not be having the staffing potentially on this, where, again, seeking judicial relief is an important part of the process. Mr. Speaker, I do have, well, at this point, I guess I would ask Representative Carlson to respond to the 5 to 20 day time period, if he feels that that would be adequate to have the situations I've outlined earlier in play.
Representative Carlson will yield. Representative Carlson.
Mr. Speaker, I apologize. I should have remembered this particular provision, but you kind of surprised me with the question, but that's fine. If you look on page 11, lines 11, 13, 11, 14, nothing in this paragraph precludes a charging party from seeking injunctive relief in district court after filing the unfair labor practice charge. So they would still have that option available according to the language in the bill.
Representative O'Driscoll.
Thank you, Mr. Speaker. Representative Carlson, would you yield to a question, please?
He will yield. Representative O'Driscoll.
Well, thank you, Mr. Speaker. And Representative Carlson, I was reading those provisions as well, and that's why I wanted to go down the previous line of questioning, because I'm not exactly sure how on a holiday weekend one's going to be able to file this paperwork with the board so that they might be able to seek injunctive relief, or does it have to be recognized and accepted by the board, or does the board have to grant the court's permission to seek that injunctive relief? Perhaps you could enlighten the body on the spirit legislative intent on this.
Representative Carlson will yield. Representative Carlson.
Mr. Speaker, members, it's a little difficult to respond to these what-if situations. I suspect if that did happen on a holiday weekend, there are ways to resolve that. So I think it's an issue that maybe is a bit of a far-fetched situation. It would probably be a pretty remote situation that might happen. Although theoretically, I suspect it could, but I think they would be able to get resolution.
Representative O'Driscoll.
Well, thank you, Mr. Speaker. I'll give you a real-world example of this, Representative Carlson. If a contract were to expire on December 31st, we know that the 1st is a holiday, which could be backed up against a Saturday and Sunday, which could be a prolonged period of time that business might not be able to be done. And again, as I said, we may have a situation where labor is being trampled on by management, or management is not able to get labor to keep their end of the agreement, and we do have a walkout or some other kind of a situation. So I do believe that there is the potential for some very real things to happen here. Since the board is not on call, the board does not have any provisions to have people on standby to seek injunctive relief as you would within the court system. To the provision as well that says precluding a filing with the of the unfair labor practice with the board, that must preclude seeking injunction and judicial relief according to the language of the bill. So I think what we're doing is we're creating some more complexities in the bill, and we've got some problems that we need to work out. And this bill probably is going to create more problems for us on a go-forward basis than it solves. I sure hope that we have people continuing to bargain in good faith and to keep their end of the deal, because I don't think that the law is going to help them under the changes that have been put forth in this bill. Thank you, Mr. Speaker.
Any further discussion? Representative Pepin.
Thank you, Mr. Speaker and members. Well, I know I've talked quite a bit on this issue, but I think it's something that we really need to pay attention to. And I just want to give a recap of my view of what this bill looks like to me. This board is a partisan board of 3 members, all appointed by the governor. There are absolutely no requirements whatsoever that anyone on this board have any legal training whatsoever. They don't have to be a lawyer. They don't have to be a judge. They don't have to have any mediation training. They don't have to be on the board of qualified neutrals. Nothing. They're put on the board by the governor, the partisan governor, and he can put whoever he wants on the board. There's very little, there's nothing that says anything about what the requirements are, nothing about that. There's some kind of language that supposedly talks about conflict of interest, but it's a very shallow discussion there because the whole board is a conflict. There's discussion in this bill about the procedure that's done by this board of people that have no skills or training in the law. There's no discussion about how they will be served, how a party will be served. There's no discussion about what the rules of procedure are. There's no discussion on what the rules of evidence will be used. They're supposedly going to go through some rulemaking process, even though they have no training in the law, mind you, when we already have a process in place. I hope members have had a chance to look at 1400 starting .550. There's several subparts on how to issue a service, how to notify someone that there will be a hearing. It's very detailed. I'm looking at this is the ALJ, so this is a more relaxed procedure than it would be if you were to go to a district court. You have to have a certification of service must be made by the person making the service. A certification of service must bear the name of the person certifying the service has been made. Service by mail or licensed overnight express mail service is effective upon placing the item to be served in the mail or delivering it to the authorized agent. Personal service may be accomplished by either delivering the document to the person or by leaving the document in the person's home or place of business with someone of suitable age and discretion who resides in the same house or is located in the same business address as the person to be served. These are important, members, because there's nothing in this bill that describes what would happen if a party were served but the party were gone for the week, or what happens if the party were served by the babysitter, or what happens if the party isn't actually served at all. It's just maybe thrown under the door and the person doesn't know that it's there because they're out of town. There's nothing in the bill that addresses that. Whereas in any other court, it would have very specified rules for this. And the process that we currently have already has specified rules for this. This is no joke. People could be hauled in without having any notice whatsoever that they're being hauled in. Not only that, and just in the ALJ, and never mind, again, this is more relaxed than a process if you'd go to the district court. There are 16 points on contents of notice and order. In other words, what's required to be included. The time, date, and place for the hearing or pre-hearing conference has to be included. The name, address, and telephone number of the judge has to be included. A citation of the agency's statutory authority to hold the hearing has to be included. Goes on and on. A brief description of the procedure to be followed during the hearing. A statement of advising the parties to bring to the hearing all documents, records, and witnesses need to support their position. None of this is required in this bill. There's absolutely no information on the procedures that are required. They're going to do this apparently through rulemaking, even though they actually have no training. There's no requirement that they have any training in the law. So we have this partisan board, nobody having any training. There's no information on what rules of evidence they're going to use. It's not clear. The evidence, I didn't talk about that yet. The evidence, not sure, Representative Carlson, if hearsay, double hearsay, triple hearsay is going to be allowed in. Not sure if I were to say, well, I heard that Representative Carlson was using unfair labor practices. Oh, well, that's a preponderance of the evidence. Let's charge it. Let's fine him. Not sure if relevant evidence only is to be included, because it doesn't say. And the sham of it is that we already have a process in place that works well, that was developed in the 70s. It works perfectly well. Again, in the administrative law procedure, you would have 30 days after receiving a notice, and the notice requirements that make sure that the party actually gets the notice. Here we don't know if the person gets notice, and then when they do get the notice, even if they don't, they only have 5 days. And in that 5 days, the complaint can be amended. And there is absolutely nothing that allows any additional time by the party to whom it's served to file an answer. That would not be acceptable under any of our court proceedings. To not have time to answer an amended complaint? Really? 5 days? 5 days, members. I know you lawyers have to be looking at this. I cannot believe you'd find this acceptable. So, You know, and the interesting thing is that once they make this, one of the arguments was this is going to be a big cost savings. You know, never mind that there's a big appropriation in here. But the thing is, they can't offer sanctions anyway. They have no authority to enforce this. So it's going to have to go to the district court anyway if it's challenged. And I think there are going to be a lot of challenges because I think that there are a lot of rights that are infringed upon here because we're not using the process that's already been established. Because the biggest point I want to make of all in this is that everyone has a right to a neutral decision maker. Everyone has a right to be heard by someone who does not have an interest. And I cannot believe the people that mentioned, well, we need to make sure that labor is represented. They're making decisions. They have the ability to send cease and desist letters. They have adjudicative authority. They have the ability to collect back pay and to charge compensatory damages. People have a right to a neutral decision maker, not that the lawyers don't get to decide in a case, that the prosecution and defense, that's what the judge does. That's what this thing is missing. And why we'd want to do this is absolutely baffling to me because we have a process in place that works very, very well. We have a system in place where all these agencies that have subpoena power, and they do, and I understand that they don't necessarily have judicial training, but the difference is that it will go through the administrative law judges. So we do have a neutral decision maker at the end of the day, and that's what this is missing. That's why this is unique. There is no neutral decision maker in this. This is wrong, members. This is a sham. This is a kangaroo court. I really encourage you to read this over. I know you want to vote your side and your side of the aisle, and I understand that. But look at the precedent you're setting here. This is really outrageous, the lack of rights that you're providing to people. This isn't the way we should be doing this in Minnesota. And why we would do this when we've already got the process in place, and why we would take away the ability to folks to have their case heard before a neutral decision maker, somebody that has no interest in the case whatsoever, because they're trained in the law and they're trained to be neutral. Members, this is really disappointing to me, and I encourage you to vote red on this bill. Thank you, members.
Representative Johnson.
Mr. Speaker, members, not too long ago, Representative Carlson talked about the tight timeline that he has to resolve these issues. And those tight timelines can cause great problems in greater Minnesota. In greater Minnesota, we don't have full-time city councils or county commissioners or full-time state employees. We have town board members. They meet once a month. When the clerk gets the mail in my area, I have 3 townships that the clerk does not open the mail till the next meeting. They could have their meeting on the 4th. Their next meeting is the 5th, the following next month. 30 days later, 31 days later, and they open the letter to find out they were supposed to have a hearing 25 days earlier. With 5 to 20 days, they also have open meeting laws they have to deal with. They could not get, in that time frame, they could not get the notices out to let people know that they have to have a meeting. Unfortunately, you didn't take Representative Franson's amendment to lengthen that time period so they could actually follow the law. This law is making, in greater Minnesota, the townships unable to follow the law. So they have a choice. Violate the open meeting laws and get in trouble, or violate this law and get in trouble. They cannot win. For those members in greater Minnesota, you have no choice. You have to vote against this. There's no other choice that you have.
Representative Leidiger.
Thank you, Mr. Speaker. Well, I think the worst thing about this bill is that it stacks the deck against the taxpayer. Here we have this SPB which is the super partisan board that has been set up, controlled by the governor. And every time they adjudicate whatever is brought before them, we know that this board is tainted. It's partisan. And we also know that any adjudication that comes from this board, it's the taxpayer who has to pick up the bill. So anything that happens that includes an increase in costs, that includes, penalties, etc., it's the taxpayer that is burdened here. And oh, by the way, about that board, what's very interesting, the one example that came up from Representative Nelson was the board that wasn't even passed. It was Representative Howe's bill. And of course it had nothing, that board is nothing like the problems that this board has. So this is just blatant growth in government. We already have an excellent system in place. PELRA has been working for a long time. We have the mediation services. We're told that, this is happening in 30 states or whatever, 32 states they're setting up these things. Well, my question is, do these other states did they ever do an agreement back in the 70s and have a PELRA agreement that everybody agreed with? Do they have a mediation services? Do they have all these things, government already in place? I don't know. I don't know the answer. All I know is that in this state, the Democrats want to grow government. And that's what's happening with this. You're creating something that we don't need. And of course you can't question the motives. I believe that's in the book, right? I can't sit there and question somebody's particular motives. But as a body, I got to tell you, Democrats, this doesn't look good. Last year I know you increased the numbers in government by something like 1,200 employees. Well, now you're coming back again this year in the unsession, and here we are growing government. And it's going to be at the taxpayer's expense. Not only in the employees, but now it's rigged. Now we're rigging the system. Because any adjudication of anything that happens over there is always going to be questionable. But you know what? It's the taxpayers that pick up the bill. And that's where we're at with this. It's not good. I recommend a no vote on this.
Representative Carlson.
Mr. Speaker, first of all, I indicated a few moments ago that I would get back to an answer, or with an answer to a question that I wasn't sure what the response was. In terms of tribal lands, there are no hospitals on tribal lands, so that should answer that part of the question. The veterans hospitals are federal employees, so they would not be covered by this particular legislation. So you asked a good question, and I did do a little research on that during the debate, and that's the status. There's been a lot of comments about growing government and cost, and originally in the bill we indicated that the board would have investigators that would be learned in law. And I met with the Commissioner of Mediation Services, and he indicated that the investigators that he currently has could handle unfair labor practices without any additional staffing. So the additional staffing would probably be, in my view, a single person that would use those investigators that would staff the board and that would have a background to be learned in labor law. There was discussion about small employers or smaller unions, and I indicated in my comments at the start that one of the reasons for this bill is the cost-saving mechanism. And a decision that small community that some of you were concerned about, or the small union, would have to make is whether they wanted to file under the current system in the courts an unfair labor practice that would cost them from $50,000 to $70,000 on average. This would, on average, with the experience of other states, cost about $5,000. So I think that when we talk about the taxpayers, we are being responsive to the taxpayers by coming in with a more cost-effective approach. The other thing is that when you have unfair labor practices, and if they go into the court and it takes months and sometimes years, those issues are going to continue to fester without resolution. And so this bill would allow for a faster resolution. And so when we talked about timelines, that's what I was referring to. So, Mr. Speaker, members, I think it's a good bill. I think that it will save the taxpayers money. It will bring about, I think, labor peace in the sense that we would get these issues resolved a lot faster. And so, Mr. Speaker, I would appreciate the support of the body.
Seeing no further discussion, the clerk will take the roll on the bill. The clerk will close the roll. There being 74 ayes and 59 nays, the bill is passed as amended and its title agreed to. The next bill on the calendar for the day is House File 2180. The clerk will report the bill.
House File 2180, the Fifth Engrossment, an act relating to insurance.
Representative Murphy.
Thank you, Mr. Speaker and members. I am happy tonight to talk with you about House File 2180. This is a bill that creates a statewide competitive process for securing and evaluating health coverage proposals for school districts. When implemented, it will provide proposals for coverage representing the best value for school employees, school districts, and Minnesota taxpayers. I want to thank those of you who have been in the committees that have heard this bill for the constructive debate thus far. We've been to Ed Policy, Civil Law, Local Government, Ed Finance, State Government Finance, and Ways and Means. And I also want to thank the various stakeholders who have spent time with me on this proposal, including Education Minnesota, the charter schools, AMSD, the superintendents, the Council of Health Plans, the school boards, the Rural Education Association, the service co-ops, AFSCME Council 65, and many self-insured districts from different parts of the state. The bill is in strong shape now. There's a little more that we might be able to accomplish together, but we've made a lot of headway. This bill is not the former school pool bill that has been debated by this legislature for the past decade. That bill, carried by Representative Davids for a number of years and Representative Ward in this last session, still waits for hearing in Ways and Means. But those who have been seeking relief for the cost of health coverage for school employees, school districts, and for taxpayers have come up with a new and novel approach. And I really want to give a shout out to our friends at Education Minnesota for their bright thinking about this. The novel approach, I think, is here in order to address the cost of health coverage for employees, for districts, and most importantly for school districts. School districts acquire their coverage in different ways depending on where they are in the state. They are fully insured, they're self-insured, they get their coverage through PEEP, they get their coverage through co-ops, the service co-ops, and we've worked very hard to preserve the notion of a competitive bidding process while making changes to the bill to recognize the differences in the ways that school districts acquire their coverage. And so we've tried to create a level playing field, knowing that there are differences based on geography and the size of a school district. And I think we've done a good job of balancing those things out while preserving the basic core tenets of competitive bidding, a sealed process, the the case for negotiation, and applying a gift ban to school superintendents, to school district members, and to the exclusive representative who has decision-making authority around the coverage plans. I want to just tell one story, and then we can move on to the bill and to the amendments. I have a friend who was a teacher. He's not teaching anymore. He has 3 kids working in a suburban school district, and his second child fell and cut his head. He was at school, and his wife called him and said, you know, our second son, I won't name him, has a bad cut. And, you know, they were in, they're both teachers, young in their careers, incurring a lot of health care expense. And my friend, the dad, said, well, I don't know, maybe we shouldn't take him to the hospital because our deductible is so large. And he thought to himself, how can I, as a dad, even contemplate that thought? It really caught him by the short hairs, if you will. It caught him. And he decided at that point that, you know what, I don't think I can stay in my career anymore. I don't think I can teach anymore. I've got to find a better way to provide health care coverage for my family. I've got to find a different job. And he did. He left the career of teaching because he was worried about his capacity to be able to provide for his family and for their health care coverage. Health care coverage has gotten very expensive for a lot of people. It's gotten really expensive for a lot of educators, for school districts, and for property taxpayers. We haven't been able to successfully solve this problem with the school pool, but guess what? Here's another way, and I'm going to ask for your support. Thank you very much.
There's an amendment at the desk. The clerk will report the amendment.
Erickson S. moving to amend House File 2180, the 5th engrossment as follows. The amendment is coded 213.
Representative Erickson.
Thank you, Mr. Speaker and members. This would amend page 6 so that my experience, having been in a school system for 35 years, was that there were representatives from all the different unions who came to the table to negotiate for health insurance. And so this on page 6 would add the prepositional phrase in consultation with the other exclusive representatives, and then on page 7, line 16, change the may to a must, so that every exclusive representation from a union in a school district would have a say in the ultimate decision made for the bargaining process when it comes to competitive bidding. I appreciate your support and like a roll call.
Roll call has been requested. Seeing 15 hands, there will be a roll call. Representative Murphy.
Thank you, Mr. Speaker and members. I think it's a good amendment. I'll accept it.
Any further discussion? Seeing none, the clerk will take the roll on the amendment. Clerk will close the roll. There being 133 ayes and 0 nays, the motion prevails. The amendment is adopted. There's another amendment at the desk. The clerk will report the amendment.
Wills moving to amend House File 2180, the 5th engrossment as follows. The amendment is coded 206.
Representative Wills.
Thank you, Mr. Speaker and members. And I've heard this bill several times in committee and had a conversation with Representative Murphy about it. And I want to commend Representative Murphy for being so open to listening to advice and feedback from the school districts and from members on this bill. And it has improved throughout the process. She's been very accommodating in addressing concerns. And one concern that I have repeatedly brought up in committee and want to share today is in this amendment. So in the RA 14-206, the language is exempting the self-insured school districts. It doesn't mean that they are not allowed to abide by the provisions laid out in the bill, but they may opt in to follow that process if they so choose. And we heard in committee several concerns from the self-insured school districts that they follow a very different process to be self-insured. And the concern is that if they were forced to adhere to this mandate of doing the competitive bid process, that it would actually increase costs for their school districts. And for example, in my district, District 196, is a self-insured school district, and they've been able to save about $6.5 million by going self-insured over the last year with no premium increases. And they're only expecting a 2% premium increase in the coming year, an additional savings of about $4.5 million. So self-insured is working for these districts. And in speaking with our finance director and our superintendent and hearing from other school districts as well, I've received several emails. This is a huge concern for the self-insured districts. And I appreciate the intent of the bill to lower costs, but my concern is that if the bill passes without exempting the self-insured districts, that the self-insured districts would actually have increased costs and increased premium costs. So it's a concern I have, but I know in my conversation with Representative Murphy, she made it clear that she would prefer not to accept this amendment, and I respect that. So with that, I would withdraw the amendment. Thank you.
The amendment is withdrawn. There is another amendment at the desk. The clerk will report the amendment.
Anderson S. moving to amend House File 2180, the fifth engrossment as follows. The amendment is coded 203.
Representative Anderson.
Thank you, Mr. Speaker. Members, this bill has given a lot of concern to the people in my district. I happen to be one of those self-insured districts, just like Representative Wills. And the concern that that I have with this is that we have a situation here where we would be limiting the school districts to potentially having just two bidders that would be bidding on it. And we all know in negotiations, when you limit somebody's options, it tends to drive up the cost of things. So what I'm doing is I'm allowing them to continue with negotiations with their group healthcare providers so that they can negotiate the best deal possible for their employees. Because the whole purpose here is make sure that the employees have the cheapest cost to them for the best benefit. So that's what I'm looking to do here with this amendment. I'd ask for a roll call, Mr. Speaker.
Roll call has been requested. Seeing 15 hands, there will be a roll call.
And thanks for your support.
Representative Murphy.
Thank you, Mr. Speaker and members. This is a subject that has been debated in many of the committees. What we're asking is that school districts seek 3 bids, one being PEEP, and we want them to put forth their best work. So they're going to put forward sealed proposals. And from my perspective, if those sealed proposals come in together and we can open them and then negotiate with a subset of those, we're going to get the best information from those who are making that bid. However, if instead everyone who participates then gets to be included in the next round of negotiations, I don't think those making the bids are going to put forth their best effort. I think they need to compete to get into the subset. And that's why I think we need to have, this many that come in and then a subset of those opened and negotiated. And so I would ask you to vote against the amendment. Thank you.
Representative Anderson.
Thank you, Mr. Speaker. Actually, with the self-insured districts, they have an advisory council. So this is a very transparent process where all of the negotiators have a chance to see what is being negotiated. It's a completely transparent process. I've had both teachers and school district administrators that have come to me and asked for some kind of relief because they actually see the provision that's currently in the bill as a cost driver for care for our school districts. And why would we want to incur more costs for our school districts with this mandate? So I'd ask for a green vote, and thanks for your time.
Seeing no further discussion, the clerk will take the roll on the amendment. Clerk will close the roll. There being 61 ayes and 72 nays, the motion does not prevail. The amendment is not adopted. There's another amendment at the desk. The clerk will report the amendment.
Woodard moving to amend House File 2180, the fifth engrossment as follows. The amendment is coded 205.
Representative Woodard.
Thank you, Mr. Speaker. And the 205 amendment just delays the effective date of the implementation of this bill until the implementation of the Affordable Care Act or to 2017, whichever comes first. Of course, we know that the Affordable Care Act or Obamacare is something our school districts are really struggling with right now. I had a bill this year that would have helped us quantify the cost of compliance to the Affordable Care Act for school districts. And we didn't actually hear that in Education Finance, although the chair was willing to hear that. We just kind of ran out of time. And when I talk to school districts in my district, it varies on the cost of implementation of the Affordable Care Act. And they're very confused about how expensive this will be and exactly what they need to do in order to be compliant. So all this does is says that we know that there's a lot of change coming in this bill, and we just need to slow down, let the school districts kind of catch up to what's going on in health care, and then to be able to address the issues within the bill. But, Mr. Speaker, I understand that the Affordable Care Act is, we voted on this thing 1,500 times if we voted on it once. And I understand that it's not something that Representative Murphy would like on the bill. And out of respect for her and the majority leader, I will withdraw my amendment. Thank you,
Representative Woodard withdraws his amendment. There's another amendment at the desk. The clerk will report the amendment.
Woodard moving to amend House File 2180, the fifth engrossment as follows. The amendment is coded 207.
Representative Woodard.
Thank you, Mr. Speaker. And what this amendment does is exempt our charter schools and school districts that are found to be in compliance with the ACA, with the Affordable Care Act. And again, this is an area our school districts are really struggling with and really trying to figure out what compliance means. So while I think this is a good idea, it is an idea that has not been fully vetted out within the committee process because we're not sure what compliance looks like for our school districts. So while I am very concerned about our school districts and their compliance with the Affordable Care Act, actually implementing this amendment into the bill would be very difficult. And again, out of respect for the majority leader and the author of the bill, I will withdraw my amendment. Thank you, Mr. Speaker.
Representative Woodard withdraws his amendment. There is another amendment at the desk. The clerk will report the amendment.
Creshaw moving to amend House File 2180, the fifth engrossment as follows. The amendment is coded 208.
Representative Creshaw.
And thank you, Mr. Speaker and members. And this amendment simply acknowledges the fact that many of our school districts, in working with their service co-ops, are already trying to get the best value, and they're already trying to get the best deal. And while I think that's very important, and I know many do, I'm going to, out of respect for the majority leader, I'm going to withdraw my amendment, and we'll let this one go forward.
Amendment is withdrawn. There is another amendment at the desk. The clerk will report the amendment.
Creshaw moving to amend House File 2180, the fifth engrossment as follows. The amendment is coded 209.
Representative Creshaw.
And thank you, Mr. Speaker and members. And on this amendment, we simply want to acknowledge that sometimes there are incentives, and those can come in a weight loss program or a health benefit to a membership for like a fitness connection or an Anytime Fitness. And I believe that those benefits we want to make sure are clarified and not excluded when we look at some of the gift bans. And the author of the bill, the majority leader, already talked to me about this, and they assured me that there will be some work on this in conference committee, and so I'd like to withdraw this amendment.
Representative Creshaw withdraws his amendment. Representative Creshaw, you have one other amendment. Do you want to offer that one? Okay. There's another amendment at the desk. The clerk will report the amendment.
Moving to amend House File 2180, the fifth engrossment as follows. The amendment is coded 212.
Representative Creshaw.
And thank you, Mr. Speaker. And I would just like to speak briefly to this, to the idea that as they go through the negotiation process, that we should acknowledge that if the union representatives and the school district are going to enter into a better deal with a better package by going 5 years, that we should acknowledge that, and then we should see that as a possibility and maybe extend past the 2 years. And so I would just like to leave that out for consideration.
Representative Murphy.
Thank you, Mr. Speaker and members. This was a subject of some discussion, and it's one of the areas where we tried to create a level playing field given the different ways that districts acquire their coverage. So we did adjust and amend the bill to say that current law, 5 years, is acceptable if after 2 years there's an agreement between the school district and the exclusive representative. So 2 years, but up to 5 years as long as there's an agreement. And I think that gives school districts the necessary flexibility while not letting the contracts run in such a long duration that they lose a competitive edge. I would ask for your no vote, please.
Representative Cretion.
And thank you, Mr. Speaker and members. And I certainly appreciate that. And I appreciate all the work that the Representative Murphy has done on this. I think it's important that we do acknowledge and have that conversation that 5 years is not that long of a time. And that as we go into negotiations and benefits, these schools and their union representatives are looking for the very best deal that's possible. And along with that, if 5 years is going to make the difference, why not let them have the 5 years? Maybe it's going to be 4 years, maybe it's going to be 3. And I don't need to get into Representative Matt Dean's not here, but the hand signals of what is 5. But I think we should look at this, and I think it's something that we should consider.
Seeing no further discussion, all those in favor of the amendment say aye. Aye. All those opposed, no. No. Motion is not prevailed. The amendment is not adopted. There's another amendment at the desk. The clerk will report the amendment.
Barrett moves to amend House File 2180 to fifth engrossment as follows. The amendment is coded 214.
Representative Barrett.
Thank you, Mr. Speaker and members. My amendment here deals with Section 4, Subdivision 10 on page 2. More specifically, it relates to insurance premium rebates in the fortunate situation where, under this plan, there is a rebate given back to the school district based on the positive health of the total number of people in the plan. Currently, as I read the section, and I could be corrected on this because I think the language is fairly confusing to me, but as I read the plan, what happens now in the situation where there's health insurance at the school district, and obviously we all know we're part of a health plan where the employer pays the actual plan to the third-party provider, and then the employee pays a portion of it. So in this situation where there is a refund or a rebate given back to the school district, that money then would be reapportioned back to the employer based on the portion of the premium that they've actually paid, and it would be apportioned back to the employee based on their portion of the employee premium that they actually paid. As you look at the language now, especially on lines starting at 2.16 through 2.21, seems to me that that money right now that the school district has paid for the health insurance of their employees is given entirely back to the bargaining unit. And that seems a little bit nonsensical, maybe, for lack of a better word, to me, because we want the employer, we want that school district to do their best effort to get the best value. And so if we give that money that would come back as an employer refund back, not to the school district, so they could use for other legitimate purposes of the school, or maybe have a lower than normal bond levy at in the November election. If we don't give them that incentive, then what's the incentive to actually make a good argument to the health insurance provider? So this bill actually gives money back to the school district appropriately based on the amount of money that they would pay for the insurance coverage. So I'd appreciate your yes vote.
Representative Murphy.
Thank you, Mr. Speaker and members, and thank you, Representative Barrett. And I'm going to ask members to vote no on the amendment, and here is why. There are two moving pieces in this section, and the first is dealing with, first and foremost, it's important to note that the notion of a rebate is permissive in this bill. So it's, if there's a rebate, then there should be a negotiation, and the negotiation should be over the health care costs being rebated that are attributed to the employees, but both the employee portion and the employer coverage portion. So both parts should be negotiated over, and those parties negotiating have the ability to say where it goes. And sometimes the school districts have decided that the money is not going to go into health care. Sometimes it's going to go into the chess club. They can still make that choice, but we're trying to make sure we're capturing the amount of money and to say if there's going to be a rebate, then there should be a negotiation and a decision together between the employer and the employees about where that money goes. The second half, that what Representative Barrett was talking about, was the section that talks about if there's no exclusive representative. Then what happens is there's a negotiation, but those funds are going right back into health care to drive down costs. And from my perspective, if there's no negotiation happening and health care costs are a problem for school districts and their employees, then if there's a rebate, it should go back into health care. And that's why I think this is a smart provision. I would ask for your no vote on the Barrett amendment.
Representative Barrett.
Thank you, Mr. Speaker. Majority Leader Murphy. Well, I guess we probably just will disagree on the issue, but let me bring up a thought I've had for a couple days now as I've put together the amendment. And it leads back probably 30, well, I won't even date this because I'm referring to my wife. When she grew up in Representative Carlson's district back in Crystal, Minnesota. She lived right by Crystal Airport. And her and her brother, she's about 10 years old at the time. And I don't know why I remember this story, but I think it's a perfect analogy for what I'm trying to accomplish here. What she did is she and her brother Paul, they raided their piggy bank because they wanted to go down to the convenience store right down the street. And they wanted to go to the convenience store because they wanted to get some candy. So Judy raided her bank, and it had, I don't know, a buck of pennies and nickels and dimes in it. And Paul raided his bank, and it probably had $5-6 in it. So they went down to the store, they got their candy, they were all happy, they came back. They went home, and they had a bunch of candy, and they had change left over. And so this is a funny story. I don't know, I don't know why she'd tell her husband of this, but her and Paul was younger. Judy was about 10 and Paul was about 9. And so Judy had about a year up on him. And so they took the money and they divided it equally. So, they maybe had a couple dollars left over. So Judy came back home and she had candy and she had her dollar back. And Paul came back home and he didn't have his $4. He had $1 left, and he had a bunch of candy. So that doesn't seem to be a fair equation right there. But this bill is even a little bit worse than that, because what happens then, according to the language as I read it, is Judy would get all the money. Paul wouldn't get any money back. It would go to one side of a two-sided situation. In this situation, going back to the schools for a moment, the district is paying a lot of money for health insurance. The employees are paying a lot of money for health insurance, but not quite as much, generally. In this situation, all that money would go back to the bargaining unit. And the provider, or the school district, wouldn't get anything at all. Now, in the situation with my wife and her brother, we all agree that, Judy shouldn't have got $1 back, right? She got a bunch of candy. And she put in $1, and she got a bunch of candy, and she got her money back. This bill is even worse. I'm trying to correct something that I think is only fair. We have good business managers around the school in Minnesota. I know them very well in my district. I talk to them all the time. And they want nothing more than to provide good quality health insurance at a good quality price. And they're doing a lot of things preventively to make sure, or try to make sure, that the employee, the school, the teachers, and everyone else are healthy. They're even paying for a part of their health club memberships because they want that cost of that health care for everyone, the employee and their employer, to be as little as possible. And if they do a good job of that, these business managers, these principals, superintendents, and school board, that school should get money back if there's a refund. They should get a proportional amount of money back so they can use for productive things that school districts do. Maybe hire another teacher. Maybe give money back to the taxpayer. Maybe reduce the levy in November. There's all kinds of productive things that school district can do. Maybe pay for a higher portion of the employer premium for health care. But they did a good job. They should proportionally get their money back. They shouldn't get it all back. The bargaining unit shouldn't get it all back. They do in the bill, but they shouldn't. The employer shouldn't get it all back. They should get the money back proportionately for the amount of money that each side paid into the health insurance. So, with respect, I would appreciate a yes vote.
Representative Petersburg.
Thank you, Mr. Speaker. And if the majority leader would yield for a question.
She will. Representative Petersburg.
You know, I heard you talk about the negotiating of the rebate that comes back, and I think that's something that's worthy of talking about. But my question to you is, during the negotiations that set up the original payment and the distribution of those payments between what the employee pays and what the school pays, was there not already a negotiation for those dollar amounts?
Representative Murphy.
Thank you, Mr. Speaker, and thank you, Representative, for the question, and I think it would depend contract by contract.
Representative Petersburg.
Thank you, and I think that kind of answers my question. If the amount of dollars going in was negotiated in the front, then the rebate has already been negotiated because it's the percentage of the dollars that went in, and so therefore it makes sense to me that since it was already negotiated, why would you want to negotiate a second time? I think that's a little disingenuous.
Representative Murphy.
Well, thanks, Mr. Speaker. And, you know, I want to make a couple of points here. I don't think there's anything disingenuous about this. In fact, I think it is often the case that the costs of coverage and who is responsible for those costs, the employer or the employee, are negotiated. Certainly when I worked for the nurses, that was the case. The nurses across the state get their health coverage contracts negotiated in that way. But there may not be any provision for what happens if there is a rebate. And so if there is a rebate, all we're saying in the bill is there should be a negotiation over the portion that is proportionate to the employees. And this is, you know, I want to make clear, Representative Baird and I are reading this differently, and I think his reading, with all due respect, is inaccurate. So if you can just look at line 2.14, well, if we start at 2.13, that the school district must negotiate with the exclusive representative regarding the refund amount attributable to the proportionate number of insured lives covered by that exclusive representative. So we are just talking about the employees. We're talking about both the employee contribution and the employer contribution to those insured lives, but we are talking about those covered by that contract. And so I do think it's fair. I don't think we're asking Representative Zerwas for free candy. I think we're just parsing up the candy in a fair way, and I would ask you to vote no on the Barrett amendment.
Representative Kelly.
Thank you, Mr. Speaker. Would the Majority Leader yield for questions?
She will. Representative Kelly.
Thank you, Mr. Speaker. Majority Leader Murphy, I've got a real-life situation for you, and just want to clarify this because I think what Representative Barrett is asking for is correct. 5 years ago, I negotiated a deal on the school board that we actually the school was paying 100% of the premiums, and because of our bargaining situation, when it came back, we actually ended up with a refund. In your eyes, Representative Murphy, would the bargaining unit, should they be offered a rebate then?
Representative Murphy.
Thank you, Mr. Speaker, and Representative Kelly. Under the language of the bill, if a rebate is offered, then there should be a negotiation over the terms of how that is distributed.
Representative Kelly.
Thank you, Mr. Speaker. Majority Leader Murphy, I'm not exactly sure if you heard the situation, because in this situation, 100% of the premium was paid by the district. 100%. So in your eyes, what you're telling me that if there's a rebate, even though the teachers paid zero premium for their health care, they would be entitled to a rebate?
Representative Murphy.
Thank you, Mr. Speaker, and Representative Kelly. They would be entitled to a discussion.
Representative Kelly.
Thank you, Mr. Speaker. Well, Majority Leader Murphy, I think that is extremely flawed. When we have a bargaining situation, and in this case, the district paid 100% of the premiums, and then to suggest that not only do you get your full premium paid and you get provided health care insurance, that you would be somehow entitled to even more. What Representative Barrett is asking for is simply a proportionate amount. I've showed you the extreme, so all we're asking for is to share in the premium offer. If the employee actually does pay something, then proportionately
unfortunately, they should be refunded. But my goodness, this is not what this language says now. And I would firmly support Representative Barrett, and thank you for the amendment.
Representative Barrett.
Thank you, Mr. Speaker and members. So I'll just summarize my comments by saying, let's go back to the bill. Let's go back to the idea of the bill, which is that we want health insurance to be less expensive. That's the idea of the bill. I'm not sure we agree on whether the bill does it, but that's the goal in mind. So if the whole idea of the bill is to reduce the cost of health insurance, and if we agree that the school district pays for a large part of that health insurance, to me it's a contradiction not to accept the amendment, because what we want is we want the school district to receive a benefit when the cost of the health insurance is lower than what they expected. So I would ask you to accept my amendment, and Mr. Speaker, I'd like a roll call.
Roll call has been requested. Seeing 15 hands, there will be a roll call. Seeing no further discussion, the clerk will take the roll on the amendment. Clerk will close the roll. There being 61 ayes and 72 nays, the motion does not prevail. The amendment is not adopted. There is one more amendment at the desk. The clerk will report the amendment.
Erickson S. moving to amend House File 2180, the fifth engrossment as follows. The amendment is coded 210.
Representative Erickson.
Thank you, Mr. Speaker and members. This amends Clause D on page 4 and allows some flexibility for charter schools so that the mandate changes to a may, a permissive verb, and in the first subclause of D, that the request for proposal for group health insurance from a minimum of 3 sources, if practicable, and at least every 2 years to 5 years. Remember when we created charter schools, and most of us were not here, at least on this side of the aisle, when charter school language was created. But the design of charter schools is that they can have some flexibility that the regular public school does not have. So in that respect, this would allow for a continuation of that flexibility. But members, I also want to point something else out, and I know this from experience in my home district. First of all, there's no annual report from PEEP. I have requested one from MMB, and I've been told that there's no annual report because this is a public employees insurance plan. And members, I think that's problematic because I think we should be receiving annual reports from even a public employee insurance plan. Furthermore, PEEP only offers Delta Dental, and in my community and across central Minnesota in my area, Delta Dental is no longer accepted by my dentists, and I've had to hop from dentist to dentist trying to find a dental insurance plan if you want that. So that's something to think about as we pursue this. And then I believe the public employee insurance plan includes 3 different plans: Preferred One, Health Partners, and Blue Cross Blue Shield. So I can envision when these bids are open that we might have Preferred One competing against Preferred One if that's another bid. So within the public employees insurance plan, there are 3 plans available, but you might be competing against the bid from the private insurance. Let's say it's Preferred One. So I think those are some things we need to think about as we go forward. But I would like a yes vote on my amendment, and there's no roll call.
Representative Murphy.
Thank you, Mr. Speaker and Representative Erickson, and I want to say thank you to the charters and Mr. Piccolo. We were early in our discussion with them and did make modifications to the legislation in order to accommodate their concerns, and I think we did a nice job with that. I would hate to take away the tool of competitive bidding from our charter schools. I just think the notion of competition in driving down healthcare costs and getting better value is important for our public schools, for the school districts, for the employees, and for the taxpayers, and that should apply to the charters as well. So while I have a lot of respect for Representative Erickson's idea, I don't think we should make this permissive. I think it should apply to the charters, and I would ask for a no vote. Thank you.
Representative Erickson.
Oh, thank you, Mr. Speaker, and thank you, Majority Leader. Remember, this is permissive, and in light of what we have done in creating charters and allowing that flexibility, and even though you may have negotiated this, I know that there are charters and also teacher cooperatives who offer group health insurance that would like this flexibility. So I would still hope for support of my amendment.
Seeing no further discussion, all those in favor of the amendment say aye. Aye. All those opposed, no. No. Motion does not prevail. The amendment is not adopted. There's no other amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File 2180, as amended.
Third reading. Any discussion to the bill? Representative Wills.
Thank you, Mr. Speaker and members. And I appreciate the discussion we had today, and thinking about how we attempted to address some of the concerns that we have here. And I just bring up the concern again about the self-insured school districts. There's 17 self-insured districts in the state of Minnesota, and that represents about 23% of the statewide school district employees. And all I've heard from these self-insured districts is that they don't want this bill, and they don't want to be forced to go out for bids every 2 years and follow this very prescriptive model. And so that was the intention behind my amendment that I had previously. And just the concerns I'm hearing from Osseo area schools, Orono schools, Minnetonka schools, and then of course my own district, Apple Valley, Egan, and Rosemount. And so, again, members, I just want to remind you that the self-insured school districts have serious concerns with this bill, and I urge a no vote on the bill. Thank you.
Representative Grunhagen.
Well, thank you, Mr. Speaker and members. Yeah, just a quick comment. When I was on the school board and I got on the negotiating committee, one of the things we did, we were in deficit situation, we were declining enrollment school, and we had our teacher's contract audited. And the auditor came back and said, you have negotiated away many of your managerial rights as an administration in a school board over to the teachers, and you shouldn't be doing that. So we had a very difficult negotiation sessions that year, but we got quite a few of those rights back, which we should have never given away in the first place. And when I look at this bill, and after having been on the school board the number of years I have, we got bids. Everybody wants lower health insurance costs and better benefits. And we had PEEP at times bid our health insurance, but we did that just because we had the local authority to do it. We cooperated with the teachers and tried to come up with the best benefits and the best premium. And there was a big disagreement about that. What I see is this bill, it actually takes away local control. And now we're inserting the state into local control and micromanaging the bidding process and who you have to bid and how many years. And every time I've seen that in my experience, it simply drives up the cost. And by the way, Majority Leader Murphy, I do appreciate some of the changes you made to the bill. Okay, I really do. And I know you want what's best too. But do you, Mr. Speaker, would Majority Leader Murphy yield for a question?
Yes, she will.
Okay. Majority Leader Murphy, do you really believe that bringing micromanagement from the state into this process of bidding health insurance, do you really believe that it will actually produce lower cost and better value for the local district. If you'd respond to that, please. Thank you.
Representative Murphy.
Thank you, Mr. Speaker and Representative Gruenhagen. I really believe competition is good. I believe that in this case we're going to be using competition by applying a sealed proposal process. So those competing for the business will provide their best effort. And because of that, and because it's sealed, I think we're going to get a better value. I think that's going to work. I really do.
Representative Gruenhagen.
Well, thank you for your response, Majority Leader Murphy. But what I've seen is every time you get the state involved, it invariably drives up cost. And I think part of the thing, if you look at your bill, you're giving people 200 and some thousand. I appreciate it coming down from $1 million. But one of the reasons you're doing that because there's a cost to doing all these bids. Well, the private companies that want to bid, they also have those costs. And again, local administration, school boards, in cooperation with teachers, can do these bids, and they've been doing them. And inserting the government into the micromanagement is not going to produce better cost any more than MNsure did in terms of bringing actually premiums down. So I'd strongly urge you to vote red on this, members. It's not going to help your local school districts. It inevitably, in my opinion, is going to drive the cost up. Thank you, Mr. Speaker.
Representative Newberger.
Thank you, Mr. Speaker. I just rise of, this is rather new to me, this whole insurance process for school districts. I've been trying to immerse myself in this, get my head around this. I have 13 districts, school districts in my House district, and I'm getting a real mixed reaction, and I have since we heard this bill in civil law a while back. I have some questions I'd like to get clarified if Majority Leader Murphy would yield.
She will yield. Representative Newberger.
Thank you, Representative Murphy, Majority Leader. My question is, and please walk me through this because I'm really trying to understand this because I need to communicate this to people back home as we work through this process. But if you have, if your bids that come through, the ones that, if they don't line up with the current school district budget. Now, this question came from some of my school district people. If what is offered is something they cannot afford, are they going to have to turn and consider possible levy increases?
Representative Murphy.
Thank you, Mr. Speaker and Representative Newberger. I think that this bill is going to get us on a better path of getting more affordable coverage for school districts so they don't face that eventuality. Nothing in the bill is going to make them choose a plan. That authority remains with the school district. The school districts are working very hard to provide affordable coverage, and frankly, I think they are often getting bids that are very expensive. And so we're saying let's use the power of competition to get sealed bids, the best offers, and then make a choice from there. So I actually think it's going to serve to drive down costs.
Representative Newberger.
Sorry about that, members. Thank you, Mr. Speaker. Thank you for the answer there, Representative Murphy. I appreciate that. I don't know if I'm really sold on it. I've had, like I said, I have 13 districts, school districts that I'm in communication with, and I've had a number of these folks in my office, and that was a big concern that a number of them had, that they were worried that choices A, B, and C are all going to be a lot more expensive than what they currently had or were dealing with. So they were afraid that they'd have to turn to the taxpayers of the school district for more money, which generally doesn't go over well. One more question, if the Majority Leader would yield.
She will yield. Representative Newberger.
Thank you. Representative Murphy, one more clarification point here, if you'd be so inclined. As I was talking to some of my district people over the course of this bill, the life of this bill, one of the questions that came up, and I was hoping to catch it privately, and ask you this, but I guess getting this out for public record, and maybe this has already been been touched on, but if it has, please repeat, just for the good people of Minnesota. What happens? These contracts, it's my understanding, and according to this bill, are for 2 years. What happens if your contract expires and you have no agreement? What if you have like a strike, or if you have any type of labor issues? In your health insurance contract, the 2-year time period expires. Will we have teachers and school district workers will potentially in a situation where they would not be insured? Is that a potential possibility here?
Representative Murphy.
Thank you, Mr. Speaker and Representative Newberger. What you're describing is what could happen under current law, and nothing in this proposal would change that. But I do want to make a point. I think you're suggesting that if a school district seeks 3 bids, that somehow they wouldn't be able to keep the coverage that they have. I would imagine that of the bids that they seek or receive, one may be the coverage that they currently have, and the school district retains the ability and the authority to make that final choice. And so hopefully, if the people, the provider, the entity that is providing coverage for the school district to which you are referring, wants to keep that business, they'll do a good job in providing a decent bid through that sealed bidding process, but the authority for the final decision rests with the school district.
Representative Newberger.
Thank you, Mr. Speaker. So, Majority Leader Murphy, I just want to make sure that I've got your words straight here. So what you're saying then is, in essence, that there is no, this bill really doesn't offer any new protection. Basically, if there's a labor disagreement and there's an issue between the workers and the school board or the school administration, that potentially these people could still go without insurance if their strike goes past the deadline. Correct.
Representative Murphy will yield. Representative Murphy.
Thank you, Mr. Speaker and Representative Newberger. In my experience in contract negotiations, and we just witnessed this with the St. Paul teachers in the St. Paul School Board, that people with an honest interest in finding a solution do, and they find their way through those negotiations. In my experience with the nurses, it was rare that coverage, in fact, I can't think of a time when coverage was lost because they were unable to complete a contract negotiation. So what you're describing is the current existence. Nothing in this proposal changes that. I think for educators, their work requirements in that negotiation is separate from their health care coverage. They're 2 different documents, as I understand it. But I don't really understand the point of your question, because you're describing current law, and we're talking about applying a competitive process of securing affordable coverage, which is a different path that we're taking.
Representative Newberger.
Thank you, Mr. Speaker. All I'm trying to say is that there's no new protection that's built into this should this event occur, and that's the answer I'm looking for. And all I'm doing is reiterating questions that were brought up to me, and I'm bringing them forth to you to see if we can get some clarification. Thank you for your time.
Representative Ward. Representative Ward. Okay.
Thank you, Mr. Speaker. I heard you the first time. Thank you. And members, I want to make 5 points. Wait a minute, wrong hand. 5 points. 5 points. I can't hold that with that hand, so 5 points, members. From a legislator that was an educator for 34 years and on the negotiations team and negotiated a fair amount of contracts in my career. Healthcare was always healthcare premiums, healthcare insurance, was and continues to be a major issue in the whole negotiations process. And part of the whole thing, members, and then also from a legislator that carried the bill last year, and I know Representative David, you carried it 1 year, I believe. 10 years? 10 times you carried it? I can't get to 10, so I can't even match that. So, I think Representative Dabney carried it once, and Representative Sertich carried it once, and Representative Zelk, you carried it once? Okay, well, it's a tough bill to carry. It's a good bill, but it's a tough bill to carry. And Representative Davids is shaking his head yes. And it's a tough bill to carry because there's a lot of emotion around it, a passion about it, and needs about it. It's very, very critical. And so, members, as we try to provide insurance for those folks in education, all education staff, who rightfully deserve that insurance. Bless you. There's a number of things that have been happening over the past decade with health insurance in the education arena. And one of those things, and here's my 5 points. One of those things was some districts have eliminated their plans. Period. There's districts in the state of Minnesota that don't offer health insurance anymore because of costs have gone so high, escalated so greatly. Number 2, if they've kept their plans, a lot of the coverages have been eliminated. The plans have weakened, they've been watered down so that it could offer coverage for their school district employees. Number 3, and I can still use this, number 3, there's been higher out-of-pockets for those education employees significantly. Number 4, there's been raised deductibles, significantly raised deductibles for those district employees. And then number 5, members, the premiums have escalated at a significant increase annually for a lot of the districts. I was at a meeting the other day, this week sometime, when I heard one little rural district in greater Minnesota whose premiums went up about 30%. And that's not uncommon. That's not uncommon for school district premiums, health premiums in a district go up by 20, 25, 30%. And I'm sure Representative Davids heard that, and the others that have carried this bill. So this is really an attempt to, ask for more competitive bidding prices, ask for a more process that will provide that good health care coverage for those valuable education employees that take care of our children. So, members, I urge a green vote on this bill.
Representative O'Driscoll.
Well, thank you, Mr. Speaker. I sure wish Representative Atkins was here tonight because we had a very robust discussion last spring when we were talking about the implementation of MNsure and where the funding for that was going to come from. And I guess what I'd like to do is I'd like to ask the Majority Leader a couple questions. She was in our State Government Finance and Veterans Affairs Committee, and I'd asked a question. And I was told I was going to get an answer to that, and I have yet to get an answer. And I just want to toss this out. The question was, how many of our school districts in the state of Minnesota have 50 employees or less? And I see the Majority Leader shaking her head that she does recall that question. I wonder if she could help me out with that, because I hadn't heard back from the folks that she had there as testifiers who had indicated they would.
Representative Murphy.
Thank you, Mr. Speaker, and Representative Driscoll. And I do remember you asking the question. It's very few, but I still don't have a specific answer for you. My fault. I am sorry, but it's very, very few.
Representative O'Driscoll.
Well, thank you, Mr. Speaker. One of the things I want to remind members on as you're contemplating a vote on here, and as our good friend, former Representative Tom Urukavina would say, you might be getting into the weeds on this, but I think it's important that folks know a little bit of background on insurance here in the state of Minnesota. A program that no longer exists, which, by the way, I still hold has been a better program than we have with Minnesota's implementation of Obamacare under MNsure. We used to have a program called MCHA, the Minnesota Comprehensive Health Insurance Act, which created MCHA, the administration of this. What we used to do is we used to collect premiums from, as private providers of health insurance, collect premiums, and a portion of those premiums would be set aside and paid that would go into the MCHA program that helped folks who would otherwise not be able to get insurance in the private market to be able to go and apply once they've been rejected from a private carrier to be able to apply through MCHA and get a slightly higher than market premium, but a lot lower than they would have otherwise been able to get, and as well as provided coverage. Well, that went away under the Affordable Care Act or Obamacare, because everybody's eligible for insurance on that. So the question I asked Representative Adkins in committee on a couple of occasions was, what's going to happen if we don't collect those fees anymore? And he said, well, Representative O'Driscoll, those are going to be used to help shore up MNsure and pay some of the administrative costs so they don't end up going away. And then I said, well, Representative Adkins, do we collect those same premiums under PEEP? And he said, oh, Representative O'Driscoll, PEEP is exempt from that. Let me say that again. PEEP is exempt from that. So under the MNsure legislation that's in place right now, folks, in the state of Minnesota, here's what happens. Private insurance companies, they'll still collect premiums. They'll send money not to MCHA, but they're going to send it to MNsure. I'm sure everybody's in here familiar with MNsure, the program we spent at least $150 million trying to get up and running, and still have some bumps along the way on that. But we've got about 40,000 Minnesotans covered on that, so that's a pretty good thing, I think. $150 million, got 40,000 covered. We've got our base investment in that. But I'll get back to the idea of PEEP. If we take all these school district employees who would be covered under insurance out of the system, where their premiums right now would end up being paid, and a portion of those premiums would go to help shore up MNsure and their administrative and operational costs, as was explained to us last year by Representative Adkins. My simple math question, where are we getting the money to help fund MNsure on a go-forward basis? So I guess I'd like to either yield to the majority leader or to the Ways and Means Chair, Representative Carlson, for some background on the fiscal implications of that. Maybe we'll start with Representative Carlson first.
Representative Carlson will yield.
Could you repeat your question, please?
Certainly, Representative Carlson.
Representative O'Driscoll.
Thank you, Mr. Speaker. It boils down to this. PEEP doesn't
and Representative O'Driscoll, it also helps you ask the person who you want to yield before you ask the question so they can
I get that, but
thanks.
and the teacher in me, Mr. Speaker, says
go ahead,
if
Representative O'Driscoll.
Identify, then everybody listens a little closer. So I was just hoping to use one of those teaching techniques that I use in my classroom. But I will take your advice, Mr. Speaker. So, Representative Carlson, here's the question. PEEP doesn't have the fees that Representative Adkins had in the MNsure bill that would come from the private sector. So if we take all of these folks out of the private sector who might be going on to PEEP, how do we backfill the hole for the MNsure costs?
Representative Carlson.
Mr. Speaker, there may be others that are more expert on that particular question than I am, Mr. Speaker. So if there's someone that can answer that question, that would be fine. I can't give you any advice right now.
Representative O'Driscoll.
Well, Mr. Speaker, I'll take a shot at it. We don't. Because right now we don't have those fees under PEEP. Because we don't have those fees under PEEP, but we have them under the private market, we are requiring school districts to include PEEP as one of their options on this. The problem that we have is we're going to be blowing a hole open here. We don't know how big it's going to be because we don't know how many districts are going to go with PEEP. And I'm surprised we didn't have a fiscal note on this as we're moving forward on this. I also like to just comment on something that my good friend Representative Ward said. And he was going through his 5 points, and one of the things that resonated with me was the school districts are getting higher deductibles in order to get the coverage. He kind of articulated some of the issues on that. Representative Ward and others, I can tell you that has been something that my phone, my door, everywhere I go, folks have been talking about that. Not just in the public sector, but in the private sector. They're real suspect about whether MNsure is going to save them money. Sure, the premium might be less, but the deductibles, and they're just hoping beyond hope that they don't get sick and have to pay $10,000 to $15,000 a year in premiums or in deductibles to keep their coverage, where they would have had something else that was a little different before. So I would have to encourage folks to vote no on this. So how do my school districts back home view this? No one's told me they're in favor of it. As a matter of fact, I've got Representative Tice, and I've got Representative Howe, and Representative Dorholt, and I all represent parts of the St. Cloud area of public schools. And they sent us a letter this morning via email saying, please, please, please do not support this. We're self-insured. That's going to create problems for us. They articulated some of the other issues they have in this bill. Things that we had as amendments that were earlier that were withdrawn or that were turned down. And so, members, I ask you, somebody who's got 30 years of financial services here in the state of Minnesota background, real estate, insurance, securities, that's a bad deal for Minnesota. Vote no.
Representative Detmer.
Thank you, Mr. Speaker, and I too represent several school districts, and I called them today just to see where they were at. They've been following this legislation closely. I know the school district of Forest Lake, Stillwater, they're both self-insured. They do not see any advantage of them going with this type of setup. Along with Chisago Lakes, I represent, along with Representative Barrett. Again, their answer is a big no to this legislation. And I have two charter schools, small charter schools, Lakes International Language Academy, who is an outstanding academy. Again, that would put a burden on them. Along with North Lakes Academy, I talked to the superintendent there, and again, a big no. We do not need to be going this route. I believe that the current law states that if a school district would like to go into PEEP, they can. If the school district would like to go into PEEP, they have the option to do that. In fact, Chisago Lakes, their staff, their teachers are on PEEP, whereas the administrators and other people are not. My question is for the Majority Leader Murphy, if she would yield to a question.
She will. Representative Detmer.
Is if this passes, would that mean that the staff and administrators, everybody would have to abide by this law?
Representative Murphy.
Thank you, Mr. Speaker and Representative Detmer. I sometimes feel like I'm fighting the ghost of school pool past, right? So let's just remember what we're talking about here. School districts are being asked in the legislation to seek 3 sealed proposals. They open them, they can negotiate with a subset. The school district retains the authority to choose without the exclusive rep. The authority to choose in the end remains with the school district.
Representative Detmer.
Thank you, Mr. Speaker and Majority Leader Murphy. I understand that, and let's take a look at the bill itself, in lines 2.3 to 2.7. It states, no board member or school district employee shall receive any compensation or benefits based on incentives or other school or other money provided by the school district by or from the source of group insurance coverage referenced in the section 4716161 subdivision 1, except for a refund provided under section 123B.75 subdivision 10. Representative Murphy, do you know of any cases in the state of Minnesota where school board members or district employees have received kickbacks or any compensation for these types of situations?
Representative Murphy will yield. Representative Murphy.
Thank you, Mr. Speaker and Representative Detmer. And let me be really crystal clear with you, because this question has come from a number of members in committee, and I will answer it in the same way that I have in the committee. I've not once asserted that.
Representative Detmer.
Thank you, Mr. Speaker. So what I understand there, that there has been no reported incidences where there's been kickbacks to school board members or school people. So we got the same languages in 3.21 and to 3.24 for charter schools. I'm assuming there was no cases in the state of Minnesota there either. So I'm just wondering, why are we going forward with this where the current law already states that school districts can adopt their insurance through PEEP? So it just doesn't make any sense to me. And I just talked to our school districts today, because they've been following this closely. And I hope that everybody here, every representative here, has contacted their school districts to see what they would like to see done. And I'll be voting no on this legislation.
Representative Garofalo.
Thank you, Mr. Speaker. Would my favorite member from Ramsey County yield for a question?
She will. Representative Garofalo.
Thank you. Majority Leader Murphy, a couple of quick questions. Today, the Republican caucus learned that a minimum wage bill was traded for the Senate office building. Is this bill being traded for anything else?
Representative Murphy.
Thank you, Mr. Speaker. And Representative Garofalo, I am glad I'm your favorite member. I'm glad to hear about so much respect for me on the floor. And I think embedded in your question is a question about motives, so I'll just sit down.
Mr. Speaker, Representative Murphy, I wasn't questioning motives. I just know that sometimes horse trading is part of the normal legislative process here, and that's what happened with the minimum wage in the Senate office building. And I'm looking at this bill, and, you know, candidly, I don't support this bill. I've been against it. I'm just wondering if maybe there might be some other considerations or other horse trading that took place in this bill that would maybe the members on our side of the aisle would take a look at and say, well, you know, I'm not a big fan of this bill, but knowing that other things are happening, that maybe they would be in favor. But I'm not, Representative Murphy, I'm not questioning motives. I'm just wondering if this bill is similar to the Senate office building minimum wage trade.
Representative Murphy.
Thank you, Mr. Speaker and Representative Garofalo. I hope that you, as well as everybody else in the chamber, considers this piece of legislation for its merits, just as I have considered the issue of the minimum wage and the Capitol office building for its merits.
Representative Garofalo.
Thank you, Mr. Speaker, and thank you, Representative Murphy. I do have another question with regards to the bill, and I'm not a healthcare expert, but I've heard the stated goals of this bill, and I have a theory about this, and it goes something like this, is that if I'm a school district that's concerned about healthcare costs, what I would do is just cancel my health insurance, pay the penalty, throw the school district employees, the teachers, onto the state exchange, and then I've got cost certainty from the local school district perspective. This is now going to be a burden taken care of by the federal government or the state government, and that gives them cost certainty. They can use some of those savings to give salary increases to their employees. What would this bill do to resolve that potential problem?
Representative Murphy.
Thank you, Mr. Speaker and Representative Garofalo. And Representative O'Driscoll, I got an answer to your question. Just 45 school districts are at 50 employees or below. Those would be the only ones that could be eligible to consider MNsure if that's what they chose. Those 50 and above, of course, would not be eligible for that. And so I would imagine that employers, the school districts, will want to continue to provide coverage for them. And that's why I think this bill is so important. Here we are talking about requiring districts to seek multiple proposals to create competition that will lead to better value. I think that's a good idea. I really do. And my question for you is, why don't you? Why don't you think that's a good idea? I know it's a rhetorical question. I can't ask you to yield. But I think we should stick with this proposal before us. We're getting a little far afield. That's okay. But members, this is a good idea. It really is a good idea. It's a novel idea. It's about competition. It's about better value for our school districts, for their employees, for property taxpayers. I hope to earn your support.
Representative Garofalo.
Thank you, Mr. Speaker and Representative Murphy. And actually, I'll answer your question because I'm always happy to talk about education issues. You take a look at this bill, and it's a disturbing pattern which has plagued the DFL for multiple years. And that is that you use the language of, we are asking school districts to do things. You're not asking them anything. You're telling them what to do. What you're doing is taking an already biased collective bargaining process, which is some of the worst in the nation, and you're tilting it even more in favor of the local teachers' unions. That's what you're doing. That's what you've done for years. And I'm opposed to that. I think local school districts should have more power. I think it should be more balanced. That's what we did 2 years ago when we were in charge, is we made that collective bargaining process more balanced between school boards and between the teachers' union. But there's a different crew in charge now, and we're seeing the effects of that. That what's going to happen is some of the worst collective bargaining laws in the nation are just going to get a little bit worse, and they're going to give even more power to the teachers' union. Now, I will say that I was joking with some members that given the fact that Democrats are in total control, it's given the fact that Democrats are in total control, I mean, this bill could be a lot worse. I do find it interesting that the statewide teachers' health insurance bill, which we had Governor Pawlenty had to veto many times, is not being brought forward. So I guess I'm thankful for that. I'm thankful for a lot of the bad ideas the teachers union has pushed forward are not being passed today. But at the end of the day, what this bill does is it shifts the collective bargaining process once again towards more domination and more power for the teachers union. And once again, we see that the agenda of the teachers union has very little to do with assisting children, very little to do with improving the education system of our state. It's about power and control. And once again, the teachers union wins.
The member from Candy, Ohio, Representative Sawatsky.
Thank you, Madam Speaker. A couple of questions or statements I'd like to make. As a teacher on leave right now, I'm really surprised at how many school districts are not in favor of what I'm hearing. About 4 sessions ago of looking for negotiation sessions, the Wilmer School District chose not to. We were advised that maybe it'd be a good idea to go out and get a PEEP bid. Not really understanding the system, not really wanting to upset the apple cart, we didn't. And again, our insurance premiums had continued to be in the double digits, 17%, prior to that 20%, 21%, 17%. So 3 negotiations ago, we went out and asked for a bid. Came in really low. Our existing insurance company said it was like a 2% increase. Wow, 21% down to 2%. Just because we asked for an outside bid from PEEP, competition. Competition did Wilmer Public Schools really well, because I'll tell you what, there's a family in my district of 3, a mom and a dad that are both teachers, and they have their little son Jack. The dad had testicular cancer in college and has a pre-existing condition to this state. Okay? So nobody will take him. But now that he can get single coverage through Wilmer Public Schools, his wife is a teacher, so she can get coverage, but little Jack is still out. Not until MNsure came along. Now, I just got an email from that family. Little Jack is on insurance for the first time, and he is 4 years old. So, to go back to MNsure, it's working for this family. But to go back to the Wilmer Public Schools, when we don't have to have double-digit increase, I would say that competition is good. And I would think that as all of us in our world of shopping, we like competition. We like big stores, we like small stores, we like specialty stores. This is one idea that you could go out and have checks and balances. As it turned out, PEEP came in last session lower than our existing insurance coverage. But guess what? As good stewards to our members, we decided that it wasn't worth it wasn't worth to go to the PEEP bid, because we wanted to keep our members happy. We were fine with our insurance company now that it was not double digits, and so we have continued to stay. But we have asked for a PEEP bid again, and we'll do it again. That's competition. It's keeping checks and balances. That's what we're doing here today. Checks and balances. It's good. Competition is good. I would encourage that we support this bill for the school teachers, because guess what? When the mental health of mom and dad, when everybody is on insurance and you know that you can go to the doctor and you have insurance, you feel better about being able to go to the doctor because you can afford it. You can afford to pay your bill. When teachers are in the classroom and they don't have to worry about strep throat or having to get it coded in the correct way or ear infection, when teachers are in the classroom teaching the kids and they're feeling good because they have insurance covered and they don't have to worry about paying out of their pocket the whole entire bill, they are better teachers in the classroom. It does affect teachers in the classroom when teachers have insurance that they can afford. Personally, I couldn't afford family insurance. We had to go out and get outside insurance for our 2 sons. They were at age 4, they were on outside insurance because I could not afford family insurance. It would have been half my salary or more. So I would encourage that we offer this competition because I think it's good. Competition's good. That's what we're about.
The member from Polk, Representative Keel.
Thank you, Madam Chair. Members, you know, I'm a little concerned with this bill with regard to my small schools. Having been part of school negotiations, we've looked for competitive bids. In my experience, it didn't always work very well. And last year when we talked about making this mandatory, I had schools contact me, and I'm wondering, Madam Chair, if Majority Leader Murphy would fill me in on this. I'm wondering if we've had the conversation about the smaller schools. Schools are not cookie cutters. There's so many different ones, and last year I heard from them that they may, if they were to look for this, their insurance would probably go up to 200%. And so I'm wondering if we've talked to smaller schools as well as the larger schools.
Representative Murphy will yield. Representative Murphy.
Thank you, Madam Speaker, and Representative Keel. I certainly have. You know, and I at the beginning, when I was talking about the work that we had done to get to this point, I've talked with all sorts of people about this proposal, and small schools and large schools and schools that are self-insured and schools that are fully insured. And, you know, I hope that you are not thinking about the bill that Representative Ward carried that's in Ways and Means. That's not what we're talking about here. We're asking that school districts seek 3, they don't even have to get them, but seek 3 proposals on their coverage. They're going to seek proposals, I hope, right? I sure hope they're going out and seeking proposals. We just want them to seek 3, 1 being PEEP, so that they get a good cost comparison and an opportunity to choose from and negotiate from a sealed proposal process where those offering to cover those lives are submitting their very best work, so that the school districts have the option of choosing the best value for coverage for their employees, for that school district, and by eventually for the property taxpayers.
Representative Keel.
Thank you, Madam Chair. Well, Majority Leader Murphy, my schools do that. I've had all kinds of conversations. They can already do that, so I have some concerns about where this might go in the future. And I want to remind members that once again, we don't have cookie cutter schools. We have some real variety out there. We need to make sure that we have all possible availabilities for that. And I also want to, I heard something somewhere in the conversation that we've been having about the balance of being able to purchase insurance, and also the fact that deductibles were going higher and insurance was costing more. I want to remind members that that's a reality in the business world. I'm a small business owner. The prices went up for insurance. Pretty soon we said, well, gosh, we're going to have to do something, so we changed the deductible, and we changed the deductible again when it raised again. And so businesses have to deal with this all of the time, and this is hopefully, I don't expect it to be, but with all of the different insurance proposals, that people will be able to have less expensive insurance. But I'm not being told that by my insurance agents at home, and you know, I've heard from a few people that have gone from MinCare to MinSure and are very, very unhappy, and they were forced to do that. So I'm really concerned that we don't do the same thing with PEEP. Thank you.
The member from Roseau, Representative Fabian.
Thank you, Madam Speaker. Majority Leader Murphy, I appreciate what you're trying to do here. I think everybody's concerned about rising health care costs and so forth. I had a group of superintendents from northwest Minnesota in my office last week, and their question to me with regards to PEEP is, why don't they trust us? Why don't they trust us to do the best job that we possibly can for our valuable employees? And I'm not going to excuse me, I'm not going to ask you to answer that question, Representative Murphy, but that's what I hear. And a lot of the superintendents and board members take it personally almost that somehow we're suggesting that they don't care about their employees, that they're not going out and getting the best possible prices on their health insurance that they can. And I hear them and I understand that. So I do have a couple of concerns also additionally about the bill. You know, in the 35 years that I spent teaching in Roseville, there were the three most valuable groups of employees for me to make good relationships with were the secretaries, the custodians, and the cooks. Okay? Because they could either make your day pretty nice or they could make it more difficult for you. And I'm somewhat concerned, Majority Leader Murphy, about the fact that we seem to be excluding them in this process. So, Madam Chair, if Representative Murphy would yield to a couple of questions, I would appreciate that. And if you could address why we seem to be excluding the cooks, the bus drivers, the custodians, and from this process.
She will yield. Representative Murphy.
Thank you, Madam Speaker and Representative Fabian. We did amend the bill to make sure that there was an opportunity for consultation, and so I think that does address that. Again, the school district is going to make the decision about the coverage for the employees, including the educators. While I understand you're asking me a question about exclusion, they're not being excluded.
Representative Fabian.
Thank you, Madam Speaker. Well, thank you for the answer to that question. In the bill, if I remember correctly or look at it, there's $294,000 appropriated to MMB. Can you explain to me what the $294,000 to MMB is for?
Representative Murphy.
Thank you, Madam Speaker and Representative Fabian. That fiscal note that came back to support this proposal is $294,000 to MMB. It's a one-time appropriation. It is for the additional costs that people incur as they begin this process. So as they are doing bids for the multiple districts, there will be a small appropriation to cover those costs just for this 1 year.
Representative Fabian.
Thank you, Madam Speaker. Well, if there are increased costs for 1 year, how are we going to continue to cover those costs in the future? If Majority Leader Murphy would yield to that question, please.
She will yield. Representative Murphy.
Thank you, Madam Speaker and Representative Fabian. We will work with MMB to evaluate the progress that we're making to understand if there are additional costs that need to be covered in the future.
Representative Fabian.
Thank you, Madam Speaker. Well, I guess I'm somewhat concerned about that. If there's administrative costs in the process for PEEP, it would seem to me that there's also increased costs or administrative costs for private insurers, and we seem to be carving out some sort of a niche here for the PEEP process, and we're not doing some sort of a reciprocal deal for the private insurers. I've been contacted by a couple of the employee groups in my district who've asked me to not support this bill because they have looked into PEEP and they don't think that it works. They've actually gotten the bids and they decided not to use PEEP. So my broad question, Representative Murphy, Madam Speaker, if she would yield to this question, is why are we mandating that PEEP must be involved in the bidding process? Why can't we just allow bids to come in and take the best bids that there are?
Representative Murphy will yield. Representative Murphy.
Thank you, Madam Speaker and Representative Fabian. You know, when we introduced the bill, we required PEEP to respond to a bid. And the others, the co-ops and the fully insureds, the health plans, said they would prefer to be included in that same way. So I think that the idea here to get proposals sealed, to inject some competition, to get the best value is a good idea, and PEEP can be part of that. But in the end, once those bids are opened and there's a subsequent negotiation, it's up to the school district to choose which coverage is best for the school district, the employees, and ultimately for the property taxpayers.
Representative Fabian.
Well, thank you, Madam Speaker, and thank you for the answer. Again, Majority Leader Murphy, I appreciate what you're trying to do here, but I think that this is kind of wrong-headed. I'm concerned that what we're going to wind up doing here inadvertently is creating a situation that really isn't the best for a lot of our employees. And I go back to my opening comments about local administrators working along with their staff, all staff members, and their school boards to get the very best deal that they possibly can. And, you know, I have great faith in them being able to do the negotiating and make sure that they do get the best bids that they can. And I just, you know, I'm philosophically opposed to doing this carve-out for PEEP. So thank you very much, Madam Speaker.
Representative Woodard.
Well, thank you, Madam Chair. And, you know, this is the unsession. And the education unsession bill was tucked away in a 175-page education finance bill. And we've been told that when it comes to the unsession that everything would have to be non-controversial. We didn't really want to actually eliminate any mandates. We just wanted to clean things up. Basically, with all due respect to our advisors, a reviser's bill. And we all talk about mandates. And we all hear from our school boards, and we hear from the superintendents and the principals and everybody in the education establishment, please stop the mandates. As Representative Fabian said, you'll hear it from every one of your superintendents and school boards, please let us do our job. Members, we know that school boards today can use PEEP. They can get a PEEP bid. There is no reason for us to pile on to the mandates. Mandate after mandate after mandate. And you know, I find it interesting that we have some school districts in our state where even though we spend double-digit on each per pupil spending, that we graduate half of those kids in some of our school districts. In some school districts in this state, in the state in which we're proud of our education system, half of the kids do not graduate from high school. We have the nation's worst achievement gap between kids of color and their white counterparts. It's not open for debate. That's what we know. And yet, over the last few hours, we've debated whether or not we should add another mandate on our schools to mandate that they use PEEP, to mandate that they get another bidder. In fact, in the education finance bill, we had almost $300,000 to help PEEP do that. I didn't see any bills this year to help the health plans accomplish the mandates they're under. The fact is that under the Not So Affordable Care Act, that the health plans are required to do this as well. They're required to respond to these proposals. And members, I feel like we're rearranging the chairs on the deck of the Titanic. I know that many people in the education establishment hate it when Republicans stand up and point out some of the issues we have in the education system, because it's upsetting the apple cart. Because we want to talk about the kids and whether or not the kids are being successful. Instead, this entire session and last session as well, we talked about money and we talked about the bureaucracy. And we continue that trend today with this bill. So members, you can vote however you'd like on this bill. And obviously, that's the same with every bill. I will bet you there are Republican members who vote for this bill. And I'll bet you that there's some Democrat members who are right now having a little bit of heartburn over this bill because their superintendents and their school boards and their school districts are telling them, let us do our job. So my guess is there'll be bipartisan opposition and there'll be bipartisan support for this bill. The point is, we are wasting our time talking about it. Our education system is in a crisis in this state, and I'm sorry that you have to hear it. And I was just reading through the Education Minnesota legislative priorities. And members, their legislative priorities are things like meeting the basic needs of our children. They want to eliminate poverty before we can address the needs of our education system. That's their number one priority in 2014. PEEP is in there as well, but that's the number one priority. And members, I can tell you, we've been working on poverty for a long time as a government, and we all know that the only way we can address poverty is through education and through economic equality and economic freedoms. And members, poverty doesn't cause bad education. Bad education causes poverty. And it's always been that way. And I was accused in committee one day of having 18th century ideals about our education system. And I'll tell you, for the part at least that we were talking about, I'll take some pride in that. Because we know that the number one factor for success of students in the public school system, in the charter school system, and in the private school system is the teacher that stands in front of them. Yet this legislature fails to act on issues of flexibility and staffing. We still have an environment today in our education system in this state, in this day and age, where it matters more when you signed a contract with the state, with your school district, than how good of a teacher you are, how passionate you are about your job, or how good you are at teaching. It matters more when you signed a contract than what kind of teacher you are. That should make all of us pause. And I know Education Minnesota, and quite frankly the rest of the education establishment in this state, don't want us talking about that. Because they'd rather have us spending the last 4 hours talking about PEEP, and talking about bureaucracy, and talking about the weeds. Because members, the school districts and the collective bargaining units and our school boards have this figured out already. Yet we are wasting our time talking about this bill, when we should be talking about the issues that really do affect our school districts. And we can, all we want, we can put into law, which is what we did last year, that we're going to have a 100% graduation rate. So everybody who voted for the education finance bill last year voted for a 100% graduation rate. Well, whoop-de-doo. Because the state can't mandate that. It requires teachers teaching. It requires the kinds of reform and the kind of education freedom and education choice that creates the competition, that creates the kind of passion around teaching that teachers that you probably had and that I certainly had. And instead, we're going to treat our teachers as though they're just a cog in a wheel, that all of them teach equally, that none of them are superstars, they all do the same thing, and every year we're just going to give them a little bit more money. Members, we should have a system where superstar teachers are recruited, where because of pay, because of benefits, because of passion surrounding the culture of the school that they go to, they should be recruited. But we can't do that today because our system is handcuffed. And until we address that, we're going to continue to talk about it, and we're not going to see anything happen. We're going to continue to have some of the worst achievement gaps. We're going to continue to see some of the worst graduation rates for our most vulnerable students. Students who are taught, because of the culture that they're living in today, that they'll be nobody, that they'll go nowhere. And members, I'll remind you, if you were here in 2011 when we had the voucher bill, when we had the opportunity scholarship bill, and we had kids from schools around the state come and testify, and they talked about a system that failed them. Because they said that you are special needs, and that we're going to pigeonhole you into this category. And, by the way, we'll receive a little bit more funding from the state because of it. And yet these kids ended up in other schools where the culture taught them there are no excuses. And we will make sure that we do wraparound services in this school to make sure that we're going to hold your hand through the process and you're going to graduate and you're going to go on to college. And members, when we talk about, and this is not popular to talk about in the Republican caucus, and I assume it's not popular to talk about in the DFL caucus, but when we say that not every kid should go to college, let me ask you if your kids shouldn't go to college. How many of you told your kids, don't worry about college? College gives you the opportunity to be a welder later in life, to be a brewmaster later in life, to do all kinds of things. But when you're 16 years old, you don't know squat about what you want to do. And if we're not giving them the opportunity to go to college for every single student in this state, if we are writing them off early in their careers, in their education careers, then no wonder we have a problem in this state. We cannot continue to do that and to treat them as though not all kids can go to college. And members, I'll give you a quick story of what happened in 2011 when, at the time, Chair Garofalo of the Education Finance Committee took us on a tour of a few schools. And I won't name the schools, but we went into one school, and the first thing they did was squirrel us away into the library. And what the teachers and the administration wanted to talk to us about was how difficult things were in the school. And yeah, they were. They're dealing with kids who go home to a pretty crappy life. That the highlight of their day is going to school. And they talked about how if we just had more money, if we just had this, that, or the other, we could really do something here. But we can't because we don't have it. Literally within a mile away, we go to another school, and that culture was a 180-degree difference. You walked into that school, the first thing the teachers wanted to do was take you into the classroom. And each one of those classrooms had a banner in front of it with a college name. And each one of those classes were assigned that college name. And so as they went up through the grades, the expectation was, no matter who you were, we're going to make sure we get you to college. We're going to hold your hand, no excuses. We know you've got a crappy life when you go home. But when you're here, you're going to be taught that you have an opportunity. And members, that difference in culture is what makes the difference with kids. It's what will address the achievement gap. Not mandating it. Not saying if we sprinkle pixie dust, it's going to happen. It's actually providing that kind of culture and that kind of freedom. So members, we should all be dreaming of an education world where we trust our school districts, where we eliminate the mandates and then we hold them accountable at the end. And instead of saying, here's what you're going to do from 8 a.m. to 5 p.m. or 8 a.m. to 4 p.m., we're going to say, here's the resources and the tools. Now go teach. Go inspire. Go do what made you become a teacher in the first place. And then at the end of the year or the end of a couple of years, we look at the results and see whether it's working or not. And if it's not, then we have to change them. And the school district needs to change. But we cannot mandate that from St. Paul. We cannot be the state school board. And until we fix that issue, we're just going to be talking for hours on end about the weeds and about the bureaucracy and about spending $300,000 so a state plan can compete against private sector plans. So members, again, vote your conscience here. I think there's going to be lots of bipartisan support and bipartisan opposition. But remember that this will do nothing when it comes to the achievement gap that we all are trying to address. It will do nothing for the graduation rates. It will do nothing to inspire Minnesota kids to do better and to do better than their parents. Thank you, Madam Speaker.
The member from Carver, Representative Hoppe.
Thank you, Madam Speaker. Well, members, Representative Woodard did a nice job and took some of the things that I was going to say about PEEP and competition and the ability for districts to do this now. And Representative Sawatsky did a nice job about talking about the Wilmer School District and what they've done. And members, there's nothing under current law that prohibits districts from doing that. In fact, school boards that are doing their job for their employees and their taxpayers should already be doing this with co-ops, with PEEP, with other insurance entities, and shame on them if they're not. And my hope would be that all of them are doing it, and if they're not, they should be. We don't need to pass this bill. We don't need to mandate that they're doing it. Now, Madam Majority Leader and others tonight have talked about wanting to get the best possible price and get a better value and have competition. We've heard a lot about that word, about competition. And I think we all agree competition is a good thing. The more competition you have, the better price you're going to get, whether you're buying a car or negotiating for school, health insurance, or whatever it would be. So, Mr. Speaker, would the Majority Leader yield to a question?
She will. Representative Hoppe.
Thank you, Mr. Speaker, and Madam Majority Leader. We've been talking, and you've been talking about competition and the property taxpayers and the best possible price and more competition and a better value. And that might be the case for some school districts. But my question, Madam Majority Leader, is this. What about those self-funded districts? Why can't they be included? Why can't they be carved out of your bill? Because if we want competition, they've already got it. They're already doing what this bill is mandating that everybody does, and what they're telling us, at least what they're telling me, is that this is going to result in higher prices for them. So if they're already doing, the question is, if they're already doing this, Madam Majority Leader, why can't we carve them out in this bill?
Representative Murphy.
Thank you, Mr. Speaker and Representative Hoppe, because competition is good for them too. And we worked with them. I met with multiple self-insured school districts. Everyone that has reached out to me, I have talked with them. And we adjusted the proposal so that we would ask them to get an RFP on their TPA services and one PEEP bid. And all they have to do to get that PEEP bid is send in their claims data. So we have made this very simple for the self-insured districts. And let me say one more time, it is the school district that retains the authority to make the decision in the end. So if they like what they're doing and it's working for them, they can. But competition's good for them. I don't know why we would let that, why would we say we're going to do it for everybody else but not for you? It's a good thing. It's going to drive better value.
Representative Hoppe.
Thank you, Madam Majority Leader and Mr. Speaker. Well, Representative Murphy, I think that the answer why we wouldn't do it for them, we're not doing it for them, we're doing it to them. And I think if they don't want to have us do it, we should skip it. If the self-insured districts are telling us that this is going to result in higher costs, and they're already out there getting competition, which this is all about, then we should let them opt out of this. We should have something in this bill that says that the self-insureds don't have to do this. Because, folks, I will tell you, I know as Representative Woodard said, we are going to have members on both sides of the aisle vote for this bill, and we're going to have people vote against it. But I will tell you what's going to happen. It might not be 2 years from now. It might not be 5 years from now. But ultimately what this is going to do, if you represent a self-insured school district, this is going to wind up costing you more money for your health insurance. And in all likelihood, you're not going to have an apples-to-apples comparison. You're probably going to be looking at higher deductibles. You're going to be looking at different kinds of services in all likelihood. And folks, 5 years from now, these 23% of school employees, of educators, they're going to be looking at paying more for health insurance. And in all likelihood, it's going to be sooner than that. Please vote no on this bill.
Representative Sudzinski.
Thank you, Mr. Speaker. Would the Majority Leader please yield to a question?
She will yield. Representative Sudzinski.
Thank you. You know, we heard Representative Detmer earlier speak about the self-insured, and you know, I have a general question. I asked the Majority Leader when she came into Commerce Committee, knowing the self-insured market and how that situation works. So I laid out in committee kind of a scenario. So a school district, which is self-insured, does go to a PEEP program. They have large amounts of reserves dollars. They have large money set aside. Because of the way the bill's set up, we have a 2-year spectrum and then the potential to go up higher. What's going to happen to those reserve funds if they, per school district?
Representative Murphy.
Thank you, Mr. Speaker and Representative Swazinski. The reserves are in the control of the school district.
Representative Sudzinski.
Mr. Speaker, thank you. Would the Majority Leader yield to another question?
She will yield. Representative Sudzinski.
Thank you. So currently, I believe the self-insureds will also be paying into the MNsure administrative fees. Am I correct?
Representative Murphy will yield. Representative Murphy.
Thank you, Mr. Speaker and Representative. We're talking about my bill tonight, and I know you want to talk about MNsure, but we're talking about my bill tonight.
Representative Sudzinski.
Thank you, Mr. Speaker. But it's my understanding that most of the competing insurance programs, we talk about we want to have fair competition. We talk about entering the pool. We want 3 insurance pools, whether it be one of the insurance companies or potentially PEEP to jump into the pool and essentially compete. We want the strongest, the fittest. And it's my understanding from Representative O'Driscoll's commentary earlier tonight that PEEP will not be playing by the same rules. Essentially, we can all jump in the pool, but some of the insurance programs will have a life preserver, and other insurance companies will have a millstone, essentially. And if we're starting, we'd all like to swim against Michael Phelps with his hands tied behind our back. And I think that's one of the sad things that we're seeing here, is that we're trying to give advantages to some groups and allowing some groups to opt out on some of the, to allow them to be less competitive for some of our own benefits. And I think that's unfortunate as we move forward. I was maybe leaning a little bit towards this bill early on tonight, but as the conversation's been having on the floor, I seem to have more and more questions as the night goes on, and I appreciate it. Thank you.
Representative Barrett.
Thank you, Mr. Speaker and members. So there was a question asked earlier, I think, by Representative Sawatsky, why would you be against the bill? Well, I think one of the reasons you'd be against the bill is because our school districts are against the bill, and they want the best for the school district. And so they're looking at the bill, they're looking at the mandate, and they're saying this mandate does not result in what we need it to result to in order to teach our kids in the state of Minnesota. I talked earlier about the amendment that failed, and the amendment that failed actually would put more money into the school district so that they can hire a teacher. And unfortunately, it's less likely. Why I would be against the bill is because passing the bill makes it less likely that a school district would hire a teacher, because of the fact the refunds paid would not go to the school district proportionally. They would go to the bargaining unit. And so another reason I'd be against the bill is it's kind of full of contradictions. And one contradiction I'd like to explore just for a minute is something I wanted to ask an Education Policy Committee when the bill was introduced, but it got introduced late in the day, and I wasn't able to ask the question appropriately. So Representative Murphy, Majority Leader Murphy, would yield for a question.
She will yield. Representative Barrett.
Representative Murphy, I'd like to ask a question regarding the $294,000. I know Representative Fabian already asked that question, but when it was in committee, actually, it was $1 million. It's $1 million that would have went to one of the 3 health care plans in order for the health care plan to negotiate or create a presentation to the school district. That $1 million has since been reduced to $294,000. Representative Murphy, could you explain how that happened? I'm not in any of the committees to which the bill got referred. Why, if $1 million was needed from one of the 3 health care plans a month ago, why is it down to $294,000 today?
Representative Murphy.
Thank you, Mr. Speaker and Representative Barrett. We got a fiscal note from MMB that said the cost of the bill would be $294,000 and adjusted the proposal as a result.
Representative Barrett.
Thank you, Representative Murphy. I didn't quite catch the first part of that answer because I have trouble hearing and I use the headphones here. But I think you just said, well, the price got better. $294,000 was the final amount that got into the bill. My question, though, is the bill costs taxpayers $294,000, and it gives a mandate to school districts in our state to have 3 bids for health care. The way I look at it, these people that are leading our school districts, the superintendent, the business managers, they're highly paid individuals that make very complex decisions on a daily basis. Wanting 3 bids for a health care plan is one of the least, one of the decisions that is the most obvious for them to make in a given day. So for them, it's a mandate. It's another thing they have to think of in order to do their job, and they're actually negotiating against themselves in that one of the 3 health plans that they would be talking with and getting a health care plan rate from has a significant advantage over the other 2. And so when they talk to me about it, and they wondered what's going on, because they don't think this is good for their district. Now, I had the advantage for many years before getting elected here of being on the Chisago Lakes Community Finance team. It was a community finance team put together by the superintendent at the time and the business manager of Chisago Lakes, and they invited a couple community members, probably 4 or 5, to meet with them on a regular basis to talk about the finances of the school district. They had a couple school board members on the team, and I learned a lot. One of the things I learned by being on that team is that the Chisago Lakes School District business manager is top-notch. She makes decisions based on the best thing for their district, starting with the kids, including the teachers, including the parents, and the staff. She looks at numbers, understands what's good for her district, recommends solid, financially thoughtful decisions to her school board and her superintendent. And she doesn't need a mandate to do what's right. She doesn't need a mandate to do what she knows is right in her heart. And then when you add to it the amendment that failed tonight, the fact that she in her good heart doesn't get the advantage of getting a refund back, I just can't support the bill. So with that, members, I'd encourage a no vote on the bill.
Representative Quam.
Mr. Speaker, I had 3 quick clarifications from the chief author, if she would yield.
She will. Representative Quam.
Representative Murphy, Madam Leader, how are refund histories factored in to give a balanced understanding of the bids? Because if you're continually or have a history of getting money back, that should be factored in. 2, how are the additional costs of taxpayers for the overhead of PEEP figured in or factored into the bill, bid that you have, because that's a higher amount to the taxpayer? And then 3, if we look at the combination of teacher retirement plans that has been going on over the years, it appears as if every year I've been here, we've been adding tens of millions of dollars to try and make that a balance, so to speak. And what assurance do we have that PEEP won't cause, as it grows, growing pains like that? And if you could answer those, I'll sit down and that's it.
Representative Murphy.
Thank you, Mr. Speaker and Representative Quam. 3 quick questions. I'll have at least 2 answers. I might need you to repeat the last one. So with regard to refund history, I think that could be discussed, among the participants at the local level. But we're talking about going forward and not going backward. So I would imagine that would be an easy discussion to have. If there have been refunds in the past, it just depends on if there have been refunds in the past or not. Local control, local discussion. With regard to the taxpayers, my belief is that with the competitive bidding process, the costs for health coverage for school districts, for their employees, and for the property taxpayers are going to go down. And that's a good thing. And then your third question. Can you give it to me one more time?
Representative Quam.
Thank you, Mr. Speaker. And I was having some trouble hearing what was said. And I think that you probably covered everything but the concern, which is hard to quantify, but as PEEP grows from being a fairly small to a larger plan, what's to ensure that we aren't going to have the growing pains that we had from the teacher retirement plans? As we combined them together, it appears that we've had to add some additional funds. So that was, I believe, the last question.
Representative Murphy.
Thanks, Mr. Speaker and Representative Quam. There's no guarantee that PEEP is going to grow under this proposal. Only if the school district, who retains the authority to make the choice, chooses PEEP, and lots of school districts will do that. If they do that, if lots of school districts do that, PEEP could grow. But they are a public employee, self-insured pool, and their costs are borne by those who are enrolled over time.
Representative Myra.
Thank you, Mr. Speaker.
I recently asked the superintendents in my House district to share with me the good, the bad, or otherwise. And they shared two big concerns. This bill was one of them. I was told that they're self-insured, and that currently what they're doing is working really, really well. This year they had no premium increases. The proposal, they said, will increase their costs and reduce their options. And so, Mr. Speaker and members, I encourage you to vote no on this bill, as I will be.
Okay, Representative Breinert.
Thank you, Mr. Speaker. Members, well, I, like many others here, have heard this bill 3 times in committee, and I'm not going to go through the entire process, but I'll say simply that I began in the first committee in which Representative Murphy presented, sharing my concerns and saying that I wouldn't be able to vote for the bill the next time I heard it unless she addressed a series of concerns. And just by way of a background, I have opposed the mandatory pool my entire 7 years, now 8 years, in the legislature. So it's been a constant concern of mine for a number of reasons. And just to sketch that out briefly, I'll say my school district, among many others, did not want to be lumped in a mandatory pool with districts who had bargained away their benefits through cash in lieu and be competing with districts who had done a much better job of managing their insurance priorities through, whether they did it through a group process with service cooperatives or self-insured or otherwise. So I had a list of concerns about this bill. And as the bill progressed through committee, as I heard it a second and third time, Representative Murphy continued to address the concerns of many of the outstate districts. More fairness between service cooperatives and PEEP. The concerns around the appropriation is still there, but it's been dramatically reduced and it's one time to be re-examined. I still have concerns about its existence and how it might unfairly advantage PEEP. But I do think we're called upon to do some due diligence and oversight as this moves forward. But this is a genuine compromise. Districts maintain control here, members. The bidding process, the sealed bidding process, is in the hands of the districts. They still make their choices regardless of the low bid, but it creates a competitive environment for a more careful examination of insurance costs and benefits. So I encourage members to support this and then carefully watch as it proceeds. And there's a number of pieces that we can revisit. But also remember that Representative Murphy has agreed to carry some of the concerns that have been raised on the floor tonight forward as this goes into conference committee.
Representative Krisha.
Thank you, Mr. Speaker and members. And I'll be brief. I know we've had a lot of conversation about this. I don't believe, as we look at this, that anybody's trying to hoodwink anybody here. I think that this is all on the up and up. We've all heard from both sides. It's not like there's this huge smelly underbelly out here that we're all trying to avoid. It's just that both sides are really listening to their constituents and trying to work through this. We get it. Insurance can be very complex. It's all in the game, right? Yo? And so as I look at this, and I look back at all the school districts that have contacted me, I've heard from both sides. I've heard from the teachers. I've heard from the administrators. And both sides are working very hard to get this done. And when I talk to the teachers, and I've talked to teachers from the area, from former, now Senator Tori Westrom, but former Representative Westrom's area, and my area as well, and I've encouraged them, go to your school administrators. Ask them about the PEEP bid. And in all cases, when they went back and they talked about it, what they saw was that the administrators were simply trying to do the best they could and looking all across the spectrum. And what we find is that a new teacher that comes in that's unmarried with no kids will be at much different rates than where they try to shoot for the average, which is a married couple with 2 kids. And you slide up and down on that scale as you go. The administrators know that. And I believe as the author of the bill has tried very hard and worked in committee to do all of this, we all understand that insurance costs are going to go up, and we all understand that this is part of it. So I believe that we keep the independent name in the school district's name, and I believe that we continue to work with and trust our school administrators. I believe if this bill goes through, we'll be back here trying to fix it again, and we'll be back trying to do more and more. But the fact of the matter is, we really can't create a competitive environment. We have to let our people do the best they can, and we have to support them in the process. So members, I know there's been a lot of discussion on this. I know there's been a lot of work put into it. I urge a red vote.
Any further discussion on the bill? Representative Murphy.
Thank you, Mr. Speaker and members. You know, at the very beginning, I thought maybe I'd said something wrong because you were all so quiet, but now I recognize our more familiar arguments. I just want to share this. I'm not going to say which school district this is from, but I've got a handout here from March 28th that talks about a school district that's facing a 27.4% increase in their health care costs. 27.4% for the employees. Good teachers are leaving the classroom because their health care costs are so high, and their health coverage is less than adequate. And I think if we can find a better way to provide affordable coverage, good teachers will stay in the classroom. And when I listen to Representative Woodard talk, it sure seems that's something that we agree on, that good teachers in the classroom are going to achieve better education for our kids, and we agree on that. So at least, you know, I think there's a little kumbaya there. I might get your vote yet. And I think if we can reduce costs for school districts, more money can go into the classroom, and we agree on that as well. As Representative Saitow used to say, it's a good bill. Vote for it. Thank you.
Seeing no further discussion, the clerk will take the roll on the bill. Clerk will close the roll. There being 76 ayes and 57 nays, the bill is passed as amended and its title agreed to. The next bill on the calendar for the day is Senate File 1509. The clerk will report the bill.
The first engrossment, an act relating to state government.
Representative Mariani, to your bill.
Mr. Speaker and members, this bill mirrors an action that we took on this body last week on the anniversary of Cesar Chavez's birthday. Members will recall that what we did was simply read a House resolution as a acknowledgement of that date. Senate File 1509 is a bill that designates March 31st as Cesar Chavez Day in the state of Minnesota. Members, I don't think I need to be long. I did a good description of this great American for you last week. An American farm worker, labor leader, civil rights activist, who along with Dolores Huerta founded the National Farm Workers Association. He's clearly an icon in U.S. Latino communities, the Mexican American communities, which of course form a major part of our broader Minnesota community. Is actually one of the longest communities, racial, ethnic, cultural communities in our state, well over 100 years, have featured prominently in the well-being of many of our economic activities and social and civic activities, but particularly in much of our success as an agricultural state. Members, you probably would associate Cesar Chavez with the Si se puede slogan. I would submit to you that that saying is a solid U.S. American saying. It's really about the can-do spirit and attitude that we all possess here. This bill would designate March 31st as Cesar Chavez Day. It would be similar to what we've done with a few other dates in state statute, including recognizing that great Minnesotan and American, Dr. Norman Borlaug. We also have an Ethnic American Day, etc. And this would not create a holiday, so this would not create any kind of mandate or imposition on either government or private sector. It's really more about lifting up for all time within this state in recognition of the rich diversity of Latino people that we have in Minnesota, and also in recognition of the social justice, the nonviolent activism of this incredible American. And so, members, I would urge your support of this bill.
There's an amendment at the desk. The clerk will report the amendment.
Hansen moving to amend Senate File 1509. The first engrossment as follows. The amendment is coded 201.
The member from Dakota, Representative Hansen, to your amendment.
Thank you, Madam Speaker. And the RA 14201 amendment is to add a provision that has passed this body already. A year ago, the agricultural employment section that's here was passed. It was part of the governor's budget. It was heard, I believe, in Representative Johnson's committee, and so I'm adding that to the Cesar Chavez Day.
Representative Poppe.
Madam Speaker, I rise for a point of order under House Rules 3.21. Motions and propositions must be germane. And I'd like to offer some advice.
Please state your advice.
Senate File 1509, which is the bill that we're addressing as the Cesar Chavez Day, is under Chapter 10, which commemorates a day of remembrance or observance, and the amendment is under Chapter 177. So it is the Fair Labor Standards Act. This amendment would greatly expand the scope of the bill. It's just simply not germane and should be ruled out of order, please.
Advice. The member from Hennepin, Representative Winkler.
Madam Speaker, I rise for advice, and I would urge you to find the point of order not well taken. If you actually look at the language of Rule 3.21, it says that simply that the amendment has to be germane, and it doesn't define it. If you go to Mason's manual and look at the definition of germaneness under Section 402, it says that the amendment to be germane needs to be relevant, appropriate, and logical sequence to the original subject matter. Madam Speaker, we have before us a bill to commemorate Cesar Chavez. We have an amendment to the bill that actually makes the work of Cesar Chavez relevant in Minnesota after we unfortunately were not able to pass that as part of a broader bill this session. Agriculture workers in Minnesota deserve the same 40-hour work week that every other worker in Minnesota should enjoy, and just because the federal government exempts them doesn't mean that the work of the great Cesar Chavez and ag workers organizing around the nation should not be honored in Minnesota in this way. And finally, Section 10 of statute actually does contain provisions related to employment. So if you add up the great latitude that you have as Speaker Pro Tem on a germaneness ruling with the very loose definition provided in Mason's and in House rules, and the fact that this is a highly logical and appropriate follow-on to the bill before us, I would urge you to find the point of order not well taken.
Representative Woodard.
Thank you, and advice, Madam Speaker.
State your advice.
Actually, that was very eloquent, Representative Winkler, and this is a classic example of why it's important to follow the rules, because I disagree with Representative Hansen's amendment. I think it's a bad idea. However, I think the definition we just heard of germaneness is spot on. And I would expect that we'll hear that again later when we discuss germaneness. So I would certainly agree with Representative Winkler on this. Thank you, Madam Speaker.
The member from Dakota, Representative Hansen. Advice.
Advice, Madam Speaker.
State your advice.
Thank you, Madam Speaker and members of the body. You know, every day when we sign in, we hear the Pledge of Allegiance, and the good folks back here always say justice very loudly. And if you look at the background of Cesar Chavez, he wasn't that popular during his lifetime. He actually started the great boycotts in 1966, and it wasn't popular. And the agricultural industry opposed him. But back in 1966, that was kind of the first time that social justice was brought into our food supply. And when you look at the history with Cesar Chavez, the agricultural worker, it says agricultural worker, agricultural workers, agricultural workers. It talks about strikes, it talks about boycotts, and it talks about his record as a labor leader. My amendment relates to Cesar Chavez Day. It has the 40-hour work week, the justice of a 40-hour work week, going into effect on March 31st, Cesar Chavez's birthday. So I think I would ask the Speaker to consider that. When you're looking at the day, the bill, SF 1509, designates March 31st as Cesar Chavez Day. The bill talks about the justice and the effort working that Cesar Chavez did. We often say words when we recite the pledge. We can implement legislative days, and we can institute policies to make those happen. And that's what my amendment does, and I would hope the advice would consider it well taken.
Representative Davids, advice.
Well, thank you, Madam Speaker, and I would like to rise for some advice here. And I agree with Chair Poppy and her comments. And, you know, I've spent many hours right where you are, Madam Speaker. And just the point of greatly expanding the scope of the bill. This is a great expansion. This really, really hurts our farm families out in rural Minnesota. Because where I come from in Fillmore County, you're talking about a 40-hour work week. Where I come from, we call that Wednesday. And so, Madam Speaker, I hope that you will rule in the favor of the chair of the Ag Committee.
Having listened to the advice of Representative Poppy, Winkler, Woodard, Hansen, and Davids, I find the point of order is well taken.
Madam Speaker.
Representative Sanders.
Thank you, Madam Speaker. I'd like to appeal the ruling of the chair and ask for roll call.
Representative Sanders appeals the ruling of the chair and requests a roll call. Seeing 10 hands, there will be a roll call. The question before the body is, shall the decision of the Speaker stand as the judgment of the House? A yes or a green vote supports the ruling of the Speaker. A no or a red vote goes against the ruling of the Speaker. Representative Sanders. The clerk will take the roll. The clerk will close the roll. There being 125 ayes and 8 nays, it is the judgment of the House that the decision of the Speaker shall stand. The two other amendments were amendments to the amendment, and since the underlying amendment is out of order, there are no further amendments to the bill, and the clerk will give the bill its third reading.
Third reading, Senate File 1509.
Third reading. Discussion. Representative Holberg.
Thank you, Madam Speaker. Will Representative Mariani yield?
He will yield. Representative Holberg.
Thank you, Madam Speaker. Representative Mariani, this is a little unusual, naming a day after somebody, and I'm a little concerned about setting a trend here, and I'm wondering, can you tell me, do we have any other dates named after individuals in the state of Minnesota?
Representative Mariani.
Madam Speaker and Representative Holberg and members, I don't have an exhaustive list here, but as I indicated at the beginning, we have Dr. Norman E. Borlaug World Food Prize Day. So it's similar legislation to this, and obviously refers to that great humanitarian Minnesotan, Dr. Borlaug, who, quite frankly, members, if you don't know, probably did more did more as one person to change the world. Opened up the possibility for humankind to be able to prosper into the 20th, throughout the 20th, and into the 21st century. And so, with Cesar Chavez, what we're proposing here is a recognition of someone who made huge contributions advancing our own humanity, did so from a very deep, humble, spiritual base, focus on social justice and lifting up out of, frankly, right out of darkness. Farm workers, you only have to read Steinbeck to understand the long history that we have in our nation of sticking farm workers in a place where they're not seen. And bad things happen when we place people in places where they're not seen. And yet, those farm workers, and be they white or black or Latino or Asians, without them, without their work, the United States would not have made it through the 20th century, would not, and quite frankly, would still be unable to make it through the 21st century. And so I think what you have before you, and I appreciate the question, I think what you have before you is an appropriate step on our part to not just recognize anyone, not just someone who hits home runs or, wrote a famous song that hit the pop charts or something like that, but someone who has made an incredible contribution that transcends history and time and makes us a better people. Just as Dr. Borlaug did that for our state and for the world, Cesar Chavez did that through his selfless efforts for this nation and for the world as well. But yes, Representative Holberg, there is precedent for doing this.
Representative Zellers? No. Any further discussion to the bill? Representative Erickson.
Thank you, Madam Speaker. Would Representative Mariani yield to a question?
He will yield. Representative Erickson.
Representative Mariani, I've done some reading on Cesar Chavez, and I want you to tell us if this is true or not. But he did not treat his volunteers as I think you're characterizing him. When they wouldn't follow his orders, I have read, he punished them. These were the farm workers who wouldn't go along with something that he was promoting. So would you please comment what you know about that? Because that's what my reading tells me. And I'm not sure I want to honor someone who perhaps had a character trait that doesn't epitomize what I see in our farm workers today and in our farm employers who honor very much these employees that they bring on to take care of their crops, to plant, to harvest. So would you comment on that, please?
Representative Mariani.
Madam Speaker, and Representative Erickson and members, yes, indeed, gladly. I suspect that Dr. Borlaug probably had bad days too. I suspect that all our great American heroes, men and women, have had their bad days, and I can tell you humbly, I'm certainly not a perfect human being. I have certainly committed many errors and mistakes in my life, and I think the powerful redemptive nature of being a human being is always a possibility of growing and learning and building off of that. All I can tell you is that there is a voluminous body of work that points to, captures in great detail the incredible work and sacrifice and therefore contributions that this remarkable American made on our behalf, build a powerful movement out of the people who lived in the shadows. And they did so, quite frankly, in the face of great violence, of great attempts to humiliate them, but never did they resort to violence as a response to that. Cesar Chavez was a deep disciple of nonviolent change and activism in the spirit of Dr. Martin Luther King, of Mahatma Gandhi, and so many others who have just made us better human beings. And so all I can tell you is what I know. And what I know is that this remarkable, humble man, who, by the way, members, to his dying days, lived an incredibly simple life, never amassing any kind of wealth, never living any kind of comfortable life. He was born a poor farm worker, and basically, at the end of his days, he lived out in a very simple existence, conducted himself that way. You never saw him wearing fancy clothes or driving fancy cars or eating fancy food. He was who he was, a true American hero who lived humbly and in servitude to the people. So, Representative Erickson, I think I just want to rest your mind that by casting a positive vote here, you would be honoring a great American who millions and millions of Americans have recognized and who have striven to honor as well. There are about a dozen other states that have this kind of designation in their states. There are a few states that have them as official holidays. We're not looking for that here. We think it's simply good enough for the state of Minnesota to pause and do a good reflection on lifting up this great man. Representative Erickson, you would be in good company with lots of good Americans who seek to honor this great servant of the people.
Any further discussion? Seeing none, the clerk will take the roll on the bill. The clerk will close the roll. There being 83 ayes and 45 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is House File 2276. The clerk will report the bill.
House File 2276. The first engrossment, an act relating to the Safe at Home program.
The member from Dakota, Representative Holberg.
Thank you, Madam Speaker and members, and I know it's late, and I'll try and be as brief as possible. This bill relates to the Safe at Home program. It's a good program that was implemented to keep the location of domestic abuse victims secret so their abusers could not find them or their other family members. Unfortunately, this program was put into place in 2007 in a conference committee, and the bill was never heard in either body. It was just thrown in as a last-minute idea. Well, ever since then, we've been chasing the data issues around this program, trying to keep, when we have disclosure of data, trying to keep the participants in this program safe. Currently, there are about 700 households representing over 1,600 people in this program. Last year, we tried to do a comprehensive Safe at Home data bill that would apply across the board to keep the location of these individuals unavailable, even to law enforcement. Well, what happened after that bill passed is an inadvertent consequence related to property registration, searching titles, filing deeds, etc., became problematic because this information, some of it which has always become public, was no longer public and causing problems. So over the interim, the Office of the Secretary of State, the Minnesota County Recorders Association, the Land Title Association, the Coalition for Battered Women, and individuals with the real property section of the Minnesota Bar worked on the solution that's before you today. It's not perfect, but it solves the majority of the concerns that were raised as a result of the bill that passed last year, and I would appreciate your support.
There are no amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File 2276.
Third reading. Discussion. Seeing no discussion, the clerk will take the roll on the bill. The clerk will close the roll. There being 133 ayes and 0 nays, the bill is passed and its title agreed to. Reports from the Committee on Rules and Administration.
Report from the Committee on Rules and Legislative Administration. Murphy E. for the Committee on Rules, pursuant to Rule 121 and 333, designates the following bills to place on the calendar for the day for Wednesday, April 9th, 2014. House File numbers 2536, 859, 2141, 2295, 2446, 2402, House File 2656, 3027, 2227, 2950, 2874, and 2313, and Senate File 1762.
Motions and resolutions. There are copies of the non-controversial motions on the House or at the House desk and online. If there is no objection, we will take action on those motions first. Hearing no objection, the motions prevail. Announcements. Representative Carlson.
Yes, members, this is directed to the members of the Ways and Means Committee. We'll meet earlier than we usually do. We'll be convening in room 200 at 8:30 a.m. and we'll adjourn by 9:45 or earlier because the session starts at 10 o'clock, and we do have 4 bills on the agenda, so I'd appreciate people arriving on time so we can get the bills dispensed with.
Representative Doubt.
Thank you, Madam Speaker. Would the Majority Leader yield for a question?
She will yield. Representative Doubt.
Thank you, Madam Speaker. And Madam Majority Leader, could you give us an outline for what tomorrow looks like, what time we're coming in, if we'll be caucusing, how long we'll be caucusing, what you anticipate the day to look like? Sorry, Madam
Sorry,
Speaker.
I thought you were done. Representative Murphy.
Thank you, Madam Speaker and Representative Dowd. We'll come in at 10, break to caucus, and come back and take up the bills that are calendared for tomorrow. We should talk together about how long you think you might need for caucus, and then we can plan from there.
Any further announcements? Representative Murphy.
Madam Speaker, I move that when the House adjourns today, it adjourns until 10 a.m. Tuesday, April 8th, 2014.
Representative Murphy moves that when the House adjourns today, it adjourn until 10 a.m. Tuesday, April 8th, 2014. All those in favor, please say aye. Aye. Those opposed, please say no. The motion prevails. Representative Murphy.
I move that the House do now adjourn.
Representative Murphy moves that the House do now adjourn. All those in favor, please say aye. Aye. Those opposed, please say no. The motion prevails. The House stands adjourned until 10 o'clock a.m. Tuesday, April 8th, 2014.